ಏನ್ ನೋಡ್ತಾ ಇದ್ದೀರಾ ಮೇಡಮ್? ಮ್ಯೂಟ್ ಮಾಡೋಣ ಅಂತ ನೋಡ್ತಾ ಇದ್ದೀನಿ. ಆಗ್ಬಿಟ್ಟಿತಾ ಪಿನ್
Court master, am I audible? Can court master can confirm, please? Am I audible? Can court master can confirm, please?
Sir, you're audible.
Thank you, sir. Thank you.
Lord, the court's mic is muted, my lords. Nothing is audible, my lords.
My lords, the court mic may be switched on. My lords, nothing is audible.
Brother, Dharwad matters are going on. After completion of Dharwad matter, court will take Bangalore list. Just wait for a while.
Dharwad bench, my list number, cause list number, item number 7, my lords.
ಹಲೋ ಇದು ಧಾರವಾಡ ಬೆಂಚ್ ಆದ್ಮೇಲೆ ತಗೊಳ್ತಾರೆ ಅದು.
ಸರ್ ಇವಾಗ ಧಾರವಾಡ ಬೆಂಚ್ ಮ್ಯಾಟರ್ ನಡೀತಿದೆ.
ಸರ್ ಧಾರವಾಡ ಬೆಂಚ್ ನಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 7 ಸರ್ ನಂದು.
ಸರ್ ಹಂಗಾರೆ ನೀವು ಅದು
ಬೇರೆ
ಬೆಂಗಳೂರು ಮ್ಯಾಟರ್ ತಾನೇ ಅದು.
ನೀವು ಯೋ ಟಾಪ್ ಇದು
ವಿ ಕೌನ್ಸಲ್ ಮುಖಾಂತರ ಲಾಗಿನ್ ಮಾಡಿ.
ವಿ ಕೌನ್ಸಿಲ್ ಲಾಗಿನ್ ಆಗ್ಬೇಕು ನೀವು.
ಅಯ್ಯೋ ಸಿಗ್ಲಿಲ್ವೇ?
ನೀವು ಡಿಸ್ಕನೆಕ್ಟ್ ಮಾಡಿ ಯು ಲಾಗಿನ್ ಥ್ರೂ ವಿ ಕನ್ಸೋಲ್ ಅಂತ ಬೇರೆ ಇದೆ, ಅದು ಬೇರೆ ಧಾರವಾಡ ಬೆಂಚ್ ಸಪರೇಟ್ ಪ್ಲಾಟ್ಫಾರ್ಮ್.
ಓಕೆ
ಬರೋದಿಲ್ಲ ಅದು.
ಸರಿ ಸರ್.
ದೇ ವಿಲ್ ನಾಟ್ ಟೇಕ್ ಅಪ್ ಧಾರವಾಡ ಮ್ಯಾಟರ್ ಇನ್ ದಿಸ್.
ಓಕೆ ಸರ್, ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಸರ್ ಇವಾಗ 7 ನಡೀತಾ ಇದೆ ನೋಡಿ
ಓಕೆ.
ಧಾರವಾಡದು.
ಹ್ಮ್
Fact matter.
Supreme Court confirm.
No, that is your lordship misses the mistake is committed by state. The entire SLP is cut and paste of 482 petition.
What to do now?
I suggested the DGCID to file a review petition on that.
Howದು? Because it is
And we made a submission that the
ಅದಕ್ಕೆ 511 and 405 ಕೊಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ.
ಹೌದು.
406.
ಹೌದು.
Matter
but
Patel.
I suggested DG to review that file a SLP
ನನಗೆ
review
ಗೊತ್ತಿಲ್ಲ,
petition.
ಕನ್ಫರ್ಮ್ ಆಗಿದೆ.
May I make one?
I am myself telling it's a wrong order.
ಹೌದು.
Ajit C.
My lord.
My lord, appear for plaintiff in this case, petition in this case, my lords.
List the matter on 7th March. Interim order subsisting will continue till the next date of hearing.
Oblige lords.
Yes.
Number 2, Devraj I.
But the petitioner, I mean, audible, madam?
Yes, yes. Yes, sir.
And the petitioner, accused number 4 and 5, my lord, has been arrived in the charge sheet. And kindly turn to the ink page 41, my lord.
Heard the learned counsel, we will dismiss it, sir. Heard the learned counsel appearing for the petitioner and the additional SPP. A perusal at the summary of the charge sheet would clearly indicate no role by the petitioner for, no role by the petitioners accused 4 and 5 in the alleged episode of the offences, in the alleged offences punishable under section 3. ಇದಿದ್ರದಲ್ವಾ assault.
Assault.
That
Assault,
my
but
pursuant to my orders.
Instigate.
yes, ma'am. Yes, ma'am.
That's what. So
Yes.
no ingredient of the offense that are alleged against the petitioners. In that light, there shall be an interim order of stay of all further proceedings where the petitioners accused 4 and 5 till the next date of hearing. List the matter on 14th March.
Get operative portion and today it's
ಯಾಕೆ
ಅದು ಇವತ್ತು ನಾಳೆಗೆ ಇಟ್ಕೊಂಡಿದ್ದು ಕಮೆಂಟ್ ಅಲ್ಲಿ ಇಟ್ಕೊಂಡಿದ್ದು.
ಈಗಲೇ
Comment
ಅಪ್ಲೋಡ್
ಅಲ್ಲಿ.
ಮಾಡಿ, ಈಗಲೇ
Please.
ಅಪ್ಲೋಡ್ ಮಾಡಿ.
Great, great.
Number 3, GS Venkat Subarao.
Initial.
Same covered. ಎಲ್ಲ ಬರೋದೇ ಇಲ್ಲ ಅವರು. The issue in the list stands answered by the orders passed by this court in all connected cases. There is no representation behalf the petitioner. List the matter as a last chance on the 7th of March. Yes.
Number 4, Hanmantraya CH.
I appear for the petitioner in this matter, your lordship. Mr. Valmiki Corporation scam.
ಗೊತ್ತಾಯ್ತು. 197.
Yes, your lordship. Sanction illa, prior sanction illa.
ಎಲ್ಲಿ ಪ್ರಸನ್ನ ಕುಮಾರ್? Not come. Shyam Sundar sir is. Where is he? Yes, Abhinay madam, pass over ಮಾಡ್ತೀನಿ.
Much obliged.
Number 5.
For the petitioner, accused is the petitioner is the accused number 6 for the alleged offense of section 390 and 402 of IPC.
Yeah. Come to page 59, last 6 lines.
Please, my lord.
ಆರೋಪಿ 6ರವರು ಕೈಯಲ್ಲಿ ಪ್ಲಾಸ್ಟಿಕ್ ಹಗ್ಗವನ್ನು ಹಿಡಿದುಕೊಂಡು ಯಾವುದೋ ಸೋನ್ಸು ಅಪರಾಧ ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ಹೊಂಚು ಹಾಕುತ್ತಾ ರಸ್ತೆಯಲ್ಲಿ ಓಡಾಡುವ ವ್ಯಕ್ತಿಗಳನ್ನು ತಡೆದು ಬೆದರಿಸಿ ಹಲ್ಲೆ ಮಾಡಿ ದರೋಡೆ ಮಾಡಲು ಅಥವಾ ರಸ್ತೆಯಲ್ಲಿ ಒಬ್ಬಂಟಿಕರಾಗಿ ಓಡಾಡುವ ವ್ಯಕ್ತಿಗಳನ್ನು ಅಡ್ಡಗಟ್ಟಿ. Anything else you want, sir?
That's the allegation, my lord, but there are no
That's
witnesses.
not allegation, sir. That is in the charge sheets.
My lord, it's based on the statement of the co-accused, my lord.
No, sir.
Subsequent, my lord, subsequent to filing, subsequent to the anticipatory bail granted to the accused number 6, my lord. May I request your lordship to page 80, my lord? It is his voluntary statement taken subsequent to
Yes,
anticipatory bail, my
Page
lord,
66.
on 6/8/2024.
Page 66, my lord, Mazar itself speaks about
ನೀವು ಇದು ಮಾಡ್ತಾ ಇಲ್ಲ ಅಂತ ಸಾಧ್ಯವೇ ಇಲ್ಲ. These incidents have become rampant now.
For a moment, my
If
lord,
you go on saying these things, road rage or road alley, what all you're doing, it will be putting a premium on them.
my lord, including the charge sheet, my lord.
No,
For a
no,
moment,
sir. Nothing
my lord,
doing.
For a moment, my lord, page number 80, my lord. I am a
Why
student, I am a student, my lord. There are no antecedents.
Student ಅಂದ್ರೆ ಕ್ಲಾಸ್ ಅಲ್ಲಿ ಮಾಡ್ಬೇಕು.
My lord, I'm
Not
not,
on the road in the night.
There are no
Yes.
antecedents, my lord. I was
No,
not even present at the scene. That is only on the
Sir,
statement of
ಅದು
the
ರಾತ್ರಿ
co-accused, my
ಆಗಿರೋದು
lord.
ಇವನ್ ಕಾಲೇಜಲ್ಲಿ ಇದ್ರ?
No, my lord. Even what is the nothing has been recovered at my instance, my lord. What they have recovered is they say that for a
No, sir.
moment, my lord, page number
We
80.
will
my lord.
not, we will not pardon these people who trouble travelers in the night, trying, whether you are trying to commit dacoity or not. It's preparation for commission of dacoity, I will not.
My lord, there is no specific court act allegations against
Oh,
me.
no,
They say that I just ran out from the crime scene, my lord. There is no specific court act allegations.
That's
Just
all.
be,
We'll
my
see,
lord.
we'll see.
But for a moment, my lord, page 80, my lord.
We'll see, sir.
Page number 80, my lord, for a moment.
Yes.
And also
Discharge
according,
discharge ಹಾಕೊಳ್ಳಂಗಿದ್ರೆ ಹಾಕೊಳ್ಳಿ.
my lord, even looking into the version of the complainant, my lord, even in the arrest memo, nothing is forthcoming. It is admitted that against accused number 1 and 2, there are 4 to 5 cases. Not even
Very
single
next
case
page,
against me, my lord. Not even a single case.
Okay.
Very next page, the Mazar.
ಎಲ್ಲ ಇದೆ. Not. List on 7th March. Next.
Grateful.
Bill number 6, Srinivas Rao, FF.
I appear for the petitioner.
Entry order ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ ಸರ್.
ಅದೇ ಇದೆ ಹಿಯರ್ ಮಾಡಿದಾರೆ ರೆಡಿ
7ನೇ ತಾರೀಕು ಮಾಡುವ.
ಆಯ್ತು.
Place the matter on 7th, interim order subsisting would continue to the next.
Literally, that they raised the issue of SIT notification issue.
ನೋಡಿ ತೀರ್ಮಾನ ಮಾಡೋಣ.
ಅದರಲ್ಲೂ ರೇವಣ್ಣ ಕೇಸಲ್ಲೂ ಅದನ್ನ ಇಟ್ಕೊಂಡು ಮಾಡ್ತಾ ಇಲ್ಲ ಅವ್ರು. ಇದನ್ನ ರೆಫರ್ ಮಾಡಿ.
ಹೌದಾ?
They place this.
ಮತ್ತೆ ಆರ್ಗ್ಯುಮೆಂಟ್.
ಹೌದಾ? ಅಲ್ಲ ಅವ್ರು ಸ್ಪೆಷಲ್ PP ಇದ್ದಾರೆ ಅದರಲ್ಲಿ. ಪ್ರವೀಣ್ ಅವ್ರು ಇದ್ದಾರೆ ಅಂದ್ರೆ.
Anyway, let's.
ಪ್ರದೀಪ್ ಅವರು.
7th, list on 7th March. Yes.
March.
Interim heard the learned senior counsel Ashok Karnali appearing for the petitioner. List the matter on March the 7th, 2025. Interim order subsisting will continue to the next date of hearing.
Bill number 7, Bhanu Prakash VG, Prasanna Kumar.
Hearing for the petitioner in this case, my lords.
Huh?
A week's time may be granted, my lords.
Week's time.
Yes.
Remove pin.
At the request of the counsel appearing for the petitioner. List.
Interim order may kindly be extended, my lords.
List on 7th March. Interim order subsisting would continue to the next date of hearing.
Obliged, my lords.
8, Suyog Herle.
153, 502.
For the petitioner,
502.
your lordship.
30.
Yes, madam.
My senior is held up in another court. If your lordships may pass it over.
Why you have not read the file?
I have read your lordships.
Then ಹೇಳಿ.
The offense is under 505 subsection 2, your lordships. The only allegation is that the petitioner, both the petitioners have made an inciting speech during a rally. But the complaint has been registered so moto, your lordships.
What's your name?
Chaitra.
Heard the learned counsel so and so, as Chaitra appearing for the petitioner. A perusal at the complaint so indicated would not meet the ingredients of the offense punishable under section 153 or 505(2) of the IPC as held by the apex court in the case of Javad Hajam 2024 4 SCC.
Stay there.
Stay there. So list on 7th March interim order ಬೇರೆ ಏನ್ ಬರಿಬೇಡಿ. Heard the learned counsel Chaitra ಅಂತ ಹಾಕ್ಬಿಟ್ಟು list the matter on 7th March.
Only 505(2). 153.
7th March interim order subsisting will continue to ಬೇರೆ ಏನ್ ಬರ್ದಿಲ್ಲ. Continue to the next date of hearing. Yes.
9, Vaidya Ravi.
Lord, I appear for the appellant.
ಇಲ್ಲ 7th, all these appeals 7th March.
Please.
Bill number 10, Girish Kumar BM.
Appear for the petitioner, my lord.
Objections ಹಾಕಿದಾರಾ?
ಹಾಕಿದ್ದಾರೆ. They have served on me.
Just sought for a complete relaxation. In fact, 8 accused have been granted bail. None of them have been, this condition is there.
My lord, but the relaxation, my lord, is let the victim of those 2 cases where the now matter is committed to Sessions Court be examined, and thereafter, my lord, can be considered.
Let's see. Let it come on 3rd March. Yes.
Please.
List on 3rd March.
Bill number 11, Vardhaman V. Gunda.
Petitioner. Petitioner under section 528 of the PMLA. That the petitioner and the respondents are in a business relationship. The respondent had, during the course of the business, raised an invoice of around.
Use the mic, sir.
15 lakh and 80,000.
Use the mic.
15 lakh and 80,000 my lord, on the petitioner. The petitioner has disputed a said amount. The respondent, rather than reconciling or discussing,
Petitioner is
negotiating
before
with
this court. Calling in question. Proceedings in CC 50865 of 2024. The learned additional SPP is directed to accept notice for the first respondent, emergent notice to the second respondent. A perusal at the complaint or the summary of the charge sheet now filed would clearly indicate that the proceedings, the criminal law is set into motion by the second respondent for the purpose of recovery of money out of a financial transaction between the petitioners and the complainant. Permitting further proceedings to continue would run follow the judgment of the apex court in the case of Lalit Chaturvedi versus so-and-so, 2024 SSC online SC page 759. Therefore, there shall be an interim order of stay of further proceedings quay the petitioners to the next date of hearing.
Number 12.
Obliged.
Gaurav N.
To the respondent, my lords, I filed my statement of objection.
Hakidira.
Hakidira.
7th, list on March 7th. Cancellation of bail.
Cancellation.
7th March.
Number 13. Vishnu Murthy.
I appear for petitions, your lordship. The offence is 306, 34, your lordship, that he was succumbed to death by hanging, your lordship, that he was already married and he have the 2 children, your lordship. He had illicit connection with the girl.
Illicit connection.
Your lordship, that
Illicit connection.
illicit connection, your lordship, that
electricity connection ಹೇಳ್ತಾ ಇದ್ದೀರಾ? Illicit relationship ಅಂತ ಹೇಳಿ.
Illicit relationship, your lordship, that she is aged 23 years, he is 38 years, your lordship, that they only suggested, your lordship, that he is already married and this engagement was held this one for this girl. That's why he was committed after 1.5 months after the death note, your lordship, that after 1.5 months of the incident, your lordship, that kindly peruse the in page number 115, your lordship, that he is approached the advocate, your lordship, that and was signed before the advocate for that one. After 1.5 months he was committed suicide. He was nowhere concerned with this incident, your lordship, that
repeat ಮಾಡಿ.
Your lordship, that in 115 page, your lordship, that this was mentioned in the death note, your lordship, that and the date 9/1/2023 Monday, they do call on 10/1/2023 Tuesday near Bamboo Bazaar advocate office, and they took my sign. Bamboo Bazaar advocate office. And take the affidavit and take the signature for the affidavit. After that, there's no such incident took place, your lordship, that after 1.5 months he was committed suicide. There's a 25. Therefore, your lordship, that is nowhere concerned for abatement to commit suicide, your lordship, that as held by the Lakshmidas versus state of West Bengal, as held by the apex court, your lordship, that
ವಿಷ್ಣುಮೂರ್ತಿ ಅವರೇ,
please, your
once more.
Please.
ಏನು ಗೊತ್ತಾಗ್ಲೇ ಇಲ್ಲ.
Your lordship, that the incident took place on 25/2/2023, your lordship, that he was taken to the advocate office on 9/1, called on 10/1/2023, your lordship, that and take the signature.
Petitioner is before this court calling, petitioners are before this court calling in question proceedings in CC 12703 of 2024 registered for offences punishable under section 306 read with 34 of the IPC. A perusal at the complaint or the summary of the charge sheet as obtained in column number 17 would not indicate the ingredients as necessary under section 107 of the IPC to be met for it to become an offence under section 306 of the IPC. The complaint appears to have been registered, or the charge sheet appears to have been filed only to assuage.
ನೋಟಲ್ ಒಂದು ಕಡೆ ಡೆತ್ ನೋಟಲ್ಲಿ
ಒಂದೂವರೆ ತಿಂಗಳಾದ್ಮೇಲೆ
ಬ್ಲಾಕ್ ಮೇಲ್ ಮಾಡ್ತಾ ಇತ್ತು.
Only to assuage the family of the deceased. The apex court has observed in 2 of its cases permitting further proceedings would run foul of the judgment of the apex court in the case of so and so 2025.
Lakshmi Das was the state of West
Wait, sir.
Yeah.
2025 SSC Online SC page 107 and 2025 SSC Online SC page 120. Therefore, there shall be an interim order of stay of further proceedings quae the petitioner till the next date of hearing. List on 1 additional SPP 2 emergent notice 21st March. Returnable by 21st March. List on 21st March. Yes, next.
Please, much obliged.
Lakshmikant
Much
ji.
obliged.
For appealing petition, my lord. Today we have already taken steps, my lord.
ಎಲ್ಲಿದ್ದೀರಾ ಸರ್ ನೀವು?
Officer.
Where are you?
Sir, I'm in office.
Set ಮಾಡಿ ಕರೆಕ್ಟ್ ಆಗಿ.
Today we have already taken steps, my lord.
You have already taken steps.
Yes,
I have already dismissed it. Learned counsel submits that the needful has been done. Office to verify 7th March. 7th March. Interim order subsisting will continue to the next date of hearing. Next.
15, Hariprasad MB.
For the petitioner, my lord, needful has been done, my lord.
Counsel submits needful has been done. Office to verify 7th March.
Grateful, my lord.
Vidyasagar R.
Special.
My lord, appearing for petitioner, my lord, this matter may be posted on 7th of March. Yeah.
List
I'll
on
comply meanwhile, my lordship. Objection.
office objections to be complied with
All
by
of-
the next date. List on 7th March. Next.
Copy has to, sir. Copy is not yet, sir.
ಅವತ್ ಮಾಡ್ತಾರೆ ಬಿಡಿ.
Please.
ಏನಿಲ್ಲ.
Vyake.
My lord, proxy counsel for the petitioner. Week's time may be granted, my lord.
ಏನಿದು ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್? A week's time is granted to comply with the office objections. In the event the stand complied, list the matter on 7th? 7th March, yes.
Bill number 18, Hanmantappa Harvi.
Complaint has been dismissed.
7th. Notice ತಗೊಂತೀರಾ?
Complaint has been dismissed.
Complaint. Learned additional SPP is directed to accept notice for the second respondent. List on 14th March.
Admission matter, serial number 19, KBK Swami.
Please, my lord.
I appear for the respondent, my lords, in serial
Correct.
number 19.1.
There are 2 petitions. One is seeking for cancellation of the bail, interim bail granted by the trial court. Second one is filed by the accused for quashment of the order passed in respect of the dismissal of the discharge application. Please, my lord.
ಈಗ stay ಇದೆಯಲ್ಲ?
Stay there, but in the second matter, they have not provided copy to us. Last time also it was directed to
ವಿಜೇತಾ
them.
madam.
Yes, my lords.
ಕಾಪಿ ಕೊಡಲ್ವ ಇವ್ರಿಗೆ?
My lords, we had already served the copy to the counsel previously appearing.
ಅವ್ರತ್ರ ಇಸ್ಕೊಳ್ಳಿಲ್ಲ.
We'll inquire with them. So both matter may kindly be heard together, please.
ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಅಲ್ವಾ?
Yes, please.
7th.
Grateful, madam.
List on 7th.
Great.
Interim order may be
Interim orders of any kind subsisting in any of these cases shall continue till the next date of hearing.
great.
Bill number 20.
ಇದು ಅಷ್ಟೇ 7th March.
Yes, my lord.
Interim order
Appear
subsisting
for-
will continue till the next date of hearing.
21, Shiv Prasad.
ಅವತ್ತೇ ಬರ್ಲಿ ಶಂಕರ್.
For
R2, my lord. I am appearing for R2.
ಯಾವ್ದ್ರಲ್ಲಿ?
21, my lords. 21, I appear for the petitioner.
ಏನು?
My lord, in this, I have made an
ಸ್ಪೆಷಲ್
application.
ಕೋರ್ಟ್ ಮಾಡ್ರ?
No, my lords.
498.
498A. I have
For
made an
the-
application for amendment. Charge sheet was filed during the pendency of these proceedings.
ಮಾಡಿದ್ದೀರಾ?
I have made an application. It is not put up, my lords. It may be taken up on.
List the matter on 7th. ನನ್ನ ಹತ್ರನೇ ಬರ್ಬೇಕಲ್ವಾ?
Please, my lords.
List the matter on 7th March. The registry is directed to put up the application seeking amendment of the petition. Interim order subsisting will continue to the next date of hearing. Yes, next.
Bill number 22, Sharad Jain.
Lords, this is 498 my lords, that Brahma Kumari matter. Both are police constables, my lords. The petition by the husband. Lordship has passed order, my lords. Stay is not yet considered. Only
Constable versus constable.
police, my lords.
Yes, list the matter on 7th March. There shall be an interim order of stay of further proceedings quae the petitioner till the next date of hearing.
Obliged.
Yes, next.
23, Prashant Chandra.
Lord, kindly permit me to appear online, my lord. Lord, here is a case, my lord. The charge sheet has been now filed. under section 427, 447, then 504 of IPC, and then my lord, the section 3(1)R, S and BA of my lord, the SC/ST prevention.
Civil suit ಯಾವುದು?
Civil suit ಇನ್ನೂ ಆಗಿಲ್ಲ. Civil suit ಅಲ್ಲಿ ಇದೆ, my lord, complaint lodge ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ. Civil suit ಇದೆ, but it is in the nature of civil. Why, my lord, I am saying so? The complaint itself doesn't say, my lord, there is any such offense being committed. My lord, in fact, initially the petitioner's hearing had filed, my lord, the petition before the honorable court challenging the FIR. But that was stayed. However, later it came to know
FIR stay ಇತ್ತಾ?
ಅದು stay ಇತ್ತು.
Yes. One additional SPP, 2 emergent notice returnable by the 14th of March. The learned counsel appearing for the petitioner submits that at the crime stage, there was an interim order operating in favor of the petitioners. In that light, there shall be an interim order of stay of further proceedings by the petitioners till the next date of hearing. Next.
Hello.
Special court.
Serial number 24, my lords. I appear for the petitioner.
24, my lord.
Who appears for the petitioner?
Dharmapal.
24, my lords.
24 Dharmapal.
Yes, my lord. The offense punishable under section 7 of Religious Institution Prevention and Misuse Act 1988. Now, my lord, during the time of the election, the allegation is that they have delivered the speech in front of the temple. And my lord, that temple not belongs to page number 78, my lord, that is the Dradikarana. Anur Gramada Panchayati Vyaptiya Anur Kere Gramadaliruva Doddatai Devasthana Mujina Ilake Serirudu Alla endu.
We will consider one additional SPP, 2 emergent notice returnable by 14th. In the meantime, there shall be an interim order of stay of further proceedings by the petitioners till the next date of hearing.
25, Ravishankar K.
I am for the petitioner, my lord.
I appear for the respondent 2 to 6 in this matter, your lordship.
Appointment of special public prosecutor gettu, my lord. Kindly have it after 2 weeks, my lord.
May I make a small submission, your lordship? Idrally, the application they have filed is the application which was dismissed in 21/3/24, where they had sought the court to treat the witnesses CW 35 to 37 as court witnesses. Now, all the 3 witnesses have been examined as PW 16 to 19. They stand discharged. Now, when the matter was posted for 313 statement, this appointment of special PP comes in, and they have filed another application for recalling the said witnesses with the mention saying they want to treat those witnesses hostile. So in the background of this submission, your lordship, this petition becomes infructuous because
Yes,
they are
madam.
asking the.
I'll seek the instruction from my senior, my lords. Kindly have it.
I'll take it on 20th then. If it has become infructuous, we'll close it.
Matter before the trial court is also on 20th, your lordship.
So I have not granted any stay here.
Yes.
At the request of the counsel appearing for the petitioner, list the matter on 20th. Yes, madam, seek instructions on that. Infructuous agidre infructuous ashte.
Much obliged.
Vidyasagar R. Prasanna
My lord,
Kumar.
this matter may be called out along with the criminal petition 7568 of 2018.
Well, Prasanna Kumar bandilva.
My lords, I appear for my lords, the respondent, but seniors my lords appearing a VC my lords Bangalore bench matter. Will be there in my lords 15 minutes.
All right, yes.
I'll file my objection in the meantime, my lords.
File it. List after 2 weeks. Yes.
This matter may be called out with
at the request of the counsel appearing for the petitioner. Next.
Number 27, Sundararaman MV.
Lords,
I appear for the petitioner in this matter, my lords.
for the respondent, my lords.
My lords, I've also filed an application for amendment, my lords. It's been served on the other side as well, but the same has not been reflected online, my lords.
Lords, objections are my lords sent for approval. I'll file it, my lords. A week's time may be granted in this matter, my lords.
All right.
Cell number 27.
Special court alva. 7th.
Please.
Interim order subsisting will continue to the next date of hearing. Yes.
Please.
Correct.
Appear for petitioner in this case, my lordship. Offense is 498A, my lordship.
The petitioner is the accused number 2, my lordship. The husband and wife are residing at Bangalore. She is the present petitioner residing at Tanjavur, my lordship. She never involved in the alleged offences, my lordship. Moreover, my lordship, in the annexure G, page number 82, my lordship, the complainant respondent has taken a defense, my lordship. Her husband was married in the year, she has got the divorce in the year 2017, my lordship. The
Yes,
present
the petitioner is accused number 2, the mother-in-law of the complainant. A perusal at the complaint or the summary of the charge sheet would not indicate any offense or any overattack performed by the petitioner for her to be drawn into the web of crime for offences punishable under section 498A or 504 of the IPC, permitting further proceedings against this petitioner, the mother-in-law, would run foul of the judgment of the apex court in the case of Kashkan Kaushar versus so-and-so 2022 SSC Online SC, page 162. Therefore, there shall be an interim order of stay of further proceedings by the petitioner till the next date of hearing. One additional SPP 2 emergent notice returnable by the 21st of March. List on 21st of March. Next.
Number 29.
I appear for the petitioner in this case, my lord. Petitioner was allotted a Karnataka Housing Board site in the year 2013 and 2019 when RTA activist, he makes a complaint before the ACB and the ACB has registered a complaint under 13(1)(c), my lord. I am not a public servant. I am only an individual making allegations that I have violated.
One.
Under similar matter, my lord, criminal petition number 13(1).
Number Kodi.
13(193) of 2024. 13(193).
13(193) of
2024.
20. Tag this petition along with so and so. List them both on 14th March. There shall be an interim order of stay of further proceedings by the petitioner till the next date of hearing. Yes, next.
Number 30. Dharampal.
I go to the petition, my lord. Petitioner was the one of the guarantor for the vehicle loan. Now the society who has a granted loan, they filed the private complaint without supporting an affidavit.
Where is the private complaint?
Private complaint, it is in the 16, my lord, page number 16. Page number 16, ink page number 16. Previously, I have preferred a petition where there was a
interim order ittala.
Interim order irlilla. Interim order.
Irlilla.
You know. FIR ಮೇಲೆ challenge ಮಾಡಿದೆ ಅವಾಗ stay.
The petitioner is before this court calling in question proceedings in CC 126 of 2024. The investigation is referred to by the learned magistrate on a private complaint filed by the second respondent complainant invoking section 200 of the CRPC. A perusal at the private complaint would not indicate its compliance with the rigors of as held by the apex court in the case of Babu Venkatesh versus State of Karnataka, reported in 2022 SSC Online SC page 200, for it does not accompany with an affidavit and as also the compliance with section 154, 1 and 3 of the CRPC. Therefore, there shall be an interim order of Therefore, there shall be an interim order of stay for the proceedings by the petitioner till the next date of hearing. One additional SPP to emergent notice. Next.
Number 31. V. Lakshmiya.
Hello.
Hello.
I am appearing for the petitioner, my lord. That petition has been filed for early disposal of the criminal petition pending before the trial court, my lord.
Oh.
Because this has been filed in the year 18, my lord. Unnecessarily, they are dragging the matter by one way or other by putting the two criminal petitions has been filed before this court. Your honor, you have been disposed of those things. Even then, the trial court is not taking any initiative. Go on giving the dates, my lord.
Yes. Additional speak. Nivilva. Oh, complainant.
Yes, I'm the complainant under section 138, my lord. This is a check bouncing.
The petitioner is before this court seeking a direction for expeditious disposal of the proceedings in CC 3014 of 2018 on the score that the concerned court is granting adjournments to the respondents accused without any rhyme or reason, and there is protraction with the proceedings. The issue is with regard to dishonor of a check and issue is with regard to offense punishable under section 138 of the Negotiable Instruments Act, and it is of the year 2018. In that light, as also the fact that the prayer being innocuous, I deem it appropriate. Innocuous. Innocuous. I deem it appropriate to dispose the petition with a direction to the concerned court to conclude the proceedings at an outer limit of 6 months, if not earlier, in accordance with law ordered according. Next.
32.
But I am in the connected matter. I have one submission to make, my lord, in this. 32.1, my lord.
Special court.
ಅದರಲ್ಲಿ ಲಾರ್ಡ್ಶಿಪ್ಸ್ ವಿಲ್ ಸಿ ನಂದ್ರಲ್ಲಿ ಸ್ಟೇ ಇದೆ ಅಂತ ಹೇಳಿ ಅದರಲ್ಲಿ ಅವ್ರು ಸ್ಟೇ ತಗೊಂಡಿದ್ದಾರೆ. ದಟ್ಸ್ ನಾಟ್ ಕರೆಕ್ಟ್ ಲಾರ್ಡ್. ಓನ್ಲಿ ದ ಚಾರ್ಜ್ ಫ್ರೇಮಿಂಗ್ ವಾಸ್ ಡಿಫರ್ಡ್. ಕೈಂಡ್ಲಿ ಸಿ ಲಾರ್ಡ್.
ಅದರಲ್ಲಿ ಸ್ಟೇ ಅಂತ ಆಗಿದೆಯಾ ಈಗ?
ಇಲ್ಲ, ನಂದ್ರಲ್ಲಿ ಚಾರ್ಜ್ ಡಿಫರಲ್ ಆಗಿದೆ. ಅವರು ನಂದ್ರಲ್ಲಿ ಸ್ಟೇ ಇದೆ ಅಂತ ಅವ್ರದ್ರಲ್ಲಿ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದಾರೆ.
This court on 16/1/2025 on the ground that there is an interim order in criminal petition 13591 of 2024 had granted an interim order of stay. The interim order in 13591 of 2024 is only deferment of the proceedings before the concerned court and not an order of stay. Therefore, the same order is to be granted in the cases in the other companion petitions as well. Therefore, the orders, if any, of granting of stay stand modified to the effect that the proceedings before the concerned court shall be deferred till the next date of hearing, list on 7th March.
In
this case also, they are not served the copy, my lord.
Petitioners to serve set of papers upon counsel Shri B.S. Prasad, if not already served, forthwith. Yes, next.
My lord, this matter may be connected with serial number 16, my lordship.
On that day, you make a mention, sir. Yes, next.
Number 33. V.R. Vishwanath.
33 will take secure records, my lord. It is on the exorbitant interest rates. Of late, it become a menace where people forced to.
Special court. Allah. At the request of the learned additional SPP, list on 7th March.
Lord, interim order in my case may be extended, my lord. I'm sorry.
Elladrallu interim order release extend agutte. Yes.
Number 34. Ravi Shankar K.
I'm for the petitioner, my lord.
In this case, I undertake to file wakalat for the respondent, my lord, along with statement of objections. Kindly a date may be given, my
The
lord.
learned counsel, some Hesru, madam.
Sumati Pauline, my lord.
So, undertakes to enter appearance for the respondent. Registry to print the name of so and so is appearing for the respondent. List the matter on 14th March. Objections, if any, by then interim order subsisting shall continue till the next date of hearing.
Obliged.
35. Mahesh S.
I appear for the petitioner. My lord, in this matter, PMLA matters was proceeded despite of the stay in the predicate offense, my lord. So your lordship was pleased to grant stay in this matter. And the same point of law is involved in serial number 53, my lord.
Objection to करेंगे.
Yes, sir.
My lord, same point of law involved in 53 also.
Then I'll take it at 53.
Very well.
Yes, next.
Number 36. Gaurav H.S. Jagdish.
My lord, I am for the petitioner, my lord. Praise time for 1 week, my lord.
Praise time?
Yes, my
Grants
lord.
time. Yes.
Obliged.
7th March, interim order subsisting will continue to the next date of hearing.
Number 37. Rishit Kumar.
For the petitioners, my lord. Section 192, 196, my lord, 352, 353, my lord. Protest, my lord. They're protesting against withholding the award, my lord, to the principal. Page 18, my lord, is the
One
complaint.
additional SPP, 2 emergent notice. In the meantime, there shall be an interim order of stay of further proceedings by the petitioner to the next date. Next.
Much obliged.
38, Hemant Kumar K.
Namma Mane. Jagdish. Polyclinic.
Idralli, I'll secure records, my lord, but
You secure the records. I'll take it on third.
yes,
List on the learned additional SPP to secure the records of search and seizure of the clinic of the petitioner by the next date. List on third. Yes.
Number 39, KBK Swami.
Petitioner is arraigned as accused.
filed
Number
a
5.
petition.
Yes, yes. Earlier also a petition was filed that was came to be
without,
withdrawn.
Withdrawn.
Yes, yes.
Post
Kindly
charge
come
sheet.
to.
Post charge sheet withdrawn. What are the
Post
changes?
charge sheet you withdrew it.
No, that
Why?
may kindly come to the.
Why did you withdraw it?
Page
Pre
9.
charge sheet withdraw ಮಾಡಿದ್ರೆ okay. Withdraw.
No explicit reasons are cited. So only permission was sought to withdraw, but now the change in circumstances.
ಅಷ್ಟೇ.
I mean-
Now you'll have to establish change circumstance.
Certainly, please, my lord. In the petition which was filed earlier, the grounds were not urged properly.
That is not the change circumstance.
No, that's true, please, my lord.
Its lacuna is not the change circumstance.
No doubt that. But in the present case, what had happened is that prior to conducting the raid on the particular party, see, the complainant did not go to the spot and overhear the conversation as to whether the information which he received is credible or not.
ನೀವು ಒಂದು ಕೆಲಸ ಮಾಡಬೇಕು.
The
ಅಲ್ಲಿ ಡಿಸ್ಚಾರ್ಜ್ ಹಾಕ್ಬಿಟ್ಟು ಅದು ರಿಜೆಕ್ಟ್ ಆದ್ಮೇಲೆ ಬರ್ಬೇಕು.
and liberty may kindly be granted to approach the, at least in that regard, so that please, my lord.
ಅಲ್ಲ ಈ ವಿಡ್ರಾ ಮಾಡಿದ್ಮೇಲೆ
ಕೇಳಿಲ್ಲ.
ಸರ್ಕಮ್ಸ್ಟಾನ್ಸ್ ವಿಲ್ ಬಿ
Yes, yes.
ಹಾಕ್ಬೇಕಾದ್ರೆ ಮೆಮೊ.
Earlier, my predecessor has not sought that
ಅಲ್ಲ
place.
should you not file a
That permission may kindly be granted, please, my lords. We'll explore the possibilities there.
Yes.
Come back.
The petition heard the learned counsel appearing for the petitioner. The petitioner is before this court calling in question proceedings in CC 2846 heard the learned counsel for the petitioner and the learned additional SPP B.N. Jagdish. The petitioners are before this court. Accused number 5 matra alla?
Yes, please, my lord.
The petitioner accused number 5 is before this court calling in question proceedings in CC 2846 of 2023 registered for offences punishable under 309 and 399 and 402 of the IPC. The very petitioner had preferred a petition in criminal petition 6479 of 2024. After the filing of the charge sheet, the same comes to be withdrawn. And therefore there is no change circumstance in the considered view of the court at this juncture to entertain a second petition, though there is no absolute bar. The petitioner at this juncture would submit that he would avail the remedy of filing a discharge before the concerned court and then approaching this court in the event of need arising. The said submission is placed on record. Liberty is reserved to the petitioner to avail of the remedy of filing a discharge and then approach the doors of this court if need arises, ordered accordingly. ಈಗ permission ಕೊಟ್ಟಿದೆ.
Great.
Memo correct.
Please.
Yes.
40.
My lord, in
ಇದೇನಪ್ಪ?
serial number 40 and 40.1,
Hmm.
the issue is in respect of rejection of the order in respect of application filed under 91
ಏನ್
CRPC.
ಇದು ಇನ್ನೊಂದು ಹಿಯರ್ ಮಾಡಿದ್ದಾನೆ ಅದಲ್ವಾ ಇದು?
That's a different matter.
ಅಲ್ಲಪ್ಪ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲ.
Same matter.
ಸೇಮ್ ಮ್ಯಾಟರ್ ಇದರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆ ಅಲ್ವಾ ಇರ್ಲಿ?
Now there is an interim order
But this can
to
be
defer
disposed
the proceedings. Now the issue before this honorable court is that.
Other matters filed.
Yes, please, my lord.
ಒಂದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೋಯ್ತು ಅದಲ್ಲ, ಅದಾದ್ಮೇಲೆ ಒಂದು ಫೈಲ್ ಮಾಡಿ.
That was in respect of 164 statement.
ನಾಗೇಶ್ ಅಪಿಯರ್ ಆಗಿದೆ.
Yes, please. Learned senior has appeared in that matter.
ಹೌದು. ಅದು ಯಾವುದು?
So that was in respect of 164 statement, please, my lord.
ಅದು ಡಿಸ್ಪೋಸ್ ಮಾಡಿದೀನಿ. ಅದಾದ್ಮೇಲೆ ಎರಡು ಹಾಕಿದಿರಲ್ಲ.
So that is in respect of the second case, please, my lord. There are 2 FIRs.
ಗೊತ್ತಾಯ್ತು. ಆ ಸೆಕೆಂಡ್ ಆ ನಂಬರ್ ಕೊಡಿ. ಇದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದೆ ಅಲ್ವಾ?
Yes, please.
ನಾಲ್ಕು ಒಟ್ಟಿಗೆ
This can be
ತಗೊಂಡು.
disposed of.
This can be disposed of.
They are only asking for certain, they filed an application seeking a document to be summoned from the police
Cottonpet
station.
police station, please, my lord.
That can be allowed, my lord. That matter need not be.
On consensus will close it then.
Yes.
Yes. ಇಲ್ಲರೇ ಬರಿಬೇಕು ಅದು ಪೂರ್ತಿ. Yes, the petitioner is before this court calling in question an order dated 29/1/2025 by which the concerned court rejects the application filed by the petitioner under section 91 of the CRPC. Heard so and so. The petitioner, end document ಬೇಕಾಗಿತ್ತು ನಿಮ್ಗೆ?
So the station house diary,
ಎಲ್ಲಿ?
kindly come to the
ಅಲ್ಲ ಎಲ್ಲ
Page 81. Page 81.
page number 81. The copy of the application is also
The
annexed.
petitioner files an application before the concerned court invoking section 91 of the CRPC, seeking certain documents from the Cottonpet police station. The documents sought are as follows. Page 81-82. The application comes to be rejected, the rejection of which has driven the petitioner to this court in the subject petition. The learned additional SPP submits that the document.
Rejection is, our objection is that he not filed an RTA application. That cannot
The learned additional SPP submits that the objection of the prosecution was that he could have secured them by filing an application under Right to Information Act. The rejection on the said score, the objection is taken note of by the concerned court and the application comes to be rejected. The rejection of which is on the face of it illegal, as that is not the purport of section 91 of the CRPC, that an accused should be driven for securing documents under the Right to Information Act. In that light, the petition deserves to succeed. Deserves to succeed with the prayer that is sought before the concerned court to be granted. For the aforesaid reasons, the following order. Petition is allowed. The so-and-so order stands quashed. The application filed by the petitioner under section 91 of the CRPC is allowed. The prosecution shall place on record the documents that are sought by the petitioner at the appropriate stage in the trial.
Grateful.
Yes, ordered according.
if available.
41.
If available.
Same,
Of course, subject to availability. Always.
the same, please.
Same, 40?
Yes, yes, please. 41.
ಎರಡು ಒಟ್ಟಿಗೆ ಮಾಡ್ಬಿಟ್ಟು.
Yes, yes, please, madam.
Same
Come
time
on.
ಮಾಡ್ಬಿಟ್ಟು ಒಂದೇ order.
42.
Great.
Satyanarayan.
I appear on behalf of the petitioners, Your Lordship. 42 and 42.1. Seek a short accommodation, Your Lordship.
Special
Some
court
inconvenience today.
Seventh, yes. List on seventh interim order subsisting will continue to the next day.
Much obliged to you.
Ivani Shetty.
For petitioner, Your Lords. Your Lords, this is the matter with regard to where senior counsel Mr. Sandesh Chowta had appeared with regard to 50,000 rupee.
He is here only.
Yes, Your Lords.
You have not briefed Sandesh Chowta today?
Yes, we have, Your Lords. Your Lords, this
We
was,
have, then he is not here.
Your Lords, this is for the respondent's submissions, Your Lords.
Loss of 50,000 mineral permit.
Yes, yes, Your Lords.
Yeah, in fact, I'd argue this matter. 4 points for consideration. They were supposed to reply back to the 4 points.
B.S. Prasad.
It's also, my lord, up to 46, my lord, on 7th, my lord.
43 to 46 on 7th, because I've heard you completely.
Please,
List the matter on 7th for further hearing.
My lord, I appear in 44 and 40.
50,000 rupees.
40
Up to 46, yes.
Yes.
May I make a submission, my lord?
Interim order sub, Pradeep sir.
Yes, my lord. I'm sorry, my lord, for interfering.
Yes,
My lord,
tell me.
serial number 6, I was not able to connect, my lord.
ಯಾವ್ದಕ್ಕೆ ಪ್ರದೀಪ್ sir?
The serial number 6 ಅಲ್ಲಿ SIT matter, my lord.
ಅಯ್ಯೋ ಅದು 7th ಹಾಕಿದ್ದೀನಿ.
Obliged, my lord.
7th ಹಾಕಿದ್ದೀನಿ. Yes.
Obliged, my lord. I'm sorry,
Same
my lord.
request, my lord. Serial number 12, my lord. May I only
Jagdish
mention
sir
same
is here.
request. Serial number 12, it has been adjourned to 7th, I believe, my lord. I was not aware.
7th March. You
Serial
want it
number
on 7th
12.
March, sir?
7th, is it adjourned, my lord? I'm not aware. Because
No,
the
it
matter
is, the council said take it along with 53. So
No,
I
but
am
I'm told
yet to
number
reach
12 has
53.
been adjourned to 7th. That is what I was told.
All right, sir, we'll take it on 7th, no problem.
Very well.
Yes.
I'm sorry, my lord, for disturbing the court.
No problem, sir. Yes.
Yes. Obliged.
Yes, yes.
Number 47. Shivcharan R.
Lord, in this case, appeal for the petitioner, my lord. Lord, the petitioner is seeking to quashing of FIR, my lord, where the crime has been registered under section 144 of Karnataka Forest Act, my lord. My lord, this is with respect to where the land, whether it comes under the 100 meters within the boundary of forest.
Yes, comment.
Like it's earlier he filed a petition. Court said go and approach for discharge. Earlier, filed a petition.
Huh.
Court said file a revision.
Where is it?
It's
My
attached,
lord,
my lord,
as per Annexure H, my lord.
page 70, sorry, page 109.
One nimisha.
Lord,
All connected cases.
yes, my lord.
Page 109.
109, or maybe 72 or 1. Both numbers are there. Annexure G, my lord.
Page number 70, my lord.
All contentions taken. Revision petition ಹಾಕ್ಲಿಲ್ವಾ?
Akittu, my lord. That has been, as per Annexure H, my lord.
ರಿಜೆಕ್ಟ್ ಆಗಿದೆಯಾ?
Criminal revision petition has been
ರಿಜೆಕ್ಟ್ ಆದ್ಮೇಲೆ
reject ಆಗಿಲ್ಲ, my lord. They said to approach the concerned special court pertaining to MMRD Act ಅಂತ refer ಮಾಡಿ.
They said go before appropriate court and file.
Go before appropriate court. This is not the appropriate court.
Posted for HBC.
Please, my lord.
482 is not the appropriate court.
Please, my lord. Please, my lord. I'll approach the concerned.
Yes,
only request, my lord, may I make one submission? My lord, till some time may be granted, stay may be granted till I approve. That's all. If it,
Court has said you approach the appropriate court. This is not the appropriate court. Where
Please.
will I grant an interim order, sir?
please, my lord.
You
I would
immediately do.
concede.
The
Please, my lord.
petitioner is before this court. A petitioner is before this court seeking the following prayer. This very petitioner was before the court in criminal petition 2894 of 2012, which comes to be disposed by a coordinate bench. Observing that the petitioner has to avail the remedy of filing a revision until the petitioner would file a revision petition, the interim order would operate. The petitioner avails of filing a revision, and the concerned court now relegates the petitioner to the special court as the offences are the ones punishable under the MMDR Act, MMDR Act. The learned counsel at this juncture submits that he will approach the concerned court by filing a necessary petition. The submission is placed on record. Petition is disposed with the aforesaid liberty.
Grateful.
For 48, further reading matters.
The respondent number 2, my lord, praise time.
Praise time, no grants time. Yes.
For petitioner,
Mm.
this case is his allegation is the accused number 1 has denotified the land for the benefit of the petitioners. These petitioners are the purchasers of property after lapse of 3 years from the date of need to not.
ಒಂದು ನಮ್ಮ ಆಗ್ಲೇ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದೇನೆ ಕುಮಾರಸ್ವಾಮಿ ಕನೆಕ್ಟೆಡ್ ಅಲ್ವಾ?
ಇಲ್ಲ ಅದು ಅವರು ಚಾರ್ಜಸ್ ಇದಕ್ಕೆ ಫರ್ದರ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಬಂದಿದೆ, ಅದು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. ಇದು ನಾನು ಇದು ಪ್ರೊಸೀಡಿಂಗ್ ಕ್ವಶನ್ ಮಾಡಿದ್ದೀನಿ. ಇದ್ರಲ್ಲಿ ಮಾಡ್ರಿಲ್ಲ 21
list the matter on 7th March.
ಇಂಟ್ರಿ ಮಾಡಲಿ 21 to
No, sir. Yes,
ಬಿಫೋರ್
next.
ಚಾರ್ಜ್ ಪೋಸ್ಟ್ ಆಗಿದೆ. ಇದರಲ್ಲಿ
7th
ಎವಿಡೆನ್ಸ್
March.
ಮಾಡಿ ಕಾಮೆಂಟ್.
49, Naveed Ahmed.
Same 7th March interim order subsisting will continue to the next date of hearing.
Bill number 50, Abhishek ke?
Filed objection.
Oh, no.
I have filed it.
Filed,
Filed.
Oh, very good.
My lord, petitioner here in my lord is editor.
Moda scam air ಮಾಡಿದ್ದಕ್ಕೆ offense.
ಇಲ್ಲ Moda scam ಕಿಂತ ಮುಂಚೆನೆ in the budget, my lord, if your lords may kindly see, my lord, take to page 33, annexure C. This was a tweet, my lord, which was done.
Yes.
I'm an editor, my lord, of a news channel. The tweet, your lords may kindly see, my lord, page 33. What I have stated. Annexure C, my lord.
330 crores.
330 crores have been earmarked by the Congress Karnataka state government in its budget for development of work property for construction of Haj Bhavan and Mangalore and Christian community development. This is a state where the government pockets an average of rupees 450 crores worth of annual donation by Hindu devotees. Yes. Now, my lord, on the basis of this, a complaint has been filed under 153A and 505, and matter referred to CID for investigation.
Very important matter, CID investigation.
Very important matter. Now, my lord, I have, if your lords may kindly see the interim order, my lord, your lordships have given it is a detailed order on 27/9/24. I am, my lord, relying upon the judgments of my lord
Javed Hajam.
Suresh. Yes, Javed Ahmad and
Prasad
Patrika
Senwal
and Shiv
and
Prasad.
Javed Hajam. Yes.
Yes, my lord, my colleague, my lord, will just hand over. It was given on earlier occasion also, my lord. It might be in the file also.
Interim order kodbekar aden irlilla. So
Yes.
don't worry. Yes.
Now, my lord, my further submission is, it is not that, my lord, I have given a false statement. Now, what is there in the budget, my lord, I have stated. Now, budget also has been produced, my lord, as an extra page. If your lords may kindly turn to page 89.
Yes.
Page 89,
Objection.
90 and 91.
Objection yenu.
My objection, my lord, this very
It amounts
tweet,
to.
the very tweet itself is a false.
Huh?
The very tweet itself is false.
Oh, because it is false, so it has the propensity to incite.
It is false. It intended to create an enmity between different religious groups.
Oh, yes.
And I have given, my lord, in my statement of
Petitioners have a right, my lord, to dissent in a legitimate
how
and
much
lawful
money has
manner.
been.
They cannot, my lord, curb our freedom of expression.
In my objection, my lord, I have stated.
Heard reserved. Heard the learned counsel Bipin Hegde appearing for the petitioner. Counsel additional SPP B and Jagdish. Judgment reserved. Yes, next.
Number 51.
Judgment.
My lord, I appear for the petitioners, your lordship. Senior counsel Lakshman sir is engaged in the manner. He's on his way.
List on the way.
Yes, your lordship. He's held up in a court. He's coming to the chambers for to appear through VC, your lordship.
Oh, on the way to VC. All right.
FSL report
From the
was
court
sought.
hall.
Yes.
FSL report was sought.
7th Parley. List on 7th. Interim order subsisting will continue to the next date of here. Yes.
52. Manjunath Amar.
No, 52 I appear for the respondent, my lord, in 52 and 52.1 I have for the petitioners, my lord. That case, my lord, that 4 marriages, my lord has heard.
Petitioner really.
Bandila avaru.
Both connected, Allah.
How's
Anyway, one chance Koduvard. We'll take it on 20th.
Please.
List on 20th awaiting the appearance of the petitioner in 252. Interim order subsisting will continue to the next date.
Number 53. Mahesh.
May I appeal for the petitioner? This matter.
7th ASG asked on 7th.
No issues. And in the meanwhile, their objections may kindly be served on me, madam.
All right. Yes. List on 7th. Objections of the respondent enforcement directorate be served upon the counsel for the petitioner. Next.
And stay in both the matters may continue.
Interim order will continue, madam. Innon serial number yavadu Mahesh?
35.
35 and this tag them and list them both on 7th. Interim order subsisting will mark the presence of both counsel as Mahesh appearing for the petitioner and learned additional solicitor general appearing for the respondent enforcement. Yes.
Definitely.
Next.
We beg to appear for the petitioner, 499 and 500.
For the respondent, my lords. My lords, so I pray time, my lords, a week's time may be kindly be granted.
Bless the matter on 7th March.
Grateful, my lords.
Interim
order subsisting will continue till the next date of year.
Great. Obliged.
55. SB Matpati.
Petitioner. Oh, senior is that? Senior. Yes. Kudi. Yes. In Dagidya.
Last time, my lord, he wanted to argue.
Allah, because he had come, he has submitted. Now you are there. How long will it?
Office. I'm basically. 66.
Sir.
Basically, I'm too important and serious legal issues. If that appeals to your lordship, probably I need
then
not.
We'll go to the legal issues.
Go to the facts of the case and all that. Now, I for myself feel, my lord, in the fitness of things and in fairness to the complainant, that the matter warrants an order of remand at your lordship's hands in the event of my lord agreeing with my legal submissions. That's all. My lord, this is a private complaint. Complaining of an offense of forgery and user of a forged document, knowing or having reason to believe that the document is forged. That is made penal under section 465, 468, and 471. But the court would take cognizance and would issue process against the accused. The accused would enter into his appearance in the case. But in view of the fact that the complaint is a private complaint, my lord, the procedure that is mandated under Chapter 15B has got to be followed. May I just request your lordship to kindly turn to Chapter 19B.
19 CRPC.
CRPC, old.
Sorry, Your Honor, which petition is being?
Which pet? 111
1172.
Yes.
The case 19B, cases instituted otherwise than on the police report. So kindly pause for a minute. For my understanding, my lord, I am making this submission. Well, if it is a police report filed under 173, for the purpose of framing of charges or for the purpose of passing an order of discharge, the court will have the advantage of the report as filed under section 173(2) of the CRPC. It leaves no doubt. The report that is filed under 173(2), my lord, contains my lord, the statements of witnesses, the documents, if any, the investigator collected during the course of the investigation of the crime and whatnot. After a perusal of the record of the case, my lord, be it under 227 or be it under 239, that is the statement of witnesses and the records, the court would make up its mind whether charges have got to be framed or the accused is entitled for an order of discharge. But in a private complaint, that is a case which is instituted otherwise than an report.
Yes.
May I just invite my lord's kind attention to section 244 first. When in any warrant case instituted otherwise than a police report, but this is a case that is instituted a warrant procedure otherwise than a police report, it leaves no doubt. The accused appears or is brought before the magistrate. The magistrate shall proceed to hear the prosecution and take all such evidence as may be produced in support of the prosecution. Kindly pause for a minute. Well, the law enjoins a duty, be it upon the court or be it upon the complainant, my lord, to produce all such evidence. I'm sure your lordship would certainly agree with me. The trial judge says it is only the examination chief is evidence and cross-examination and re-examination is not evidence. I'm sure your lordship would certainly agree with me. The evidence that is found under section 244 is not confined only to examination in chief. It certainly includes cross-examination and re-examination. Let me repeat it. The recovery petition requires that accused appears or is brought before them. The magistrate shall proceed to hear the prosecution and take all such evidence as may be produced in support of the prosecution. Here the prosecution is the private party, a complainant has got a lead evidence. The magistrate may, on the application of the prosecution, issue summons. But here even summons could also be issued to the witnesses, to any of the witnesses, directing him to attend or to produce any document or thing. If upon taking all the evidence referred to in section 244, but even under section 244, your lordship would get or take all such evidence. Now under 245 also, if upon taking all such evidence referred to in section 244, the magistrate considers for reasons to be recorded that no case against the accused has been made out, which if unrebutted would warrant his conviction, the magistrate shall discharge him. But the evidence that is led under section 244, there is only examination in chief or cross-examination and the re-examination. If it were to remain intact on record in the case without being subjected to the test of cross-examination, the magistrate should be in a position to give a finding. Well, that is sufficient to hold the accused guilty.
Now, what has the court done?
I'm sorry, my lord.
What has the court done now?
Court says it is only examination in chief alone that could be looked into.
So you filed an application for compliance with 244?
No, my lord, I have cross-examined the witnesses.
Oh, you already cross-examined?
Yes. But next, only one sentence, then I shall take your lordship to the finding that is given, and then the law laid down by the Supreme Court. Well, now kindly go to 245, my lord.
Yes.
Leave the evidence led by the complainant in the absence of a touchstone method of that evidence being subjected to the test of cross-examination.
Yes.
If that were to be left alone, unrebutted, without being tested, subjected to the test of cross-examination, that should infuse a confidence in the judicial mind of the court that is sufficient to hold the accused guilty. Otherwise, no, my lord, he can't do it. Under section 245, my lord, then, my lord, comes 246. If when such evidence has been taken, here also your lordship would get evidence, 245 evidence, 246 evidence, 244 also evidence has been taken, or at any previous stage of the case, the magistrate is of the opinion that there is ground for presuming that the accused has committed an offense triable under this chapter, which such magistrate is competent to try and which in his opinion could adequately be, he shall frame the charges in writing. So the basic essential requirement for the court
is that it is at the stage of framing of charge? No, it is crossed that.
No, my lord, I would make an application requesting the learned judge to exercise his jurisdiction under section 245, no sooner the evidence is recorded, to pass an order of discharge in my favor. May I invite your lordship's kind attention to the order, my lord, without going into the evidence. I don't want to take your lordship to the evidence at this point of time. If it becomes necessary, certainly I shall do it. May I invite your lordship's kind attention to the order at page 100, commencing from page 178. Kindly go to page 178.
Yes, sir.
I think it would be useful for me to invite my lord's kind attention straight away to the finding which my lord gets at page 186 first. Then I will go back. My lord, with all humbleness, let me submit to your lordship. This judge thinks that he knows better law than his predecessor in office. He writes it. He writes it. But may I request your lordship to kindly go to page 186, para 22. As already discussed here in above, after the evidence of prosecution under section 244 of CRPC, the stage is for charge or discharge of the accused under section 245 of CRPC. It is thereafter, my lord may kindly note this, it is thereafter the accused gets the choice of cross-examination of complainant and the prosecution and its witnesses. However, maybe due to inadvertence, in this case, my predecessor in office had allowed the accused to cross-examine PW1 prematurely before the charge, before the stage of section 245 of CRPC. As such, that portion of premature cross-examination of PW1 by the accused cannot be considered at this stage of section 245(1) of CRPC. Because if such cross-examination of PW1 is also considered at this stage, it would amount to final appreciation of evidence for arriving at a final conclusion, and that would lead to the judgment of conviction or acquittal. But this is certainly unacceptable. It is an assault on the provision of...
Yes, what are the judgments?
I'm sorry, man.
Judgments.
Any number of judgments I shall. Still, if my lord feels... You baridirodella findings
yes.
findings that is number one. But kindly go to the second issue, legal issue that is involved in the case is this. Well, probably to buttress his claim, the complainant would send certain documents to the private forensic science laboratory. That is
Private laboratory?
Truth.
Truth labs.
Truth labs. ಅದರಲ್ಲೂ ಏನಿತ್ತು ಹೇಳ್ಬಿಡ್ತೀನಿ ಒಂದೇ ನಿಮಿಷ ಹೇಳ್ಬಿಡ್ತೀನಿ ಜಾಸ್ತಿ ತಗೊಳ್ಳಲ್ಲ. The truth lab would give a report. May be or may not be in favor of the complainant. Let us not go to that report now. But what came to be sent to the laboratory for the purpose of comparison? But it is crystal clear that in the science of handwriting, my lord, what is needed to be sent to the expert for comparison and his opinion are threefolded. Number one, question document or a disputed document. In common parlance, we call it as disputed document. Well, scientifically, they call it as question document. Number two, standard writings or standard signatures. A writing or a signature which has come into existence at an undisputed point of time. Number three, a specimen writing or a specimen signature. These are the basic documents that are needed for the purpose of comparison of a writing or a signature by an expert. It is only thereafter, my lord, by using some technical devices and all that, he has got to compare the writings and signatures. We saw the question document and then give his opinion. But what came to be sent to the truth lab are all Xerox copies of the documents. That is impermissible.
Where do you get that?
Yes, I shall take your lordship now to that. And what the learned judge says is, does not matter whether it is a original or a Xerox, he has given opinion. And he is not even examined. And under 244, all such evidence, marking of a report through the complainant who has nothing to do with that document, cannot be read in evidence. May I now invite your lordship's kind attention to kindly go to page 176 at paragraph 13. 13.
170?
176 at paragraph 13. Well, I'm only on two important legal issues. It is only for that limited purpose I am drawing my lord's kind attention. Para 13. That apart, the complainant has also got compared and examined the signature of the accused number one. Exhibit P6 through an expert of the Truth Labs, Bengaluru, and obtained the report as per Exhibit P22. On considering all the above documents with the testimony of PW1, prima facie it appears that there is such a difference in signature of accused number one in Exhibit P6 and other documents which could be noticed with naked eyes by any prudent man. Similarly, there appears to be some similarities in the nature of signature of accused number one in Exhibit P6 and the signature of accused number two in Exhibit P9. Therefore, the documentary evidence produced by the complainant in his examination in chief prima facie corroborate the allegations of complainant as to the forgery of signature of accused number one in Exhibit P6, though the said documents are subject to the test and proof by way of cross-examination by the defense counsel. Now, my lord, kindly go to page, because your lordship asked me a question about the Xerox copies having been sent. Where do we get it? Kindly go to paragraph 180, paragraph 17, page 180, paragraph 17. Further, as rightly argued by the learned senior counsel for submission, well, finding is in my favor, but the result is against me, unfortunately. Further, as rightly argued by the learned senior counsel for submission of the said form number 6, the personal presence of the accused number one was not mandatory. No doubt, such a form of a person could be submitted by any of the agents or workers, but such form should prepare and signed by the accused number one himself, but not anybody else. As such, in the present case also, there was no bar for the accused number two to submit the said form number 6 of the accused number one to the electoral registration officer. Said form number 6 should have been duly signed by the accused number one himself. It is the allegation of the complainant that the same was signed by the accused number two, as if it was signed by accused number one, who was not at all in India, at that particular point of time. Therefore, the issue as to the forgery of signature of accused number 1 by accused number 2 is for trial in this case, but not the issue as to the filing of submitting the form number 6, etc. Then, my lord, he also admitted down below, my lord, down below, etc. Probably we can skip all those things and then kindly go to straight away.
But this line of argument cannot be considered at this stage.
You can't consider it. He said, my lord, I shall just show to your lordship. Kindly go to page 189, paragraph 25. This here your lordship would get it. Because this would clear your lordship's question to me. Paragraph 25. No doubt on perusal of the records, it appears true that the complainant for getting the said expert opinion in Exhibit P6 had not supplied the originals of the said form number 6 and also not supplied specimen signatures of accused number 1. But he has supplied Xerox copies of the said Exhibit P6 to the said truth labs along with the documents containing standard/admitted signatures of accused number 1. On the basis of the same, the expert of the said lab has given his opinion as per Exhibit P22. Whether the said opinion could be accepted or not could be considered only upon his examination, which he has not done. He places reliance on that, says it is a case of forgery. Opinion on the basis of the said Xerox copy of Exhibit P6. Moreover, any such expert opinion or scientific report may not be a sole and substantive evidence to decide the issue in this case. It may be one of the corroborative piece of evidence. Well, what was sent to the expert, that is the truth lab for opinion, examination and opinion, are 3 Xerox copies of the documents. And on the strength of those 3 Xerox copies of documents, not even the specimen signature, well, the opinion came to be given. And even otherwise, well, the expert having not been examined under section 245, the learned magistrate ought not to have placed reliance on the opinion that is marked through the complainant who has nothing to do with this. Now, straight away, let me invite my lords. I have many more points, but this is sufficient for me at this point of time, would be my respectful submission.
Yes, Abraham. Only these legal submissions.
One more minute.
Oh, no, yeah.
One more. In fact, the Supreme Court has come upon this truth lab heavily.
Truth labs.
Adallo refer madida. Untrustworthy, dishonest. Let me invite my lord's kind attention to first judgment of the Supreme Court, my lord. On the point, my lord, even in law college also we are taught, my lord, evidence means examination in chief, cross-examination and re-examination. And I invited my lord's kind attention to the finding given by the learned magistrate. Only examination in chief. No, I can't look into it. My predecessor in office has committed a serious.
Basic thing is, if something has to be considered for the purpose of discharge, it cannot be only on one side's evidence.
Well, that is what the Supreme Court has said.
That is what I know.
Straight away, let me invite your lordship and attention to the judgment of the Supreme Court, 2013.
In fact, in this criminal petition 11172, your lordship.
No, it's senior counsel is only on legal submissions.
I was just making a submission.
Let him finish.
They have not, they've given me an incomplete.
Let him finish.
Incomplete petition.
All right, we'll see.
That's okay. Have not been given.
Incomplete petition. This matbad. Incomplete petition.
ಅಲ್ಲ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಏನು illegal issue ಇಲ್ಲ ಬರೀ ಆರ್ಡರ್ ನಲ್ಲಿ and judgment
Order ಗೊತ್ತಾಯ್ತು.
ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಏನು ಇಲ್ಲ
What I had to do was
I'll
look
come
at
back.
the list of
Let him-
documents
let him-
and I had to prepare the
You
remains.
want time, sir?
No, sir. it's okay.
You request the court and
Seniors have.
then why is that
Let
issue?
senior finish, wait.
If he wants time, let him take time. It is up to your lordship to grant him time or not to grant him time.
No.
I will not come in the way if the papers which I have
No,
given to him are
if
incomplete.
these
you
are the
furnish
two
the
legal
incomplete
issues.
Papers.
Like, these are the two legal issues to be answered.
Legal
Not
issues ಅಲ್ಲಿ ಆ papers
unless-
ಅಲ್ಲಿ ಇರಲ್ಲ.
You want time?
Legal issues.
No, to answer these legal issues,
Anything.
not on the merit of the matter,
No, no.
not on the
I
merit.
will.
Yes.
My Lord, may I
It's already answered, Your Lordship.
No, that is what is wrong is said.
No, I'm saying this court has already answered.
Then we'll see. Yes.
Why would I answer
All
it
right.
again?
But this is in 2013,
Ah.
Volume 9, Supreme Court Cases 209.
Paragraph.
May I request Your Lordship to kindly turn to paragraph 18 first and then go to 19. This was also a case of private complaint. Evidence recorded under section 244. As in this case, the trial court would also say it was only the examination in chief that would be looked into. Paragraph 18, internal page 218 of the judgment. My Lord gets it.
Yes.
Secondly, because the evidence under chapter 19B has to be recorded in the presence of the accused, and if a right of cross-examination was not available to him, he would be no more than an ideal spectator in the entire process. The whole object underlying recording of evidence under section 244 after the accused has appeared is to ensure that not only does the accused have the opportunity to hear the evidence adduced against him, but also to defend himself by cross-examining the witnesses with a view to showing that the witnesses is either unreliable or that a statement made by him does not have an evidentiary value or that it does not incriminate him. Section 245 of the code, as noticed earlier, empowers the magistrate to discharge the accused if, upon taking all the evidence referred to in section 244, he considers that no case against the accused has been made out, which may warrant his conviction. Whether or not a case is made out against him can be decided only when the accused is allowed to cross-examine the witnesses, but otherwise he may not be in a position to demonstrate that no case is made out against him and thereby claim a discharge under section 245 of the code. It is elementary that ultimate quest in any judicial determination is to arrive at the truth, which is not possible unless the deposition of witnesses goes through the fire of cross-examination. In a criminal case, using a statement of a witness of the trial without affording to the accused an opportunity to cross-examine tantamounts to condemning him unheard. Life and liberty of an individual recognized as the most valuable right cannot be jeopardized, leave alone taken away, without conceding to the accused the right to question those deposing against me from the witness box. Thirdly, because the right of cross-examination granted to an accused under section 244 to 246, even before framing of the charges, does not in the least cause any prejudice to the complainant or result in any failure of justice, while denial of such right is likely and indeed bound to prejudice the accused in his defense. The fact that after the court has found a case justifying framing of charges against the accused has a right to cross-examine the prosecution witnesses under section 246(4) does not necessarily mean that such a right cannot be conceded to the accused before the charges are framed or that Parliament intended to take away any such right at the pre-charge stage. But under section 246, the accused is again given a right. Already those witnesses who are examined under section 244, do you wish to recall them for the purpose of further cross-examination? The learned judge thinks under section 246, you get an opportunity of cross-examining the witness. Therefore, the cross-examination cannot be looked into. That is an assault on the statute, would be my respectful submission. But the second judgment, I think, I don't know whether I should be your lordship in any number of judgments are there of this court.
No, but page 183, annexure R11.
180?
183, annexure R11 of his objection. Same ground taken in criminal petition 5014 of 2022.
No, my lord.
Huh?
He was not even cross-examined.
No, come R11.
No, that was an opportunity was not given to cross-examine me was the criminal petition. That is Honorable Justice Sunil Dutt Yadav's order, my lord.
Discharge
Yes.
or on discharge.
It was not even cross-examined.
Not,
Not cross-examined. Then, my lord, the honorable court would remit the matter. And then after remittal, an application came to be filed seeking recall of PW1 for the purpose of cross-examination. That was granted. Then, my lord,
yes,
this finding comes into play.
yes.
And I was running it. My lord, may I request you, 183, my lord?
Ah.
Yes, have a look at this, my lord.
Yes.
My lord, this was again a legal issue, without even cross-examination of PW1. What the learned judge, for the purpose of proceeding to frame charge, did was, she would refer to the law laid down by the Supreme Court under section 227 and 239. 227 is a police report. 239 is also a police report. There, my lord, the cross-examination of witnesses will not be there. Here under chapter 19B, my lord, because it is a private complaint, the cross-examination will be there. That was a question which came to be raised. In fact, his lordship would write that. May I request your lordship find it, go to paragraph 5, my lord. There's only one page.
Is that a one short judgment? I've seen.
Yes. Therefore, his lordship would say, no, 227 judgments, you can't apply to this. It is a private complaint. It is only after that order of directing framing of charges came to be set at naught by the High Court, by this court, in this criminal petition 5014, we would make an application because it was not cross-examined on that day, at that time. Then, my lord, the court would allow that application. I was permitted to cross-examine the witness. That is PW1, the only witness is the complainant. Complainant was, his say was subject to the test of cross-examination. Thereafter, my lord, he was required to examine
Yes,
the
sir.
purpose of. Then, my lord,
ಇನ್ನೂ ಇದೆಯಾ?
ಬೇಕಾದಷ್ಟು
ಜಡ್ಮೆಂಟ್ಸ್ ಇದೆ.
ಅಲ್ಲ ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಎಕ್ಸ್ಪರ್ಟ್ ಇದೆ.
ಟ್ರೂತ್ ಲ್ಯಾಬ್ಸ್ ಗೊತ್ತು.
ಅಲ್ಲ ಟ್ರೂತ್ ಲ್ಯಾಬ್ಸ್ ಅಲ್ಲ. That is the barest, our High Court judgment, my lord. Therefore, it is invalid. You can't look into it at all. Is the law laid down by our High Court. But that is it. Otherwise, it defies elementary logic and common sense. But Xerox copies, keep it, print it, and take it and send it in the absence of original and all that. That can't be done. Even in another judgment, my lord, in what the Supreme Court has said, same thing. My lord, we saw this section 244, 245, and 246. In only one paragraph, my lord, I shall just read it and be done with it. This is in 2009, volume 14, Supreme Court cases 115. Only one paragraph. Kindly go to paragraph 51 at internal page 131 of the judgment.
This is followed.
That is followed in that judgment. But here, my lord, it is more elaborately is written. The right of cross-examination is a very salutary right, and the accused would have to be given an opportunity to cross-examine the witnesses who have been offered at this stage of section 244(1) of the CRPC. The accused can show by way of cross-examination that there is no justifiable ground against him for facing the trial, and for that purpose, the prosecution would have to offer some evidence. While interpreting this section, the prejudice likely to be caused to the accused in his losing an opportunity to show to the court that he is not liable to face the trial on account of there being no evidence against him cannot be ignored. Well, the learned judge does not even refer to it, and he says, no, I am not going to look into it at all. And he did not. He did not look into it. But as far as expert evidence is concerned, can't be looked into.
Yes, sir.
Well, these are the two important serious legal issues. If my lord is persuaded to accept my submissions,
Then
my lord,
I will go into the merits.
then if
If
my
I'm
lord does not accept my submissions, my lord, then your lordship may permit me to take your lordship to the merits of the matter. Because the learned trial judge does not even refer to one sentence in cross-examination. Not even one sentence.
No, according to him, it is wrong.
No, according to him, it is not necessary.
Not
His
necessary.
predecessor committed a sin. His predecessor committed a wrong. You ought not to have permitted me to cross-examine the witness.
Yes, sir. Only on those 2 points.
Your Lordship,
244,
primarily,
245.
the issue that was raised in 5015, I had submitted a chart the other day, a comparison chart
Yes, it's here.
between 11172 and the previous criminal petition 5014.
Yes.
The grounds, 3 facts cut and paste. Now,
Same thing.
the
501.
only, now to cut short the, my submission, I would straightway take this court to, what is the order of this court in
501.
501?
4. Yes.
The learned senior counsel would surely convince his court, if it is otherwise, that he had not put forth all these contentions before this court in 5014.
They were pleaded.
Yes. And it was addressed, it has been addressed by the court also.
Yes. I am
Now-
at page 185.
It's not in the compilation of
Not in
their
the compilation.
compilation. I have it with me.
Allah, R11 is that order.
R11 ಇಲ್ಲ ಇರೋ ನನ್ನ ಹತ್ರ ಇವ್ರು
ಇಲ್ಲೇನ್ R11 ಮತ್ತೆ ಇದು
ಇವ್ರು ಕೊಟ್ಟಿರೋದ್ರಲ್ಲಿ unfortunately this happens.
ನಿಮ್ಮ ಅಬ್ಜೆಕ್ಷನ್ ಅಬ್ರಾಮ್, ನಿಮ್ಮ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ R11 ಅಲ್ಲಿ ಇದೆ.
Yes, Your Honor.
ಅದನ್ನೇ ಹೇಳಿದ್ವಿ.
5014.
Page 183.
I would like this court to glance through page 160, Your Honor. It is their petition, 5014. What is their prayer, Your Lordship? Can they point out to this court where it was different from this petition, Your Lordship? What is the difference between this petition and the other petition that was dealt by this court? A reasonable order has been passed. The only problem was in criminal petition, the other day when I made my submission, I did make a submission that as far as the discharge application was being heard, it was Mr. Suman who was the senior counsel who represented the, I brought that to the notice of this court. At the conclusion of that submission, I offered to the court, if it is required, I don't mind giving citations because it is similar. I gave the court a chart, write-up, which was very convincing, which is not necessary for you to. Mr. Suman agreed that it is on the same principles, more or less. It doesn't matter. But unfortunately, he's not here, and senior came and he exercised his right to question it. He has questioned it, and it has been answered by this court. What does this court say? What is the final order of this court? Let me lead this court to the finding. At page 189, Your Lordship, the trial court in paragraph 10 has proceeded on the premise of the test and standard under section 227, which is qualitatively different as regards to the test to be answered under section 245. It would not be appropriate to enter into the merits of the case, because the merits of the case was presented in that case also, Your Honor. As the matter is being remanded for fresh consideration, it would also be necessary to observe that after disposal of the application under 245, the court, while proceeding to frame charges, must also apply its mind to the stage of 246, and an order in that regard be passed. Accordingly, the impugned order sent. Have they pointed out in the impugned order one thing that the trial court judge has not done, other than making an allegation that the trial court judge has not applied his mind? He has several times non-application of mind, non-application of mind, non-application of mind. I don't understand what they're trying to tell this court. What are they trying to impress this court about the trial court judge? I have a feeling the petitioner wants to tell this court the trial court judge does not deserve to continue.
You make a submission.
Now,
On
this,
the merit, don't worry about what they're.
Yes, Your Lordship. On this, not a single word. What did this court ask? Go back. It is sent back, and it is directed the trial court, to pass an order accordingly. Accordingly, an order is passed. Prima facie is established. This truth lab has been discussed. Everything has been covered, and now they do not. I don't know on what ground they will continue to say this. With this chart is very demonstrative that the entire thing is a repetition of the previous case. Entire thing.
So according to you, The pleadings are in reputation. The court has already considered it
Considered it.
and passed an order. There is no warrant of interference
Nothing.
or
Nothing.
entertainment of repetitive submissions. That's all.
If
That's
the
your submission.
court permits me,
No, on the merit will
Okay.
not go.
I
If
would.
I don't agree with the senior counsel now,
Okay.
then we will pass orders on that and hear both of you on its merit.
Fine.
All right? Then.
If I'm given a little time on the merits, briefly, but when
last
the
time
senior
you have
counsel is
told.
there.
Now-
No, Your Lordship.
Since these are legal.
Document wise, I will lead this court.
Definitely, I will hear that in the event I don't accept this
Obliged.
245,
Obliged.
246 submission.
Obliged.
Heard the learned senior counsel, C.V. Nagesh, appearing for the petitioner, and T.J. Abraham, the respondent complainant in person. The learned senior counsel has projected procedural aberration at the hands of the concerned court in passing the impugned order, ignoring the rigor of section 244 and 245 of the CRPC. According to the learned senior counsel, the concerned court has misconstrued those provisions to mean that it would only be the examination in chief and not the cross-examination or other evidence that is let in at the time of consideration of an application under section 245 of the CRPC. The respondent in person takes this court through the earlier order passed by the coordinate bench in criminal petition 5014 of 2022, wherein these very grounds are urged is the submission. These very grounds are urged and those have been negatived, and the matter was remitted back to the hands of the concerned court to pass orders on a particular premise. The court, having passed orders, now cannot be, the impugned order cannot be found fault with is the submission of the respondent in person. Therefore, the threshold bar will have to be crossed to hear the matter on its merit. Therefore, hear the matter on its merit as to whether there is compliance with section 244 and 245 at the hands of the concerned court. Therefore, the matter is reserved only on that score. In the event the finding would go against the petitioner, then the matter would be heard on its merit. List will pronounce it next week.
Another
Next week, 3rd March.
Third one. Interim order.
We'll pronounce it on 3rd March in Bangalore. Yes.
Yes. There's another matter, connected matter.
Interim order may kindly be.
That will connected, ಏನು?
Another connected matter is there.
Same, ah?
ಅಲ್ಲಲ್ಲ 25197.
ಅದಿಲ್ಲ. ಅದಕ್ಕೂ ಇದಕ್ಕೂ ಸಂಬಂಧ ಇದೆಯಾ?
Same.
Same, ah?
Same.
ಅದು
I will get onto this.
ಹಂಗಾರೆ ಬರ್ಲಿ.
Okay.
Serial number ಬರ್ಲಿ. I'll just continue the list.
ಅಲ್ಲ ಅದರಲ್ಲೂ ಪ್ರಾಬ್ಲಮ್ ಸೇಮ್ ಅಂತಂದ್ರೆ ರಿಮಾಂಡ್ ಆಗ್ಬೇಕು ಅಂತ ಕಾಣುತ್ತೆ. ಯಾತಕ್ಕೆ ಅಂತಂದ್ರೆ MP MLA ಅಲ್ಲಿ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಮುಂದೆ
I concede. Lordship, right away.
It should go before the.
But I concede only to that extent. I concede only to that extent that it has to be remanded to the
court.
But
without
the issues raised by them needs to be answered.
No, if the court has no jurisdiction, how will I answer those issues and send it back? I will send it back to the appropriate court. Magistrate cannot, regular magistrate cannot.
But there's a very serious issue that I've raised in that, Your Lordship.
Let the court consider, let the appropriate court consider and take cognizance.
I'm reminding this court with absolute humility, the judgments that I had quoted about 12, which says any court can take cognizance of the crime committed within the court.
See, any court, as long as there is no designated special court.
No. Not that issue. A fraud committed on the court.
Fraud committed on the
Orders
court.
obtained by fraud.
If you are saying fraud committed on the court, it should be a document of custodial legis. Then that court only will have to complain. Now this, whatever cognizance now it is taken by the normal court, the regular magistrate would not apply to a designated court. It has to go back to that court. Same procedure will follow.
That I agree.
There are so many orders on that ground, sending it back to MP-MLA court.
That I'm not at all saying no, Your Lordship. Even otherwise, if it is the March 3rd, I would have gone and made an application before the court and said there is an issue raised. There is a lapse.
That will, 67 will close that then on that ground. We'll see. Al barli, 67 barli. Continue the list.
He said it is connected with that. I said that has nothing to do.
Allah, what I'm trying to say is the
ಅದು ಬಿಡಿ.
basic,
ಬಂದಾಗ ಹೇಳಿ.
basic
ಬಂದಾಗ ಹೇಳೋಣ ಬಿಡಿ.
basic facts are.
67 ಕರ್ದಾಗ ಹೇಳಿ.
ನಾನು ಹೇಳ್ತೀನಿ, ನೀವು ಹೇಳಿ.
Right. Yes, sir. Sorry.
ಪರವಾಗಿಲ್ಲ.
Bill number 56.
ಆಯ್ತು ರೀ.
Appearing for petitioner, my lord.
Extend ಆಯ್ತು.
The learned senior judgment which learned senior referred, Justice Lalit Melod that appeared for respondent opposed the fact that the accused cross-examination. So he also writes the judgment when he become say that
My lord, serial number 56, my lord.
ಏನು?
Appearing for petitioner, my lord.
ಆಮೇಲೆ
Arguing counsel has some inconvenience, my lord. Kindly matter be taken.
list on
March, my lord.
recall ಮಾಡಿದ್ದಾವೆ.
KPID Act has been invoked.
Multi-state cooperative society. Yes, list the matter on
March. Kindly
3rd March. Yes.
interim order extended, my lord.
7th March. Interim order subsisting will continue. Yes.
Grateful.
57. Hemant Kumar K.
My lord, I appear for petitioner, my lord. I humbly pray for 2 weeks' time, my lord.
ಯಾವುದು 50?
PCP and PCP and 50.
ಅದೇ PCP and DT, all these matters.
Yes.
ಏಳಕ್ಕೆ ಬರಲಿ.
Interim order may kindly be extended, my lord.
Wait.
All these matters, my lord, they have to challenge the PCR register. This is the registered crime. The crime attained its finality by filing a complaint.
ಅವತ್ತು ನೋಡೋಣ. 7th will keep you engaged there on 7th. List on 7th. Interim order subsisting will continue to the next date of hearing.
Grateful, my lord.
My lords, appearing for the petitioners in serial number 58, my lords. Lords, this is a complaint offense under the Forest Act, registered as against the director, my lords, without arraigning the company as an accused. My lords, last time it was recorded that it's a covered under the decision of this honorable court itself. My lords, the respondents have been given enough opportunities.
Solar
Forest
panels
offense,
have been
my lords.
installed.
Madhusudan,
By violating
Anita had a covered.
Anita Hada ಮತ್ತೆ Madhusudan also covered. Recent decision of the Supreme Court, my lords, Sanjay
one?
Dutt matter, my lord.
Which one?
Sanjay Dutt versus
Sanjay
my lords, the
Dutt.
Supreme. Yes, my lords. I have placed all of that on record, my lords, and also served them a copy. My lords, on the last
See,
date, last 2
20th
times.
we can list on 20th. Interim order
My
subsisting
lords.
will continue to the next date of hearing. Yes.
20th February, my lords.
20th next week, madam. Yes.
Yeah, grateful, my lords.
Satyanand BS.
Actually, doctors, my lord, there are direction issued to file an affidavit. They are present.
Where is the doctor?
Present. Both of them are present. Two doctors have issued certificate.
Yes, doctor. Available warrant ಕೊಟ್ಟು ಕರೆಸ್ಬೇಕಾ ನಿಮ್ಗೆ?
Yes.
Available warrant ಕೊಟ್ಟು ಕರೆಸ್ಬೇಕಾ? ಕನ್ನಡ ಬರಲ್ಲ ಅವ್ರಿಗೆ?
ಬರುತ್ತೆ ಸರ್, ಬರುತ್ತೆ, ಕನ್ನಡ ಬರುತ್ತೆ.
Available warrant ಕೊಟ್ಟು ಕರೆಸ್ಬೇಕಾ ನಿಮಗೆ?
ಇಲ್ಲ ಸರ್, ನನಗೆ 6ನೇ ತಾರೀಕು ಇಂಟಿಮೇಷನ್
ಮೈಕ್
6ನೇ ತಾರೀಕು ಇಂಟಿಮೇಷನ್, 5ನೇ ತಾರೀಕು ಇಂಟಿಮೇಷನ್ ಬಂತು ಸರ್. ನಂದು ಕಂಟಿನ್ಯೂಸ್ ಕ್ಯಾಶುಯಾಲಿಟಿ ಡ್ಯೂಟಿ ಇದ್ವು ಸರ್, 3 ಕ್ಯಾಶುಯಾಲಿಟಿ ಡ್ಯೂಟಿ ಇದ್ವು ಸರ್.
Correct. We will not disturb the doctors unless
Yes sir.
they don't obey the orders of the court.
Yes sir.
I had asked you to file an affidavit. ಅವಾಗಲೇ ಬರಕ್ ಹೇಳ್ತಾ ಇದ್ದೆ. I had asked you to file an affidavit.
ಫಸ್ಟ್ ಇಂಟಿಮೇಷನ್ ನನಗೆ ಬಂದಿದ್ದೆ 5ನೇ ತಾರೀಕು ಸರ್. 5ನೇ ತಾರೀಕು ಬರ್ತಿದ್ದಾಗನೇ ನನಗೆ ಆ ಟೈಮಲ್ಲಿ ಕ್ಯಾಶುಯಾಲಿಟಿ ಡ್ಯೂಟೀಸ್ 3 ಇದ್ವು ಸರ್. ಅದು ಮುಗಿಸ್ಕೊಂಡು ಈ ವಾರದಲ್ಲಿ ಕೊಟ್ಟು ಬನ್ನಿ ಅಂತ ನಮ್ಮ
ಯಾಕೆ ಕರೆಸಿದ್ದೀನಿ ಗೊತ್ತಾ ನಿಮ್ಗೆ?
ಎಸ್,
ಒಂದು ಆಕ್ಸಿಡೆಂಟ್ ಆಗುತ್ತೆ, ಸಾರಿ ಒಂದು ಅಸಾಲ್ಟ್ ಆಗುತ್ತೆ.
ಎಸ್ ಸರ್.
ಅಸಾಲ್ಟ್ ಅಲ್ಲಿ ಪ್ರೀವಿಯಸ್ ನೈಟ್
ಎಸ್,
ನೀವು ಕೊಟ್ಟಿರೋ ರಿಪೋರ್ಟ್ ಪ್ರೀವಿಯಸ್ ನೈಟ್ ಏನೂ ಇಲ್ಲ ಅಂತ ಬರೆದಿದೆ ಆ ಡಾಕ್ಟರ್. ದಟ್ ಮೇಡಮ್ 12 hours ಅಲ್ಲಿ he travels from ಎಲ್ಲಿಂದ ಎಲ್ಲಿಗಿದು?
ಹಿರಿಯೂರಿಂದ.
ನೀವು ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದು ಮೇಡಮ್?
ಭದ್ರಾವತಿಯಿಂದ.
ಭದ್ರಾವತಿಯಲ್ಲಿ.
ಭದ್ರಾವತಿ.
11:20 AM. So 11:20 AM, madam gives a certificate, no injuries on the body. He comes to Davanagere from Bhadravati. Next morning, you give
evenings.
ಆಯ್ತು, next evening, you give a certificate, body ತುಂಬಾ injuries ಇದೆ.
Yes.
ದಾರಿಲಿ ಬರ್ತಾ ಆಯ್ತಾ?
ಸರ್
How did you give that certificate?
ಸರ್ ನನಗೆ ಪೊಲೀಸು ಪೊಲೀಸ್ನ ಒಂದು ಇಂಟಿಮೇಷನ್ ಲೆಟರ್ ಕಳಿಸಿದ್ರು ಸರ್. ಇವ್ರ ಬಗ್ಗೆ ಚಿಕಿತ್ಸೆ ಪರಿಶೀಲನೆ ಮಾಡಿ ಇವರಿಗೆ ಚಿಕಿತ್ಸಾ ವರದಿ ಕೊಡಿ ಅಂತಂದೇಳಿ ಕೊಟ್ಟರು ಸರ್. ಅದರಲ್ಲಿ ಆ ಪ್ರಕಾರ ನಾನು ನೋಡಿದಾಗ ಸರ್
ಪೇಷಂಟ್ ನೋಡಿದ್ರೆ ಸುಮ್ಮನೆ ಕೊಟ್ರ?
ನೋಡಿದ್ದೀನಿ ಸರ್. ಅದೇ ಥರನೇ
ಪೊಲೀಸ್ ಯಾವ ಥರ ಹೇಳಿದ್ರೆ ಆ ಥರ ಕೊಟ್ರಾ?
ಇಲ್ಲ ಸರ್, ಅದೇ ಥರನೇ ಬೇರೆ ಸ್ಪೆಷಲಿಸ್ಟ್ ಥರನೂ ನೋಡಿದ್ದಾರೆ ಸರ್. ಆರ್ಥೋ ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ಲೂ ನೋಡಿದ್ದಾರೆ ಸರ್, ಸರ್ಜರಿ ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ಲೂ ನೋಡಿದ್ದಾರೆ ಸರ್, ENT ವಿಭಾಗದವರು ನೋಡಿದ್ದಾರೆ ಸರ್.
ಇಲ್ಲ, 12 hours ಅಲ್ಲಿ ಅಸಾಲ್ಟ್ ಮುಂಚೆ ಅಸಾಲ್ಟ್ ಆದ ಟೈಮಲ್ಲಿ ಇಲ್ಲದೆ ಇರೋ ಇಂಜುರಿ ನಿಮಗೆ ದಾವಣಗೆರೆಗೆ ಬಂದ ತಕ್ಷಣ ಹೆಂಗಾಯ್ತು
ಸರ್?
ದಾರಿಲಿ ಬರ್ತಾ ಬಸ್ಸಲ್ಲಿ ಆಯ್ತಾ
ಸರ್ ಅದ್ರ ಬಗ್ಗೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಸರ್.
ಅದ್ರ ಬಗ್ಗೆ ನಿಮಗೆ ಗೊತ್ತಿಲ್ಲ ಅಂದ್ರೆ
ಸರ್
we will direct an inquiry to be conducted.
ಸರ್ ನನ್ನ ಹತ್ರ ಬಂದಾಗ ಯಾವುದೇ ಇನ್ಫಾರ್ಮೇಶನ್ ಕೊಟ್ಟಿಲ್ಲ ಸರ್. ಅವರು ಇಲ್ಲಿ ಚೆಕ್ ಮಾಡಿದ್ರು, ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡಿಸ್ಕೊಂಡ್ ಬಂದಿದ್ದೀವಿ ಅನ್ನೋ ಇನ್ಫಾರ್ಮೇಶನ್.
Doctor, it is simple. Both of you are doctors.
Yes sir.
Assault ಆದ ತಕ್ಷಣ the complainant alleging that he has been assaulted goes to a hospital where madam is the specialist.
Yes sir.
She examines.
Yes sir.
0 injuries on the body.
Yes sir.
That is the wound certificate given.
Yes sir.
You examine within 12 hours
Yes.
and say body full injuries.
Yes.
How is this possible? For the asking you have given the certificate, they are setting criminal law into motion. You should be very careful when giving the certificates.
Yes sir.
How did you give that certificate?
ಸರ್ ನನ್ನ ಹತ್ರ ಬಂದಾಗ ಈ ಇಂಜುರೀಸ್ಗಳು ಇದ್ವು ಸರ್.
ಇದ್ವಾ?
ಹ್ಞೂ ಸರ್.
X-ray also they have taken.
What X-ray, Jagdish? How can injuries happen when there were no injuries at the time of assault? Between Bhadravati and Davangere, injuries ಎಲ್ಲ ಮಾಡ್ಕೊಂಡು ಹೋಗಿದಾರ ಅವರು?
Either the complainant has manipulated or doctor has manipulated. Somebody has manipulated.
Complainant has manipulated or doctor has manipulated.
Sir.
So we will hold an inquiry.
Yes.
We will direct ಯಾವ ಹಾಸ್ಪಿಟಲ್ ನಿಮ್ದು?
ಚಿಗಟೇರಿ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಹಾಸ್ಪಿಟಲ್.
ಚಿಗಟೇರಿ
ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಹಾಸ್ಪಿಟಲ್ ದಾವಣಗೆರೆ.
Oh, so a government servant.
Yes.
All right. We'll direct an inquiry to be conducted as to how he issued a certificate of full of injuries on the body. Other than grievous in nature. Grievous in nature injuries when 12 hours ago there was nothing. Assault has not happened in those 12 hours. Assault admele complainant goes to the hospital, district hospital at Bhadravati. General Hospital Bhadravati.
Yes.
Depicts no injuries. So you have manipulated?
ಸರ್ ನನ್ನಂಗೆನೆ ಬೇರೆ ತಜ್ಞರು ನೋಡಿದ್ದಾರೆ ಸರ್. ಅದೇ ಟೈಮಲ್ಲಿ ಬೇರೆ ತಜ್ಞರು ನೋಡಿದ್ದಾರೆ ಸರ್. ಆರ್ಥೋ ನಂದು ಒಬ್ಬಂದೇ ಒಪಿನಿಯನ್ ಅಲ್ಲ ಸರ್, ಬೇರೆ ತಜ್ಞರು ನೋಡಿದ್ದಾರೆ ಸರ್. ಆರ್ಥೋದವರು ನೋಡಿದ್ದಾರೆ, ಸರ್ಜರಿ ಡಾಕ್ಟರ್ ನೋಡಿದ್ದಾರೆ ಸರ್, ENT ತಜ್ಞರು ನೋಡಿದ್ದಾರೆ ಸರ್, ಈವನ್ ಎಕ್ಸ್ರೇ ರೇಡಿಯಾಲಜಿಸ್ಟ್ ಹತ್ರನೂ ನೋಡಿದ್ದಾರೆ ಸರ್. ಅವ್ರದ್ದೆಲ್ಲ ಒಪಿನಿಯನ್ ಆಧರಿಸಿ ನಾನು ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಆಯ್ತು, ಎನ್ಕ್ವೈರಿ ಆಗಲಿ. Let an inquiry be conducted. Who is the competent authority? Who is your disciplinary authority?
Who is your disciplinary authority?
ಸರ್ ಸೂಪರ್ಡೆಂಟ್ ಸರ್. ಡಾಕ್ಟರ್ ನನಗೆ ಕಂಟ್ರೋಲಿಂಗ್ ಅಥಾರಿಟಿ ಸೂಪರ್ಡೆಂಟ್.
Superintendent?
Yes.
Superintendent of
Chigateri.
no, we will not allow that man to hold departmental inquiry. We will direct departmental inquiry to be held by someone else. This should not be done. ಕೇಳಿದ್ದಕ್ಕೆಲ್ಲ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡಬಾರ್ದು. Complainants or the police asking, you can't do that. This is precisely why I asked you to file an affidavit and come before the court.
Yes. ಸರ್ ಈ ವರದಿ ಬೇರೆ ವೈದ್ಯರು ನೋಡಿದ್ದಾರೆ ಸರ್. ಆ ವೈದ್ಯರು ನೋಡಿ ಅವರು ಆ ವೈದ್ಯರು ಕೊಟ್ಟಿರೋ ರಿಪೋರ್ಟ್ ಅನ್ನು ಆಧರಿಸಿ ನಾನು ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್.
ಅದು ಏನು ನೇಸಲ್ ಬೋನ್ ಫ್ರಾಕ್ಚರ್?
He should have at least given a.
ಅಲ್ಲ, ನೇಸಲ್ ಬೋನ್ ಫ್ರಾಕ್ಚರ್, ಆಮೇಲೆ ಕೀಲು ಮೂಳೆ ಯುನೈಟೆಡ್ ಭಾಗದ ಸೋನ್ಸ್ ಅವ್ರು ನೋಡಿ ಅವ್ರದೊಂದು ಫ್ರಾಕ್ಚರ್.
At least should have given age of injuries.
ಅದು ಇಲ್ಲ.
ಅದಿಲ್ಲ.
And when have you examined? When have you given the certificate? ನೀವು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟರೆ ಯಾವತ್ತು ಗೊತ್ತಲ್ಲ?
ಸರ್ಟಿಫಿಕೇಟ್ 22/5.
ನೀವು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದು ಯಾವತ್ತು?
ಸರ್ 14/4/23.
14/4. ಯಾಕೆ 1.5 ತಿಂಗಳಾದ್ಮೇಲೆ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ರಿ?
ಸರ್ ಪೊಲೀಸ್ ರಿಕ್ವಿಸಿಷನ್ಸ್ 24ನೇ ತಾರೀಕು.
Why did you not render a wound certificate on the same day, 13/4/2023, when you examined it?
ಸರ್ ಪೊಲೀಸ್ನ ರಿಕ್ವಿಸಿಷನ್ ಕೊಟ್ಮೇಲೆ ಅದಕ್ಕೆ ಅವ್ರದ್ದು
ಏನೇನ್ ಬೇಕೆಲ್ಲ ಹಾಕ್ಬಿಟ್ಟು ಕೊಟ್ಟಿಲ್ಲ.
ಇಲ್ಲ ಸರ್, ಅವರು ಎಲ್ಲ ಟ್ರೀಟ್ಮೆಂಟ್ ಕಂಪ್ಲೀಟ್ ಇದ್ರದ್ದು ಎಲ್ಲ ರಿಪೋರ್ಟ್ಸ್ ನ ಒದಗಿಸ್ತಾರೆ ಸರ್. OPD ಬೇಸಿಸ್ ಅಲ್ಲಿ ಹೋಗಿದ್ದ ಅಂತಂದ್ರೆ ಆ ರಿಪೋರ್ಟ್ ಕೊಟ್ಟ ಮೇಲೆ ಅದ್ರ ಆಧಾರದ ಮೇಲೆ ಅದು ನೋಡಿ.
ಸೊ ಆನ್ 14th ನೀವು ಯಾವ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡ್ಲಿಲ್ಲ?
ಇಲ್ಲ ಸರ್, ಅವತ್ತಿನ ದಿನ ಯಾರು
22/5 ಕೊಟ್ರಿ,
ಸರ್.
40 ದಿನ ಆದ್ಮೇಲೆ.
ಪೊಲೀಸ್ನವ್ರು ಯಾವಾಗ ರಿಕ್ವಿಷನ್ ಕೇಳ್ತಾರೆ ಸರ್, ಅವಾಗ ನಾವು ಸರ್ಟಿಫಿಕೇಟ್ ಇಶ್ಯೂ
ಅಲ್ಲ,
ಮಾಡಲ್ಲ.
ಕಂಪ್ಲೇನೆಂಟ್ ಏನು ತಗೊಂಡೋಗ್ಲಿಲ್ಲ ಅವಾಗ.
ಸರ್
ಕಂಪ್ಲೇನೆಂಟ್ ಏನು ಸರ್ಟಿಫಿಕೇಟ್ ತಗೊಂಡೋಗ್ಲಿಲ್ಲ. ನೀವು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದಾಗ ಕಂಪ್ಲೇನೆಂಟ್ ನೀವೇನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡ್ಲಿಲ್ಲ.
ಇಶ್ಯೂ ಮಾಡಿಲ್ಲ ಸರ್ ಅದು ಸರ್ಟಿಫಿಕೇಟ್.
ಆಯ್ತು, 40 days ಆದ್ಮೇಲೆ ಏನ್ ವೂಂಡ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ರಿ?
ಅಲ್ಲ ಸರ್, ಅವಾಗ ಬರ್ದಿದೆ ಸರ್.
ಏಜ್ ಆಫ್ ದಿ ವೂಂಡ್ ಏನ್ ಹೇಳಿದ್ರಿ?
ಸರ್ ಏಜ್ ಆಫ್ ವೂಂಡ್ ಬರ್ದಿರಲಿಲ್ಲ ಸರ್. ಎರಡು ಇಲ್ಲ ಸರ್.
ಫಸ್ಟ್ ಟೈಮ್ ಬರಿತಾ ಇದ್ದಾರೆ ವೂಂಡ್ ಸರ್ಟಿಫಿಕೇಟ್ ನ?
ಇಲ್ಲ.
It is fresh in nature. It appears it is dried up. It must be this many days old. Why?
Yes, come after 2 days. No inquiry about whether he has taken treatment in other hospital.
Yes.
ಸರ್ ನನಗೆ ಪೊಲೀಸರಿಂದ ಒಂದು ರಿಕ್ವಿಷನ್.
ಪೊಲೀಸ್ ಏನ್ ಹೇಳಿದಾರೆ ಅದು ಕೊಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ.
ಇಲ್ಲ
ಭದ್ರಾವತಿಲಿ ಆಗ್ಲಿಲ್ಲ ಅವ್ರಿಗೆ ಕೆಲಸ, ಅದಕ್ಕೆ ದಾವಣಗೆರೆಗೆ ಬಂದು ಏನ್ ಬೇಕಾದ್ರೆ ಕೊಡ್ತಾರೆ. You will be in soup. Highly incorrect. And you have examined madam on the previous day. You ನೋಡಿದ್ರಿ ಎಲ್ಲ ಇಬ್ಬರದ್ದು ಅಫಿಡವಿಟ್ ಇದೆಯಾ? nasal bone fracture, fracture, ಎಲ್ಲ fracture.
Inquiry should be done on both because inquiry should be done on both because otherwise he will blame on her and she will blame on him.
Inquiry will be done. Will pass appropriate orders. This court on 30th January 2025 directed available warrant to be issued to secure the presence affidavits to pass the following order. On 6/2/2025, when the doctors had not filed their affidavit, had passed the following order. Available warrants were directed to be issued to secure the presence of the doctor. The doctors are present today. The doctors, namely so-and-so, are present today. They have filed affidavits and have filed their respective affidavits. The affidavits are taken on record. Further orders would be passed. We'll pass an order. Yes, madam.
On 6th, I was not intimated about this, sir. The first intimation I got was on 10th.
I am not saying on that because court ಹೇಳಿದ್ರು ಬರಲಿಲ್ಲ ಅಂದ್ರೆ
ನನಗೆ ಬಂದಿಲ್ಲ ಸರ್.
ಏನಕ್ಕೆ ಬಂದಿಲ್ಲ?
And I have one kind usually when the patient is presented to us, we examine and write it in the MLC book, sir. The wound certificate is issued only when the police come with a requisition or if the victim comes with a requisition to get a wound certificate, sir. And the aging of the wound is written on the day of examination. ಏನಿತ್ತು ನಾವು ಬರ್ದಿದ್ವಲ್ಲ ಅದೇ ಕೊಡೋದು ಸರ್.
ಅದು ರಿಜಿಸ್ಟರ್ ಇದೆ ಇರತ್ರ?
ಅದಷ್ಟೇ ಸರ್.
ಇಲ್ಲ, ಅದು ನಿಮ್ಮ ಹತ್ರ ಇದೆ. ನೀವು ನೋಡಿದಾಗ ಇದೆ, ಅಲ್ಲಿ ಏನೂ ಇಲ್ಲ.
ಏನೂ ಇಲ್ಲ ಸರ್.
ನೆಕ್ಸ್ಟ್ ಡೇ ಅವ್ರು ನೋಡಿದಾಗ ಎಲ್ಲ ಇದೆ. Will pass necessary orders. The presence is noted and their presence in future is dispensed.
Make one request, my lords.
We continue to Tahir.
One request, my lords.
Lord, there is a matter at 2:30, my lord. It is in Gulbarga list. It's an MP MLA matter. Lord, because FIR was submitted to the the Raichur District Court, it is now categorized as MP MLA. ಅಲ್ಲ, ಅದನ್ನ ಇದ್ರ ರೀಕ್ಯಾಟಗರೈಸ್ ಮಾಡಿ ಇದ್ರ ಜೊತೆ ಇಂಟಿಗ್ರೇಟ್ ಮಾಡಿ ಲಿಸ್ಟ್ ಜೊತೆ ಮೇ ಬಿ ಟ್ರಾನ್ಸ್ಫರ್ ಟು MP MLA ಕೋರ್ಟ್.
We'll do it, don't worry.
Lord, serial number 69, my lord.
Serial number
69.
What?
69, my lord. 69.
One submission, my lord. Serial number.
Arnan's case idralli whether committee has.
Wait, sir.
ASG ಪೇರ್ ಆಗ್ತಾರೆ, ಒಂದು ಡೇಟ್ ಬೇಕಿತ್ತು.
ಕರೆದಾಗ ಕೇಳಿ.
ಆಯ್ತು.
Lordship, may I make one humble submission, Lordship?
Tahir. Review petition.
Lordship, maybe because of my conduct, Lordship, some delay is happening. I was
Hey,
ready to
no,
seek
no,
apology for all
never,
that.
never think
Because
that
Lordship, they
because
are
of
there in the jail from past 4 years, Lordship.
because of
For
the
that
delay
reason
they-
only, I'm troubling this court,
No,
Lordship.
no,
And
don't do that.
every now and
Don't think that way. Yeah, then ವಾರದಲ್ಲಿ ಮಾಡ್ತೀನಿ. Yes.
With your Lordship's kind permission, Nenne Santosh Hospital matter to Sumi. In the first instance when it was called, I appeared and made submissions, but I think there was some technical glitch. I, in fact, with the doctor and the laboratory,
You filed your objections.
I filed my objections.
We'll
In fact, there was some observation made telling that deep discounts were given. The discounts that we had conveyed deep discounts to the police
That's
officers.
okay. Don't worry about that. I am not on that. I want to lay down some guidelines. That's all.
Yes.
Yes.
Much older. I'm sorry for whatever, in the sense there was some technical glitch because of which I could not appear. Much older.
Yes, Prasanth Kumar. ಬೆಂಗಳೂರಲ್ಲಿ ಇದ್ರ ಈಗ ಬಂದ್ರ
ಬೆಳಗ್ಗೆನೆ ಬಂದೆ ಅದು ಒಂದು ಮ್ಯಾಟರ್ ಅಪಿಯರ್ ಆಗು ಅಂದ್ರೆ ಅಲ್ಲಿ ಅಪಿಯರ್ ಆಗಿ ಬಂದೆ
2:30
ಪ್ಲೀಸ್
we have finished half the list.
Please.
Remaining ಯಾವ್ದು notes ಮಾಡಿ
60
2:30 ಲಂಚ್ ಹೋಗ್ಬೋದು ತಾನೆ
ಹೆದರಿಕೆ ಆಗ್ಬಿಡುತ್ತೆ
ಲಂಚ್ ಹೋಗ್ಬೋದಲ್ವಾ ಎಸ್
ಯಾಕಂದ್ರೆ 2:30 ಅಂತ ಹೇಳಿದ್ರೆ ಇವರು 4:05 ಗಂಟೆ ಆಗ್ಬಿಟ್ರೆ
ಎಲ್ಲಿ ಫ್ಲೈಟ್ ತಗೋಬೇಕಾ ವಾಪಸ್
ನಿಮ್ದೆ ಫಸ್ಟ್ ಇದೆ
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್
ಎಸ್ ಸರ್
ಸೀರಿಯಲ್ ನಂಬರ್ 61 ಅಡ್ಜನ್ ಆಗಿದೆ ಮೇಡಮ್
ಇಲ್ಲ ಸರ್ ಆಗಿಲ್ಲ
ಮೇಡಮ್ ಆಫ್ಟರ್ ಇದೇ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಾ ಧಾರವಾಡ ಬೆಂಗಳೂರು ಬೆಂಚ್ ಮ್ಯಾಟರ್ಸ್
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್
ಹೇಳಿ
ಅದು ಸೀರಿಯಲ್ ನಂಬರ್ 52 ಇತ್ತು
50
ಸೀರಿಯಲ್ ನಂಬರ್ 52
52 ಸರ್ 52 ಲಿಸ್ಟ್
ನೆಟ್ವರ್ಕ್ ಕನೆಕ್ಟ್ ಆಗ್ಲಿಲ್ಲ ರೀಚಾರ್ಜ್ ಆಗ್ಲಿಲ್ಲ
ಅದಕ್ಕೆ
ಎಷ್ಟು ಮೇಡಮ್
20th ಫೆಬ್ರವರಿ
20 ನಾ
ಕೋರ್ಟ್ ಆಫೀಸರ್ 58 ನಲ್ಲಿ ಮೂರು ಮ್ಯಾಟರ್ಸ್ ಐಒ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಮೂರು ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲಿ 58
ಓಕೆ ಓಕೆ ಮೇಡಮ್
ಥ್ಯಾಂಕ್ ಯು ಮ್ಯಾಮ್
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕಾಲ್ಬುರ್ಗಿ ಬೆಂಚ್ ಮ್ಯಾಟರ್ಸ್ ಯಾವಾಗ ತೊಗೊಳ್ಳೋದು ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕಾಲ್ಬುರ್ಗಿ ಬೆಂಚ್ ಮ್ಯಾಟರ್ಸ್ ಯಾವಾಗ ತೊಗೊಳ್ಳೋದು
ಸರ್
ಮೇಡಮ್ ಆಫ್ಟರ್ ಲಂಚ್ ಬೆಂಗಳೂರು ಬೆಂಚ್ ಮ್ಯಾಟರ್ಸ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಾ
ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೀವಿ ಮೇಡಮ್
ಸಾರಿ ಮೇಡಮ್ ಇನ್ನೇನ್ರಿ
2:30 ಗೆ ಬೆಂಗಳೂರು ಮ್ಯಾಟರ್ಗೆ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೀವಿ
ಓಕೆ ಥ್ಯಾಂಕ್ ಯು
ಮೇಡಮ್ ಬೆಂಗಳೂರು ಮ್ಯಾಟರ್ಸ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಾ ಆಫ್ಟರ್ನೂನ್
ಹೌದು ಸರ್
ಸೀರಿಯಲ್ ನಂಬರ್ 76
ಎಸ್ ಸರ್ ಮಧ್ಯಾಹ್ನ 2:30 ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ
ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್
Court officer.
ಸರ್ ಹೇಳಿ ಸರ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಎಷ್ಟನೇ ಸೀರಿಯಲ್ ನಂಬರ್ ನಡೀತಾ ಇದೆ?
ಸೀರಿಯಲ್ ನಂಬರ್ 60 ಕಮೆಂಟ್ಸ್ ಮಾಡ್ಬೇಕು
ಹಲೋ
ಸರ್. 59 ವರೆಗೂ ಆಗಿದೆ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕಲಬುರ್ಗಿ ಬೆಂಚ್ ಇಂದ
ಮೇಡಮ್ ಹೇಳಿ.
ಇದು ಮ್ಯಾಟ್ರ್ 10:30 ಅಂತ ಇತ್ತು, ಆಯ್ತಾ ವಿಸಿದು?
ಯಾವ್ದು ಮೇಡಮ್?
ಬಿಫೋರ್ ಜಸ್ಟಿಸ್ ನಾಗಪ್ರಸನ್ನ ವಿಸಿ ಮ್ಯಾಟರ್.
ಕಲಬುರ್ಗಿ ಬೆಂಚಾ ಮೇಡಮ್?
ಹೌದು.
ಕಲಬುರ್ಗಿ ಬೆಂಚ್ 2:30 ಮೇಡಮ್, 10:30 ಅಲ್ಲ.
ಬಟ್ ಇವಾಗ ಅದ್ರಲ್ಲಿ 10:30 ಅಂತ ಮೆನ್ಷನ್ ಇದೆ. ಆಯ್ತಾ, ಅದು ಕರೆದಿಲ್ಲ ಅಲ್ವಾ ಇನ್ನು?
2:30 ಅಂತಿದೆ, 2:30ಗೆ ಕರಿತೀವಿ ಮೇಡಮ್.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
Audio is muted.
Serial number 6, my lord, your lordship, the adjourned for 7-3.
Which one?
Serial number 6. By taking stay order of this matter, the Prajwal Revana matter, they are asking for taking time. Your lordship may have it next week, my lord. And
All right. ಅದು ಅಶೋಕ್ ಅನಳ್ಳಿ ಸರ್ ಹೇಳ್ಬಿಡ್ಬೇಕು.
I'll inform.
20th.
20th.
List on 20th. ರವಿಗೆ ಹೇಳಿದೆ.
My lord, serial number 66, my lords.
66.
Yes, my lord. That PMLA matters. This may be taken up on 7th in bed.
Yes, all right.
Interim order to continue.
That will continue.
My lords, I appear for petitioner in 66.1, my lords. Both the matter interim order.
We'll see. Yes. 230 matter.
Further hearing matter, serial number 81, Praveen C, Chaitanya SG.
Investigating officer is present.
He's present, ma'am. He's present, ma'am.
Yes. What's your name? Huh? ಕೋರ್ಟ್ ಆರ್ಡರ್ ಕಮ್ಯುನಿಕೇಟ್ ಆಗಿಲ್ವಾ ನಿಮ್ಗೆ?
ಇಲ್ಲ ಸ್ವಾಮಿ.
ಇಲ್ವಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ.
ಯಾಕೆ ಕಮ್ಯುನಿಕೇಟ್ ಆಗಿಲ್ವಾ?
We have communicated, my lord. I have inquired with my office. They have communicated.
ಒಂದ್ಸರಿ ಅಲ್ಲ 2 ಸರಿ ಹೇಳಿದೀನಿ ಡಿಫ್ರೀಸ್ ಮಾಡ್ಬೇಕು ಅಂತ. ವೈ ಹ್ಯಾವ್ ನಾಟ್ ಡನ್?
ಎರಡನೇ ಸಲ ಮಾಡಿದೀವಿ ಸ್ವಾಮಿ.
ಡಿಫ್ರೀಸ್ ಆಗಿದೆಯಾ ಈಗ? What is this?
Submission.
Huh?
ಇಲ್ಲ ನಾನು ದಾಖಲಾತಿ ಇದೆ ಸ್ವಾಮಿ. ಬ್ಯಾಂಕಿಗೆ ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ ಡಿಫ್ರೀಸ್ ಮಾಡಕ್ಕೆ. 31ಕ್ಕೆ ಆದೇಶ ಆಗಿದೆ ಸ್ವಾಮಿ. 1-2ಕ್ಕೆ ಡಿಫ್ರೀಸ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ ಬ್ಯಾಂಕ್ ಗಳಿಗೆ.
31ಕ್ಕಲ್ಲ ಆದೇಶ ಆಗಿರೋದು. ಆದೇಶ ಡಿಫ್ರೀಸ್ಮೆಂಟ್ ಗೆ ಯಾವಾಗಿಂದ ಆಗ್ತಾ ಇದೆ ಗೊತ್ತಾ? We will direct DG and IG to hold an inquiry on this. 26/11/2024 ಫಸ್ಟ್ ಆರ್ಡರ್
ಆದೇಶ ಬಂತು.
ಆಯ್ತಾ? ಆಮೇಲೆ ನೀವು ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿಲ್ವಾ ಅವ್ರಿಗೆ? ಪ್ರವೀಣ್, ಇವಾಗ ನೀವು ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿಲ್ವಾ? ಟು ಹೂಮ್? ಆಮೇಲೆ ಮತ್ತೆ 12/12, ಆಮೇಲೆ 30/1/2025 3 ಸರಿ ಮಾಡಿದ್ರು. ಮಾಡದೇ ಇದ್ದಕ್ಕೆ ನಿಮ್ಗೆ ಬರಕ್ ಹೇಳಿದೆ.
31ಕ್ಕೆ ಮಾಡಿದ್ದಕ್ಕೆ ಕೋಟಿ
ಏನ್ ಮಾಡಿದ್ದೀರಾ ಈಗ?
ರಿಸೀವ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಸರ್.
ಯಾರು ರಿಸೀವ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ?
ಬ್ಯಾಂಕಿಗೆ ಮೇಲ್ ಹಾಕಿದ್ದೀವಿ.
ನೀವು ಫ್ರೀಸ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಫಾಲೋ ಅಪ್ ಮಾಡಿ ಫ್ರೀಸ್ ಮಾಡ್ತಿರಲ್ಲ, ಅದನ್ನ ಡಿಫ್ರೀಸ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಫಾಲೋ ಅಪ್ ಮಾಡಕ್ ಆಗಲ್ವಾ? ಕೋರ್ಟ್ ಆರ್ಡರ್ ಇದೆ ಅಂತ.
ಡಿಫ್ರೀಸ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಆಗಿದ್ಯಾ?
ರಮ್ಯಾ ಅವ್ರದ್ದು ಅಕೌಂಟ್ ಡಿಫ್ರೀಸ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಯಾರ್ದು?
ರಮ್ಯಾ ಅಂತ ಹೇಳಿ.
ಯಾರ್ದು ಅಕೌಂಟ್? ಪೆಟಿಷನರ್ಸ್ ಯಾರಿಲ್ಲಿ? 2, 3, 4 and 7 ಇವ್ರ ಅಕೌಂಟ್ ಯಾಕೆ ಡಿಫ್ರೀಸ್ ಆಗಿಲ್ಲ?
ನಮಗೆ ಆದೇಶ ಬಂದಿಲ್ಲ.
ಯಾರ ಆದೇಶ ಬಂದಿಲ್ಲ?
ಅಲ್ಲ, ಕಮ್ಯುನಿಕೇಟ್ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ ನಮಗೆ.
ಯಾವ ಕಮ್ಯುನಿಕೇಟ್ ಆಗ್ಬೇಕು? ಇಲ್ಲಿ ಯಾರು ಪೆಟಿಷನರ್ ಇದ್ದಾರೆ ಅವ್ರದ್ದು ಅಕೌಂಟ್ ಡಿಫ್ರೀಸ್ ಮಾಡಕ್ ಹೇಳಿದ್ ನಾನು. ಡೋಂಟ್ ಟ್ರೈ ಟು ಆಕ್ಟ್ ಸ್ಮಾರ್ಟ್.
We have communicated on 12/12/24.
Petitioner 3, Shankaregowda, Abhilash, Ravishankar. ಈ 3 ಜನದ ಅಕೌಂಟ್ ಫ್ರೀಸ್ ಮಾಡಿದ್ರೆ ಡಿಫ್ರೀಸ್ ಮಾಡಿ ಅಂತ 3 ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ಯಾರ್ದು ಅಕೌಂಟ್ ಡಿಫ್ರೀಸ್ ಮಾಡಿ? ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಇದಾರ ಇಲ್ಲಿ? ಡಿಫ್ರೀಸ್ ಯಾರ್ದು ಹೇಳಿದ್ ನಾನು?
31ಕ್ಕೆ ಒಂದು ಆದೇಶ ಬಂದಿದೆ ಸರ್.
ಹೌದು, 31ಕ್ಕೆ ಯಾರು ಪೆಟಿಷನರ್ ಯಾರಿದ್ರೆ ಅವ್ರದ್ದು. If you can't obey the orders of the court, we will make you obey.
ಆತರ ಇಲ್ಲ ಸರ್.
I will direct the DG and IG to hold an inquiry on this. There are 3 directions issued and you don't do it and you do somebody else's defreezing.
The communication ಆಗಿಲ್ಲ ಸ್ವಾಮಿ, ಪ್ರಾಮಿಸ್.
We have communicated and
Well, communication ಬಂದಿಲ್ಲ ಅಂತೀರಾ? Government, the additional SPP says communication has gone.
ನಾನು ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ. ನಾನು ವಾಟ್ಸ್ಆಪ್ ಅಲ್ಲಿ ಅವ್ರೇನು ಕಳಿಸಿದ್ರು.
ಅದ್ಯಾಕೆ ಡಿಫ್ರೀಸ್ ಮಾಡಿದ್ರಿ ರಮ್ಯಾ?
ಅದು ಬಂದಿತ್ತು ಸ್ವಾಮಿ, ಲೆಟರ್ ಬಂದಿತ್ತು.
Inquiry despite all this. They investigation. They hold an inquiry where they make a statement of the second respondent stating that I falsely lodged a complaint to extract money from my wife and I have compromised and they. Yaar complainant? They go before the coordinate bench of this court. They say we have compromised the matter where they say we have no objection to file. ಏನ್ನ ಕಾಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ? ಪಿಚ್ ಇದಾ?
ಇದಲ್ಲ sir, ಇದಲ್ಲ. First there was
Crime will pending ಇರ್ಬೇಕಾದ್ರೆ ಆ ಬೆಂಚ್ ಅಲ್ಲಿ ಹೆಂಗ್ ಮೂವ್ ಮಾಡಿದ್ರಿ ನೀವು?
ಈ ಕೇಸ್ ಅಲ್ಲ sir.
ಮತ್ತೆ
Prior to the lodging of this matter, one complaint had been lodged against his wife. She filed one writ petition before the Honorable High Court, and that came to be compromised, and ಅದರಲ್ಲಿ ಡಿಫ್ರೀಸ್ ಆಗ್ಬೇಕು ಅಂತಿದೆ, ಅದರದ್ದು ನೋಟಿಫಿಕೇಶನ್ ಇವ್ರಿಗೆ ಹೋಗಿದೆ ಸರ್. ಈ ಕೇಸಲ್ಲಿ ಡಿಫ್ರೀಸ್ ಆಗಿದೆ ಅನ್ನೋದು ಇದು.
There are 3 orders passed here. When will you defreeze it? ಏನದು?
Say a file, they claim before the court they do not do anything. 293 against A1 they have quashed. Everyone is connected in that.
ತುಮಕೂರು ಟೌನ್ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಪೊಲೀಸ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಯಾರು?
ನಾನು
ನೀವೇನಾ? ಈ ಕ್ರೈಮ್ ಬಗ್ಗೆ ಗೊತ್ತೇ ಇಲ್ವಾ ನಿಮಗೆ? ಈ ಪೆಟಿಷನ್ ಪೆಂಡಿಂಗ್ ಇರೋದು
ಅದು 31ಕ್ಕೆ ಆದೇಶ ಇದೆ ಸರ್.
31ಕ್ಕೆ ಆದೇಶ ಇಲ್ಲ. ಇದ್ರಲ್ಲಿ ಇದು ಡಿಫ್ರೀಸ್ ಮಾಡಿದಾರಾ?
30 ಮಾಡಿದ್ದೀವಿ.
ಯಾಕೆ ಕಾಂಪ್ರಮೈಸ್ ಆಯ್ತು ಅಂತ?
ಇಲ್ಲ ಸರ್,
ಮತ್ತೆ
ಆದೇಶ ಬಂದ ಸಮಯ ಮಾಡಿದ್ದೀವಿ.
ಈ ಆದೇಶ ಬಂದ ಮೇಲೆ ಮಾಡಿಲ್ಲ. ನಾನ್ ಮಾಡಿರೋ ಆದೇಶ ಬಂದ ಮೇಲೆ ಮಾಡಿಲ್ಲ.
ಅಲ್ಲ, ಅದು ಕಮ್ಯುನಿಕೇಟ್ ಆಗಿಲ್ಲ ಸರ್.
Let him file an affidavit, my lord.
ನೀವು
I'll ask
ಅಫಿಡವಿಟ್
my
ಹಾಕಿ
office to-
ಕಮ್ಯುನಿಕೇಟ್ ಆಗಿಲ್ಲ ಅಂತ.
I'll ask
I
my
will ask the
office to-
additional SPP also to file an affidavit. We will ask the DG, the IG hold an inquiry as to why the orders of this court are not being implemented. They are taken for granted. That can't happen at all. That can't happen. File an affidavit.
Let him file an affidavit. I'll ask my office to file an affidavit.
Your
According
office
to-
also shall file an affidavit. Communicate ಯಾವಾಗ ಆಯ್ತು?
Yes.
ಒಂದಲ್ಲ 3 ಆರ್ಡರ್ ಮಾಡಿ. ಎಸ್, ನಾಳೆ ಹಾಕ್ತೀರಾ? ಅಫಿಡವಿಟ್ ಹಾಕ್ತೀರಾ? ಡಿಫ್ರೀಸ್ ಮಾಡ್ತೀರಾ? ಅಫಿಡವಿಟ್ ಹಾಕ್ತೀರಾ?
ಡಿಫ್ರೀಸ್ ಮಾಡ್ತೀವಿ.
ಯಾರ್ದು?
ಇಲ್ಲಿ ಆದೇಶ ಏನಾಗುತ್ತೆ ಅದು ಮಾಡ್ತೀವಿ. ಈಗ ಆಗಿರೋ ಆದೇಶ
ಅಫಿಡವಿಟ್ ಹಾಕೋದು ಹಾಕಿ.
May I make a submission?
Yes, sir.
We don't have objections to allow this petition, my lord.
Allow the petition.
Reason is this.
Ah.
Although there is enough materials, my lord, the case which has been constructed by the prosecution, even if we prosecute it, is going to be an exercise in futility. Reason is, my lord, on the same offense, 2 FIRs have been lodged, my lord. In all fairness, I am submitting. So therefore, my lords, because our connected matter ಅಲ್ಲಿ wife jothe already we have noted to this court, even this petition may be allowed.
That we will see.
Yes.
ಯಾಕೆ ಅಲೋ ಮಾಡೋದು ಬೇಡವಾ? ಅಲೋ ಮಾಡೋದು ಬೇಡವಾ?
Not the way we want or he wants.
ಅಂದ್ರೆ you want the way to be allowed to be ಅದೇ ಬೇರೆ ರೀತಿ ಇದೆಯಾ?
Nothing happened. One of the petitioner in this case, petition inquiry is started. We take a statement from the accused and close it. Another inquiry is started against us. Then subsequently all these things, second FIR. In this they find nothing. In other words to be said, they could not make out anything out of it. Again, there is a stay by this honorable court. They conduct another inquiry that they say the husband and the wife have come. Why are the threats being dragged into the court? Is this not not tracked?
ಯಾಕೆ ಬೇಕಾಗಿದೆ? ಬೇರೆಯವ್ರು ಯಾಕೆ ಬೇಕು? You have a problem with your wife.
ಇಲ್ಲ, ಅದಕ್ಕೆ right now that is the reason why I submitted before this court that I don't have objection to allow this petition.
Now, how do you compensate for all the agony that they have undergone?
My lord, it's not that they have they have suffered, my lord, because of their because of the reason that the prosecution has not constructed this case properly, that the case cannot stand, my lord.
That's all right. Now, we'll do that.
Now, how is he connected to the crime? Without being arrested.
That we will observe. ಈಗ ನಾವು affidavit ಹಾಕ್ಲಿ.
Let his statement also be recorded.
That I will do.
I'll ask
Yes.
the DG also to
The,
DG to hold an
this
inquiry
court,
on that.
by an order dated so and so, had directed the investigating officer to be present before the court in the wake of the fact that despite 3 orders passed by this court, the investigating officer had refused to direct defreezement of the account of the petitioners which had been frozen pursuant to the crime being registered. The investigating officer puts up his defense that the order passed by this court was not communicated to him. The additional SPP submits that the office of the state public prosecutor had communicated the orders passed, every order passed to the investigating officer. Therefore, the investigating officer shall file his affidavit with regard to non-communication of the orders, and the office of the SPP with communication of the orders by the next date. The, ಈಗ ಯಾವಾಗ ಡಿಫ್ರೀಸ್ ಮಾಡ್ತೀರಾ?
ಇವತ್ತೇ ಮಾಡಿಸಿ.
ಇವತ್ತೇ ಮಾಡಿಸ್ತೀರಾ? ಆಗ್ಬೋದಲ್ಲ ಅದು? ಇಲ್ಲಿವರೆಗೆ ಯಾಕಾಗಿಲ್ಲ?
ಜೋಗಲು ಇಲ್ಲ ಸರ್. ಇಲ್ಲ ಸರ್, ಮಾತ್ರ ಏನು ನಮ್ಮ ಕಡೆಯಿಂದ ಯಾವುದೇ ಕೋರ್ಟ್ ಆದೇಶಗಳನ್ನು ಉಲ್ಲಂಘಿಸುವಷ್ಟು ತಪ್ಪಾಗಿಲ್ಲ ಸರ್. ತಪ್ಪು ಮಾಡಿಲ್ಲ ಸರ್.
ಎಸ್, ಅಫಿಡವಿಟ್ ಹಾಕಿ ಒಂದು ಡಿಫ್ರೀಸ್ ನಾಳೆ ಮಧ್ಯಾಹ್ನದೊಳಗೆ ಡಿಫ್ರೀಸ್ ಆಗಿರ್ಬೇಕು.
ಆಗಲಿ ಸರ್, ಆಗಲಿ ಸರ್.
ಎಸ್, ಆಗಿ ಅಡಿಷನಲ್ SPP ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಬೇಕು.
ಆಗಲಿ ಸರ್.
ಏನು ಡಿಫ್ರೀಸ್ ಮಾಡಿದ್ದೀನಿ ಅಂತ.
ಹೌದು ಸರ್.
Then your affidavit should be here that you have not received the orders and not communicated the orders.
ಹೌದು ಸರ್.
Then we will see what is to be done.
ಹೌದು ಸರ್.
ಗೊತ್ತಾಯ್ತಾ? Yes. Don't disobey the orders of the court. If I unleash the coercive arm of law, your service record will go then. Yes.
20th.
Next, 20th.
20th.
Grateful.
Yes, 20th will dispose the petition.
Grateful.
ಅಷ್ಟರೊಳಗೆ ನಾಳೆನೇ ಇನ್ಫಾರ್ಮೇಶನ್ ಹೋಗಿರ್ಬೇಕು ಡಿಫ್ರೀಸ್ಮೆಂಟ್. ಎಸ್, ಯು ಕ್ಯಾನ್ ಲೀವ್ ನೌ.
ವೈದ್ಯನಾಥ್.
ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ 7th ಇಂಟರ್ಮಾರ್ಟಲ್ Manjunath Prasad.
Appear for the respondent in this case.
Division petition.
In all these 8 cases, my lord,
ಕಟ್ಟಿಲ್ವ ದುಡ್ಡು?
they are arising out of the common set of facts.
ದುಡ್ಡು ಕಟ್ಟಿಲ್ಲ ತಾನೆ?
I have not been permitted.
ವಿಡ್ರಾ ಮಾಡಿ.
ಅಲ್ಲ, ನನಗೆ ಇದು ಬ್ಯಾಂಕ್ ಗ್ಯಾರಂಟಿ ಕೊಡಿ ಅಂತ ಹೇಳಿದೆ. It is as good as money.
ಬ್ಯಾಂಕ್ ಗ್ಯಾರಂಟಿ ಕೊಡಿ ಅಂತ ಯಾರು ಹೇಳಿದ್ದು?
ಅದು ಕೋರ್ಟ್ ಆರ್ಡರ್ ಮಾಡಿದೆ.
50% ಈಗ ಅಮೌಂಟ್.
Common set of facts are involved in all these 8 cases. Same transaction, single transaction. 7 checks have been issued, and all transactions have taken place through banking channels. Through banking channels, it has taken place.
ಹೇಳಿ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಇದೆ. ಅವ್ರ ಹತ್ರ ಎಲ್ಲಿತ್ತು ದುಡ್ಡು ಕೊಡಕ್ಕೆ? ಡೀಟೇಲ್ ಆಗಿ ಹೇಳ್ಬೇಕು.
Just I would like to request your lordship to see paragraph 18 and 19.
No,
of
that
the
I have
appellate
seen
court
last time
judgment.
also. Yes.
Appellate court judgment.
Admitted.
Yeah, everything is admitted.
liability.
Admitted liability.
ಯಾಕೆ ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡ್ರಿ?
Bank.
ಆಯ್ತು, 3ನೇ ತಾರೀಕು ಅಲ್ಲೇ ಹಾಕ್ತೀನಿ. ಅಲ್ಲೇ 7ನೇ ತಾರೀಕು ಹಾಕ್ಲಾ?
ಆಯ್ತು. Your lordship kindly direct the trial court to release the amount, at least on the basis.
To consider the amount, I will direct that. ಅಥವಾ 7ನೇ ತಾರೀಕು ತೀರ್ಮಾನ ಮಾಡ್ಬಿಡಿ. Yes, list on 7th March. No, ಮತ್
ಅಲ್ಲ, today, in fact, on the last date of hearing, your lordship said that today is the last day.
ಇದ್ದೀನಿ ಅಂತ ಅಷ್ಟೇ. ಅಲ್ಲಾದ್ರೆ ಇಟ್ಸ್ ಈಸಿಯರ್. ಇಲ್ಲಿ ನಾನೇ ಅಲ್ಲಿ ಬರ್ತೀನಿ ಸರ್, ನೀವೇನ್ ಬರ್ಬೇಡಿ. 7th March.
Much obliged.
List on 7th March.
Bill number 61, Prithvish MK. BB Patil.
Respondent to that.
For the petition. 7 or 13?
13 1 D, my lord.
7th intermodal subsisting will continue to the next date of hearing.
Very good.
For further hearing, yes.
62, Venkatesh R. Bhagat.
I am for the respondent in this case, my lord.
ಏನಿದು?
For the petitioners, my lord.
My lord, there is a payment of 3 crores which was agreed, 3 crore 5 lakh. Out of that, 2 crores has been paid, my lord. Another 1 crore 5 lakhs is due. And all these payments are supposed to be made in the month of November. But however, some difficulty or delay, the petitioner is making the payment. The last one installment is pending, my lord. I would request, my lord, the other.
My lord.
ಅಲ್ಲ ವೆಂಕಟೇಶ್, ನೀವೇ ಹೇಳ್ತೀರಿ ಯಾವಾಗ ಕೊಡ್ತೀರಾ ಅಂತ.
My lord, in this cancellation deed has to happen on the agreement to sale, my lord. By March 15, the
Madam, come up with the DD.
Yes, my lord. But
That
my
is what
lord,
I suggested.
Come up
my
with
other
the
side, my
DD. I
lord.
will direct what is to be done. ನೀವು ಸುಮ್ಮನೆ ಫೋಟೋ ತೋರಿಸ್ಬಿಟ್ಟೆಲ್ಲ ಮಾಡಬೇಡಿ.
No, my lord, 2 crores has been already cleared in this, my lord.
Last time 1 crore ಆಯ್ತು. Next ಇನ್ನು 1.5 ಕೋಟಿ ಇದೆಯಲ್ಲ.
1 crore 5 lakhs, my lord.
1 crore 5 lakhs, yes.
We have even drafted the cancellation agreement also, my lord.
Hold
It's in
the DD and come cancellation agreement, he will sign.
Yes, my lord. We any
My
day,
lord,
whenever
we-
they hand over the
we-
DD, we'll read.
listed in the March 15th, my lord, we will do the
No,
needful,
no,
my lord. I'll
I
convey
list it on March 7th.
My lord, may I make
Please,
one
madam.
submission? I appear for the
Please,
petition. 62.1 only, I am the petitioner.
Uh,
I have nothing to do with the settlement. I have nothing to do with the cancellation.
Don't
I
worry.
would request for
It
an
will have
order of
nothing to do
acquittal.
with the orders passed, yes.
But a warrant was issued against
Once
me.
the
That is
payment
what
is
I
paid,
am
entire
challenging.
proceedings are going to be passed against my learned friend.
1 minute. At the request of counsel Venkatesh Bhagat, list the matter on 7th March. The learned counsel submits that the draft of the cancellation deed is ready. And with the demand draft, the cancellation of the learned counsel for the respondent submits that the cancellation deed would be signed on the day on which the amount of 1 crore 5 lakhs would be cleared by the petitioner. In that light, list the matter on 7th March.
Interim order may be extended, my lord.
Interim order subsisting will continue till the next date of hearing.
Let them come with the DD
special-
on that day, my lord. There will be a direction.
ಅವತ್ತು ಬೇಕು ಅಂದ್ರೆ ಇಲ್ಲ interim order vacate ಮಾಡ್ಬಿಡ್ತೀನಿ ನಾನು. Yes.
My lord, in my case, I am only challenging the process, my lord. I am not party to the joint memo, but a warrant
stay
was issued
ಕೊಟ್ಟಿಲ್ವಾ?
against me. Stay there. I only want an observation if the matter
List
should
on,
be
list
disposed
on
of.
7th, interim order subsisting shall continue to the next date of hearing in both these cases. Next.
Right.
Yes, I appear for the petitioner.
Lord, 63.2, my lord, I appear for the petitioner. There's a matter where, my lord.
Justice Hemant Chandan Gowda order ಬಂತ ಅದು?
Yes, my
Yes, my lord, I have.
placed it on record, my lords.
Good.
Last time my lords had asked me to give the copy of it, my lords. I have given it.
The classification of the account as fraudulent has been set aside by the learned
Forensic
single.
audit report based on which the crime was registered is said to have been quashed. Allah, just declaration of fraud. That is the basis for the complaint here.
Yes.
Yes, my lord.
We have written to the bank, we have received an oral communication that they're reclassifying it and they're providing.
Reclassifying what?
Lots, the whole basis on which.
If you're reclassifying it, then redo this also.
Lots.
Oh,
Lots, it was on the basis of that opportunity was not given. Lots, may I
Well,
request a short?
Lord, the division bench of the Punjab High and Haryana High Court, my lord.
Very well.
On,
Lots.
may I make one submission, my lord?
one ನಿಮಿಷ ಜೋಡಿ ಸರ್ ಹೇಳಿ.
Lots, all I request is, lots, let me place that communication on record.
What communication?
Lots, we have written.
It is of no avail what communication,
we have
internal
not written-
communication you do between yourselves.
Lots, what has happened with the bank, the bank is not here, therefore I request.
Man, why should the bank be here?
Lots, the
Complainant here.
How the lots, they are the ones
Bank
who have
is the
classified.
complainant.
Yes, my lords. Bank is the
Complainant, bank is not a party here.
How the, but the genesis is stemming out of the bank.
Lords, bank is a party, my lords, but the entire, in my petition, my lords, that's at 63. Bank is a party.
ಇಲ್ಲೂ bank is a party, ಇಲ್ಲ ಅಂದವ್ರೆ.
Even in,
is a party, sir.
the bank is a
We have
party
written
there
to the
also.
bank, my lords. All I request is, my lord, let the communication come. My lord, they have a benefit of interim order. My lords, on the next date of
Lord,
hearing,
there
if
is a
there's no
final order
communication, I'll submit to
passed
the
by the
court.
coordinate bench.
If the very declaration of it to be a fraud has been quashed, based upon which the entire complaint has sprung, it will
Look, I
lose its legs to stand.
I
need not-
understand.
I need not tell you.
I understand that
Yes.
position, my lords. All I request is, my lords, on behalf of my side, let me place that communication on record.
What I'll take, even if that communication comes, if they're reclassifying it, that doesn't mean that I'll wait, oh, crime is there, they are going to reclassify. What happens to the order passed by the coordinate bench?
Look, that we have put it up in challenge. my
No,
lords.
that's a different thing, sir.
That's a
What happens to the order which has quashed the very declaration of fraud based upon which the complaint is
But the
registered?
entire thing, why it was quashed is, my lords,
Maybe
because of
natural
no-
justice, maybe anything, sir.
Look, they give liberty to reclassify that order.
As,
Lots,
sim-
all-
as simple as that, sir.
Very
As
well, I
simple-
understand that. Therefore, my lords, I request a
See, as
short-
simple as that, nothing. Ashte, that's the order.
Look,
Liberty-
we are also in
yes.
court.
Fact, my lord, the division bench of the Punjab and Haryana High Court, on the basis of the Supreme Court's order, my lord, has quashed the entire proceedings in other matters.
Exactly.
Very well.
This is like Vijay Madanlal Chaudhary
Allah,
saying,
ಗೊತ್ತಾಯ್ತು.
Now
Yes, my lords.
PMLA will continue even after predicate offense goes.
I'm not contending on merits.
Not contending, that's the purport of that is that.
I understand that position.
No,
Milords.
see, you have built your superstructure on the foundation of fraud. Foundation has gone where superstructure will tumble down.
That is the reason this
Then-
court granted interim order. Non request ಮಾಡ್ಕೊಂತ ಇದೆ.
My lord, more than 3 occasions, my lord, my friend has taken time. Let us, my lord.
ಅಲ್ಲ ಅವ್ರಿಗೆ
That's basic, sir.
ಅವ್ರಿಗೆ ಇವತ್ತಿಗೂ 7th ಗೆ ಏನಾಗಲ್ಲ. But I will be on a better
Oh,
footing.
no, nothing.
But I will be on a better footing.
Not
once I
necessary,
prepare.
sir. Quash ಆಗಿರೋದು ಹೌದಾ?
ಹೌದು ನಿಜಾನೆ.
That goes. Liberty here also I will give you. Liberty is granted there, liberty will be granted here. That's all the order. No, ನಿಮಗೂ ಇಲ್ಲ ಅವ್ರಿಗೂ. Same order. Yes. The ಇಬ್ರು ಇದ್ದೀರಾ ಸರ್ ಇದರಲ್ಲಿ? ಚೋಟಾ ಸರ್ and ಜೋಳಿ ಸರ್. Mahesh is there. Bipin.
Yes, my lord. I appear in 63.2, my lord.
ಅವ್ರು ಇಲ್ಲೆಲ್ಲ ಬರಲ್ಲ.
ಅಲ್ಲ ನಮ್ಗೆ ಒಂದೊಂದೇ ಮ್ಯಾಟ್ರು ಅಲ್ಲಿ ಚೌಟ್ರಿಗೆ 10 ಮ್ಯಾಟ್ರ್ ಇರುತ್ತೆ ದಿನ, ಅದಕ್ಕೆ ಬರಲ್ಲ.
Yes. The petitioner heard. I'll the operative portion ಮಾತ್ರ ಮಾಡ್ತಾರೆ. Reason same reason, that's all. Yes.
The judgment SBI Rajesh Agarwal is almost closing all the cases in CBI
What to
and
do?
bank sector.
What to do? ಮತ್ತೆ? That's just Chandrachud ಅವರು.
Yes.
Heard the earlier, that's what. Obviously, if you are declaring someone to be a fraud, it has serious civil and economic consequences. And without complying with principle of natural justice, how could you even declare it? That's too rudimentary, I guess. Heard the learned senior counsel, Kiran Javli appearing for ಯಾವುದ್ರಲ್ಲಿ sir ನೀವು? In 63.1, Bipin Hegde in 63, ಅಲ್ಲ sorry, Sandesh Chowta in 63.2. ನೀವು ಯಾವುದ್ರಲ್ಲಿ Bipin?
ಅಲ್ಲ, I am in 63.2.
That's I am in serial number 63, my lords.
Yes. Will pass the order. Dispose. ಅಷ್ಟೇ. ಆರ್ಡರ್ ಅದು ಜಸ್ಟಿಸ್ ಹೇಮಂತ್ ಅವ್ರದ್ದು ಆರ್ಡರ್ ಇಟ್ಟಿದ್ದೀರಾ? ಇದರಲ್ಲಿ ಹೌದು. ಅದೇ ಫಾಲೋಯಿಂಗ್ ರಾಜೇಶ್ ಅಗರ್ವಾಲ್.
Yes, my lords.
Yes.
Grateful, my lords.
Yes.
With my lord's leave, can I make a mention, my lord? Serial number 59, my lord, there was some VC problem, my lord, that's why, my lord,
What
I could
VC
not.
problem? Doctor had lot of problem. You are not there.
Please, my lord, I am really sorry for that, my lord.
YouTube ನೋಡ್ಕೊಳ್ಳಿ.
Please, my lord.
Yes.
Serial number 64, my lord. I am appealing for the respondent, my lord.
Yes, sir. ಇದರಲ್ಲಿ ಏನಿಲ್ಲ.
My lord, sorry, my lord.
Nothing. What remains, sir?
My lord, they have sought for the quashing of the, I request for a movement, my lord. Kindly take the prayer, my lord. Prayer in the first matter, my lord. 18668 of 2024. Page number 23 is the prayer, my lord.
Yes.
My lord, the first prayer what has been sought for is quashing of the ECIR. I will later I will come to that particular prayer, my lord. Prayer number B, my lord. Kindly see the prayer number B, my lord. Issue a writ of mandamus
Declaring
or other
proceeds
writ.
of crime traceable to original complaint, so and so.
This this PCR is not at all schedule offense.
Well, I'll give up all that.
Give up. You're giving up all the prayers except the first one.
Yes.
My lord, with respect of first prayer, my lord, I request my lords to kindly come back. The petition filed, my lord. 226 read with 482.
ಸರಿ ಅದಕ್ಕೆ
I request my lords to kindly take the. I have requested one of my colleagues to provide a list of authorities, my lord. My lord, the first 11 pages are the relevant portion of the Vijay Madan Lal Chaudhary, my lord. I will come back to Vijay Madan Lal Chaudhary later, my lord.
All right.
The page number
Hmm.
16, my lord. Page number 16. This is division bench judgment of the Madras High Court, my lord.
Hmm.
And then, my lord, after considering the Vijay Madan Lal Chaudhary, my lord, thereafter one more judgment of the another High Court, my lord. The division bench of Madras High Court has come to a conclusion that ECIR is an internal document. It is only an administrative act, and it cannot be quashed under section 482 of the CRPC. Para number 10, my lord, page number 18.
Oh, then how it should be quashed?
No, my submission is that, my lord,
Yeah,
any
question
action.
ಮಾಡಕ್ಕಾಗಲ್ಲ.
No. My submission is like this, my lord.
Hmm.
If pursuant to the pursuant to registration of ECIR, any action has been taken under section 66(2), or
That
if
is
a summons has been issued.
information to other agencies.
Yes, my lord. In such an event, my lord, ECIR cannot be quashed. Any other proceedings, my lord, which is such as.
That's right. Last time you told me,
Yes,
since
ma'am.
information is given to other agencies, if the other agencies are taking action, they
Yes,
would
my lord.
require this ECIR to be in existence.
Yes.
That's your
And
submission.
that is the purport of Vijay Madan Lal Chaudhary, my lord. Now I request my lords to kindly take Vijay Madan Lal Chaudhary, my lord. Relevant portion what I have produced along with my compilation. Page number 2, my lord. Para number 282.
Page?
Page number 2 of the compilation, my lord. Para number 282.
Para
My lord, I have
282.
not produced the entire judgment, my lord.
Other 400 pages.
Yes, my lord. I request my lords to kindly take a 6th line, my lord, from the para number top, my lord, 6th line. It starts
Yes.
like this. It is possible that
Yes.
in a given case, after the discovery of huge volume of undisclosed property, the authorized officer may be advised to send the information to the jurisdictional police under section 66(2) of the CR 2002 Act for registration of a schedule offense contemporaneously, including for other investigation in pending cases, if any. On receipt of such information, the jurisdictional police would be obliged to register or as a non-cognizable offense, as the case may be. If the offense so reported is a schedule offense, only that eventuality the property recoverable by the authorized officer would partake the color of proceeds of crime under section 21U of 2002 Act, enabling him to take further action under the Act in that regard. My lord, the Act is not only to punish, it is also prevent the money laundering act. In such an event, my lord, this ECR cannot be quashed because it is an administrative action. Now, I request my lords to kindly take the discussion regarding the ECR vis-a-vis FIR, my lord. I request my lords to kindly take page number 6 of the same compilation, my lord. My lord, at para number 456, my lord, FIR is registered under section 154.
Right.
The effect of FIR with reference to section 157 and other provisions have been discussed in para number 456, and which empowers this honorable court to quash that FIR. Whereas, my lord, in the next paragraph 457, my lord, it is not registered under the section 154 of CRPC. ECIR is not registered under section 154 of CRPC. ECIR, for the administrative purpose, it is registered. Para number 457, there is a discussion, my lord. Page number 7.
Yes.
Then, my lord, in para number 457, from bottom 7 or 8 line, my lord, it starts like this, my lord. There is a force in the stand taken by, from 7 or 8 line, my lord. If my lord's able to identify that particular sentence. Yes, there is a force in the stand taken by the ED that ECIR is an internal document created by the department before initiating penal action or prosecution against the person involved with the process or activity connected with the proceedings of crime. Thus, ECIR is not a statutory document. Nor there any provision in requiring the authority referred to in section so-and-so to record ECR or furnish a copy thereof to the accused, unlike section 154 of the code. The fact that such ECR has not been recorded does not come in the way of the authorities referred to in section 48 of the Act to commence inquiry investigation for initiating civil action of attachment of property being proceeds of crime by following the prescribed procedure in that regard. My lord, my submission is that, my lord, what I'm trying to explain is that, my lord, if the schedule offense is quashed, and in spite of the quashing of the schedule offense, if I have tried to arrest a particular person, it is null and void. It is illegal. If I am trying to attach any property as a proceeds of crime with reference to schedule offense, it is bad. Whereas, even if the schedule offense, the person is discharged or schedule offense proceedings is quashed or whatever, if the proceedings is obliterated, I can issue the summons. I request my lords to kindly take the judgment, my lords. That is the recent Supreme Court judgment. That is Willie Camo judgment, page number 12, my lord.
ಇದಾದ್ಮೇಲೆ ಒಂದಿದೆ by the same bench.
Sorry, my lord. I
ಇದಾದ್ಮೇಲೆ
will.
ಇನ್ನೊಂದಿದೆ same
Yes.
identical. Yes.
Yes, my lord. The question before the Supreme Court was that, my lord, the only issue for consideration is as whether the High Court is justified in quashing the summons on the premise that the respondent has been discharged in the predicate offense. We also know that in the said order was passed by taking into consideration the submission made on behalf of the appellant, wherein it was stated that the proceedings against the respondent may be closed. We are limiting ourselves to the question of law. What has been issued to the respondent is merely a summons, simply because he has been discharged in the predicate offense.
Yes,
A court cannot quash the summons.
I've seen this.
Yes, ma'am.
ಆಮೇಲೆ yes Madhukar.
Proceedings as well as criminal of a complaint before the adjudicating authority. Another one is filing of a complaint under section 44 and 45, arresting and all those things. My submission is that, my lord, the ECIR, since it is an administrative action, it is an internal document, it has to remain as it is, my lord. And my submission is that, my lord, it is if it remains as it is not at all going to affect the interest of the petitioner, because the object of the legislation to prevent further money laundering, and there should not be any such type of activity. For that reason, my lord, since we have shared the information, in my statement of objection, I have explained what all the information with whom all we have shared. And this is a very serious type of a case, my lord, where we have shared the information with respect of a cash payment amounting to 42.07 crores. That is one information which we have shared. There is another transaction, my lord, where 6,96,000 US dollar, which is a foreign investment which has been made. Shared the information with appropriate authority. And there are so many Benami transactions. With respect of that also, we have shared the information. Now, if my lords take back the same compilation, my lord, which my lords are holding, the similar question was before the Madras High Court, my lord, which I have referred to, my lord, whether the quashing has to take place, whether ECIR has to be quashed, that was the question. Then, my lord, the same question was also before the Chandigarh High Court, my lord, page number 20, my lord. The ECIR sought to be quashed, my lord. Then, my lord, the submission was also made before the Punjab and Haryana High Court that schedule offense is the basis and there is a discharge. That particular submission, my lords can see at page number 20. Thereafter, my lord, the Punjab Haryana High Court, single judge, at page number 23, para number 6, which continues at page number 23, as well as para number 7, the Punjab Haryana High Court has come to a conclusion that it is an administrative action, it is an internal document, and it cannot be quashed at page number 7, my lord. Similarly, my lord, the High Court of Orissa also has taken the similar view, my lord, that I have produced at page number 25.
Yes.
My submission is that, my lord, the relief what has been sought for with respect of quashing of ECIR, it has a, it will affect other investigation, or other information which we have shared, and the ECIR is not required to be quashed. As nowhere he has been affected now. And we have, it is not his case that we have attached any of his property. It is not his case. It is not his case that we are attempting to arrest him. And that is not the allegation. and they deliberately they want the ECR to be quashed so that all other action has to be stopped, which is not the purport of this particular legislation.
Yes, sir.
Please notice paragraph 467, my lord, clause D.
Vijay Madan Lal.
My lord, it clearly says that pending inquiry and trial, my lord, notional basis or on assumption that a scheduled offense has been committed. Notional basis, no. My lord, if the offense is quashed, my lord, or acquitted, then there is no offense at all. They cannot initiate action. It cannot be continued.
No, that's what the other courts have now interpreted, that it can continue.
Well, the other courts are where matters are pending. Punjab and Higher Court matters are pending.
ಇಲ್ಲ the Supreme Court order discharge ಆಗಿದೆ ಅದು. Discharge ಆದ್ಮೇಲೆ summons issue ಮಾಡಿದ್ದಾರೆ. ಅದನ್ನ Supreme Court says now.
My lord, your lordship may notice what the in Vijay Mohanlal also, my lord, at the paragraph which my learned friend read at 282, my lord. There also, my lord, clearly they say, if your lordship were to notice last couple of lines, my lord, on receipt of such information, jurisdictional police would be obliged to register a case if it is a cognizable or non-cognizable offense. No such thing has happened here. It is not, they have in fact passed on the information to the tax authorities and the EC. They will take action. Liberty may be reserved.
For action to be taken by those authorities, if there is no foundation is the ECIR. If that goes, action cannot be taken, is what he's saying.
Well, limitation, well, the problem would be if the entire material, my lord, is foreclosed. No, it is not. It is open. It revives under section 66(2). It continues, my lord. They can take action. The liberty is reserved under the section, provision itself. Therefore, they can take action. Those authorities under those enactments.
Oh, you are saying
did not.
With or without an ECIR, they can take action?
Yes, my lord, they can take action. That liberty may be reserved also. That is what the section says. That is the section contemplation. That is the reason why I'm saying that ECIR need not be required, because entire proceedings have been come to an end. Predicate offense is no longer there.
So that I'm aware.
Yes,
It's
my
my
lord.
order.
Yes, my lord. That's the reason, my lord.
Predicate offense is my order and Supreme Court confirms it.
Yes, my lord.
That we'll see, but this needs an
But
answer.
there are
What-
two other judgments of two high courts, my lord, which on
No,
the
that
issue-
is quash ಆದ್ಮೇಲೆ ಇರಲ್ಲ ಅಂತ.
Yes,
Again,
my
what is
lord.
what,
Yes.
what effect?
One is Delhi High Court, my lord.
Prakash Industries, yes.
Yes. So both are Delhi High Court.
The Delhi name, Prakash Industries, I am aware. So you are giving up the other prayers, except the first
Yes,
one.
yes, ma'am.
Yes, Madhukar will pass orders, yes.
Please.
Heard the learned senior counsel M.V. Sheshachala appearing for the petitioner and counsel Madhukar Deshpande representing the respondent. Learned counsel M.V. Sheshachala gives up all the other prayers except the first one, i.e. quashment of the ECIR. ECIR. The same submission is placed on record, reserved,
Please.
because this needs an answer.
65, Rajat?
65, my lord, 65 and 65.2. Charge sheet has been filed.
65
and 65.2.
Shantakumar Swami.
Charge sheet has been filed. Challenge the FIR. Charge sheet has been filed.
Challenge Madi. Charge sheet.
My lord, one submission, my lord. Sorry, my lord. One
Yeah, Madhukar.
submission. My lord, there is one particular matter which has been tagged with this matter, my lord. That is Sanchaya Land and Estate Private Limited.
ಅದಕ್ಕೆ
That is
ಸಂಬಂಧ
the
ಇಲ್ವಾ?
no, my lord. That is 64
My
group.
lord, it's
that-
72, my lord. Serial number
sorry.
serial number 71 for the petitioner.
It's
So
70
here also the
71,
predict 71, my lords.
No, one moment. Why are you mentioning 71? Wait.
Sorry, my lord. Sorry.
Learned senior mentioned.
Sorry, my lord. I
70.
mentioned, I was under the impression that it is part of the 64 itself.
No, no,
Sorry,
no,
my
no. Yes, yes. 65. Shantakumar Swami. Rajat. ಮೂರಲ್ಲೂ ಹಾಕಿದ್ದೀರಾ?
ಒಂದರಲ್ಲಿ challenge the charge sheet, 65.1 ಈ challenge the charge sheet. In ಎರಡರಲ್ಲಿ FIR challenge ಮಾಡಿದ್ರು. Charge sheet has been filed now.
65 and 65.2.
Yes, madam.
Challenge the charge sheet. Anyways, madam. 65 and 65.2. What is called in question is the registration of the crime. The petitioner, registration, learned additional SPP submits that submits that pursuant to the investigation, charge sheet is filed against the petitioner. Therefore, the learned counsel of the petitioner would seek leave of this court to withdraw the petition and file a fresh petition raising a challenge to the charge sheet. Liberty so sought is granted, petition is disposed as withdrawn, reserving the aforesaid liberty. 65.1 matra, list on 7th for further hearing. Yes. Next.
66,
7th March, yes.
67, SB Matpati.
66 interim order may be.
Interim order will continue, sir.
Please, please.
67.
Lordship, I have a small submission to make on this. Yes, it is true that the jurisdiction has been raised. In this context, I would draw the attention of this court to page 152, Your Honor. This is
152.
152 in my objections, Your Honor. 152. This is
In your objections.
Yes, Your Honor.
One moment.
This is a criminal petition filed by them. 201541/21.
1 minute. 152,
150, page 152. The order, I would draw the attention of this court to this particular portion. 162, Your Honor, at page 162. Para 9. The petitioners have challenged the order of the trial court before the honorable court, before this honorable court in criminal petition so-and-so, wherein it is dismissed with some observations. In the meanwhile, the criminal case number so-and-so in the trial court B there was transferred to the special court Bangalore. This aspect is known to them, and now I'm passing on a comparative statement, Your Lordship.
No,
Between
Abraham, it's not the issue.
No.
Mere knowledge
In
is not,
2021.
any amount of consent will not confer jurisdiction on any court.
I concede. I'm drawing the attention of this court to this fact that in 2021 October, they did not have a gross. Did they know about it? Yes, they knew, because there was another matter which was transferred to Bangalore. This matter, they preferred it to be there because they were already playing with the police, preparing police to, I would say, preparing the police. I'm with absolute confidence and conviction, I'm making the statement with responsibility that they will get a B report from the police, which has been the normal course from beginning for the last 10, 12 years. Every time a complaint is filed, they get a B report. In anticipation of that, they did not invoke this. Now they've invoked. And between this petition 201541 and this petition, Your Lordship, this comparative chart shows it's ditto, same. Same, cut and paste. So you did not have a grouse about the jurisdiction. Now you have a grouse. I concede. I fully agree. Your Lordship, if I'm trying to press on the orders obtained by fraud. This court has already made an observation. If that observation can be made, that please, Your Lordship, I'm looking for that small
thing is, while answering a particular issue, if I digress and go somewhere, it becomes wrong, not correct.
Okay.
We'll pass
out of my anxiety, I asked about it, but it's right. What the court says.
Pass orders on the same day with regard to jurisdiction. Sorry. Same. Reserve
no, it can be actually.
That I will do. Now I have no time to write. We'll do it.
Right.
No time to write. Yes, ಬೆಳಿಗ್ಗೆ ಒಂದು ರಿಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ, ಅದ್ರ ಜೊತೆಗೆ ಇದನ್ನ ಮಾಡ್ಬಿಡಿ. ಬೆಳಿಗ್ಗೆ ರಿಸರ್ವ್ ಮಾಡಿದ್ದೀನಲ್ಲ. ಅವ್ರು ಇನ್ನೊಂದ್ಸರಿ ಕೇಳಿದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಲ್ಲ ನಾನು. Yes.
Obliged.
Yes, sir.
For 68, Satish ke?
Satish,
68, I am for the respondent number 2, my lordship.
ಏನ್ ಸೆಟ್ಲ್ ಆಗಿಲ್ವಾ?
Not at my lordship.
List on 7th. Yes.
Much obliged, my lordship.
Interim order subsisting will continue for further hearing. Interim order subsisting will continue to the next date of hearing. Next.
69, Krishnapan N.
Lords, I represent respondent number 1 to 3, my lords, in this case.
ಇದೇನು?
Plus wiretapping.
Wiretapping.
Yes, sir.
Lords, ASG has been briefed, my lords, may I seek for short accommodation in this case.
1 minute, sir. 1 minute.
They have the benefit of interim order, my lords.
That's because he knew Tamil. That's the case, right? He translated what is to be done in Tamil, so offense against him. Yes, nimda CBI.
Allah, my lords, the question is, my lords, whether review order has been
Review
passed.
committee has passed an order of.
Review committee ಆಗಿದೆಯಾ?
Agide.
Review committee place ಮಾಡಿ, then we will consider it on its merit.
Yes, I have produced along with my
Passed a-
statement of.
Passed a detailed order.
Following Mannan's case.
Mannan's, what happened to Mannan?
Mannan is challenged, my lords, yet to come up. At DOPT ಹೋಗಿ ಬರೋಷ್ಟೊಳಗಡೆ.
Mannan's case. Ashad Narwadi Mannan. Yes. List on 7th March, Bangalore.
Please.
List on 7th March, at the request of the request of the council S. Rajshekhar to comply with the earlier orders.
Lords, I have filed statement of objections along with the review committee's, my lords, report.
ಮತ್ತೆ ಯಾಕೆ ಟೈಮ್ ಬೇಕು?
ಅದು ASG appear ಆಗ್ತಾರೆ ಇದ್ರಲ್ಲಿ.
ಯಾರು ಅರವಿಂದ್ ಕಾಮತ್ ಸರ್ ಎಲ್ಲಿದೆ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕೇ ಇಲ್ಲ ಏನು?
ಹಾಕಿದ್ದೀನಿ ನಾನು. I have filed it on 24th
ಕಾಪಿನೂ ಕೊಟ್ಟಿಲ್ಲ ಅವ್ರಿಗೆ?
28th January ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ.
Mannan's case ಒಳಗೆ. ಯಾರು DOPT ಹಾಕಿರೋದ? ಯಾರು ಗವರ್ಮೆಂಟ್ ಹಾಕಿರೋದು?
ಗವರ್ಮೆಂಟ್ ಹಾಕಿರೋದು.
ಎಸ್, ನಿಮ್ದೇನಿಲ್ಲ ಬಿಡಿ ಅವ್ರದ್ದು. List the matter on 7th. The registry is direct. Why? Why time? List on 7th at 2:30 PM for further hearing. At the request of the council, S. Rajshekhar would, request Learned Council, CGC, S. Rajshekhar.
Please.
Interim.
Number 70.
I was appearing for the petition in this case, matters. I pay for short accommodation in this matter.
Nursing ನಡೀತಾ ಇದೆಯಾ?
Please, my lords.
7th again.
Interim order 2.
That will continue. Interim order ಯಾವ್ದು ಬಿಡ್ಬೇಡಿ. Next.
71, B. Vaishak.
Please, my lords. Because in this, my lords,
Lord, in this case, I appear for the respondents, my lord. I request this matter to be listed and taken up on 20th, my lord. Physically, you will be present, my lord.
that is the only objection they have raised it, that they have asked.
Solve, why are in a hurry? Interim order ಇದೆಯಲ್ಲ. We'll take it on 7th.
Please.
20th, my lord. Physically, we will be present.
I will come physically there, sir. On
Oh,
7th,
bless.
yes. List on 7th. Interim order subsisting will continue till the next date.
Much okay.
72, Sanjeevini.
My lords, appearing for the petitioner, my lords, I seek for a short accommodation, my lords.
We will vacate the interim order then.
My lords, we wanted to be present physically, my lords, due to a personal inconvenience. We weren't able to come today, my lords. My lords, we have it on 20th, my lords, as a last chance.
I appear for respondent number 2, my lords.
Yes.
This case.
Observation and interim order as confirmed by Supreme Court.
Interim
No, not that. No, that observation about reference hearing police officer.
175 Supreme Court has written it now. Yes.
My lords, the last one, 20th, my lords, will address your lordships physically.
20th ಇರ್ತೀರಾ? Because Supreme covered, close mouth. List on 20th.
Grateful, ma'am.
Yes.
73, Sunil S. Narayan.
Appear for petition in this case, short accommodation, my lordship.
ಎಲ್ಲ short accommodation. Is not special court dalla.
Allah, sir.
14th, for further hearing, entry order subsisting will continue to the next date of hearing. Next.
74,
My lords, pray for short accommodation in this matter. Same.
order.
75.
Much obliged.
For the petitioner in this matter, my lord, it's listed for awaiting service of notice on respondent number
Post
2.
immediately after service of notice upon the second respondent.
Please, my lord.
Interim order
Great.
subsisting will continue to the next date of hearing.
Please.
Anand,
Court wants to know
My
what's
lord.
the offense. Arun Sham sir.
Yes, my lord. My lord,
Ah,
there is some objection, my lord, that has been complied in fact.
adu paravailla. Now court wants to know
Yes, my lord.
what's the offense.
But,
Against Arnab Goswami, adike.
ಹೌದು.
Yes.
Cannot fight.
ಏನು ಇಲ್ಲ. Absolutely nothing. Abuse on its face. Yes. Yes, Arun Sham sir. Allowed quashed. Hello there.
I'm grateful,
Wants
but
to know
I'm
Antaksham.
the briefing.
Wants to
I'm
know.
appearing.
Is he getting information?
I think he must have dropped off, my lord. I will inform him, my lord.
Yes, yes.
I'm grateful, my lord.
Allowed quashed, yes.
Grateful.
77, Sunil Kumar.
Ah, ಎಲ್ಲಿ ಎಲ್ಲರೂ ಇದ್ದೀರಾ? Where is Prasanna Kumar?
ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಪಕ್ಕ
ಎಲ್ಲಿ?
ಪಕ್ಕದ ಕೋಟಲ್ಲಿ.
ಹಾ. ನೀವು ಏನ್ ಈ ಕಡೆ ಇದ್ದೀರಾ ಈ ಸರಿ?
ನಾವು ಅವ್ರ ಜೊತೆಲಿ ಇದ್ವಿ, ಈಗ ಈ ಕಡೆ
Yes, sir.
What happened to my notes?
You will.
Final hearing.
Final hearing.
78.
ಅದು appeals ಯಾವ್ದು ತಗೊಳ್ಳಿ? ಎಲ್ಲ appeals ಎಲ್ಲ 14th. From 78 on 78 to 80.
ಎಲ್ಲೋಗ್ಬಿಟ್ಟು
ಅಲ್ಲ ಅದು ಎರಡೇ 78, 79. Jagdish sir. 78, 79 will be 14th of March.
Yes.
80
I make
ಯಾವ್ದು?
a request, my lord.
80 is criminal petition. Wait.
May I make a request, my lord, if lordship?
Gulbarga.
There's one matter in the
Wait,
Sorry.
sir, I'll take it. ಅದು ಲಿಸ್ಟ್ ಆಗಿದೆಯಾ ಗುಲ್ಬರ್ಗದು? ಫೈಲು ಬಂದಿದ್ಯಾ?
Stay there.
Huh?
Stay has been granted in.
Nagesh sir, one matter ಇದೆ.
Please, my lord.
5 minutes I'll take and
Doesn't
give,
matter, my lord.
because this will take some time.
We will certainly
Yes.
wait and take out.
Give me 10-15 minutes, I'll get back.
One more matter was there because.
Mood matter. ಯಾವುದು?
2:30.
ಅದು ಬರುತ್ತೆ, ಅದು ತಗೊಂತೀನಿ. ಅದೆಲ್ಲ ಮುಗಿಸ್ಬಿಟ್ಟು I'll get back to this matter. ಧಾರವಾಡದ ಮೂಡ್ ಮ್ಯಾಟರ್ ತಗೊಳ್ಳಿ, ಬಂದಿದ್ಯಾ? ಮತ್ತೆ ಗುಲ್ಬರ್ಗದ ಮ್ಯಾಟರ್. ಶ್ರೀಧರ್ ಪ್ರಭು ಸರ್.
Please, my lord. This matter, my lord, the FIR is registered before 3rd Additional Sessions Court in Raichur, my lord.
ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ವಾ ನಾನು?
ಅಲ್ಲ ಕೊಟ್ಟಿದ್ದೀರಿ ಸರ್, ಅದನ್ನ ಈ ರೆಗ್ಯುಲರ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇಂಟಿಗ್ರೇಟ್ ಮಾಡ್ಕೊಳಕ್ಕೆ ಐ ಓನ್ಲಿ ಟ್ರಾನ್ಸ್ಫರ್ ದಿಸ್ ಟು ದಿ MPMLA court is what I'm praying, Lord. Otherwise, for bail and everything, I have to go to Raichur and get this one. This wrongly, Lord, the FIR is sent to 3rd Additional Sessions Court.
MPMLA ತಾನೇ ಇದು?
ಹೌದು.
Number 1 ಇದೆ ML.
ಇನ್ನೇ
It's
ಟ್ರಾನ್ಸ್ಫರ್
19, Lord.
ಅಲ್ಲ ಇವರೇ ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ ಗುಲ್ಬರ್ಗದಲ್ಲಿ.
ಅಲ್ಲ ಯಾಕೆ ಅಂತಂದ್ರೆ that court is, my lord, the MPM, this Sessions Court in Raichur is, my lord, ಅಲ್ಲಿ FIR ಹಾಕಿದ್ದಾರೆ ಇವರು. I was compelled to file there because the FIR was not sent to the MPMLA court. Page 19 is the FIR, my lord. Therefore, I am praying that matter may be integrated in the MPMLA court and then, my lord, the renumbered.
That is all the prayer?
No, my lord. The quashment, my lord. I am so sorry. I belong to the scheduled caste. And
that's all
Lord,
right.
ಅಲ್ಲ ಇವ್ರ ಜೊತೆಲಿ ಬೇರೆಯವರು ಇದ್ದಾರೆ, ಅವರೊಬ್ಬರೇ ಅಲ್ಲ.
Sorry. But why, my lord, it is invoked against me? That I will, my lord, satisfy independently.
No, that the matter is seized off by this court. It is MPMLA court. Why are you worried?
Correct, my lord. But ಅದನ್ನ ಈಗ ಇದ್ರಲ್ಲಿ ಈ ಗುಲ್ಬರ್ಗ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಹಾಕಿದ್ರೆ ಮತ್ತೆ 230
ಇಲ್ಲ, main list, I will draw it into the main list.
That's what I'm praying. That's what
Yes.
I'm praying. That's all.
The registry is directed to list this matter not as a matter pertaining to Gulbarga bench, but a matter pertaining to the special court constituted for MP and MLA, and integrate the same into the list of cases pertaining to MP MLAs in the principal bench. Yes. Second one. Interim order subsisting will continue till the next date of hearing. List the matter on 7th March.
Great.
Yes. Opinion bandilo. ಬಂದಿದೆಯಾ ಅದು?
Mood list, serial number 1, Gaurav N, Prasanna Kumar P.
My lord, on submission, my lord. My lord, serial number 79, my lord. I'm appearing for the appellant, my lord.
14th March, sir. Yes.
Much obliged, my lord. My lord, stay may be extended, my lord.
Sir, admit tag entry order ಇದೆ, don't worry. Yes. ಇದೇನು?
Lords, filed for quashing, my lords, the proceedings.
ಓ, ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗಿರ್ಲಿಲ್ಲ ಅಂತ ಡೇಟ್ ಕೊಟ್ಟರು ಆಗಿರ್ಲಿ.
Your lordship may have it on 7th, my lords, along with
No,
the
no, no, I'm
connected
sorry,
matter.
just a minute,
ಅಲ್ಲ
sir.
ಮುಗಿಸ್ಬಿಡಿ.
ಅಲ್ಲಲ್ಲ, interim order I will make my submissions.
ಇಂಟ್ರಿ ಮಾಡ್ರ?
ಹೌದು.
ಹಾ.
May I request your lordship to kindly go to the proceeding sheet which came on the 17th of December 2024. Heard the learned senior counsel so and so appearing for the petitioner. The learned senior counsel taking this court to the documents appended to the petition would submit that the very procedure followed by the,
Procedure?
but he would follow BNSS. If he follows BNSS, then well, I am entitled for an hearing prior to he taking cognizance and issuing process. That is the settled law. In fact, your lordship also has
The
ruled.
first judgment.
Yes, your lordship has ruled that. Any number of judgments are there. Kodima?
No, the first was mine interpreting 223.
Milord, no, earlier a coordinate bench of this honorable court, Milord, speaking to his lordship, Mr. Justice Natarajan, following Allahabad and Madhya Pradesh and Punjab, would say that is the procedure that needs to be adopted.
Where
But
is
this
it?
is a
Sitting in
complaint,
Kalburgi.
yes, private complaint filed subsequent to 1/7/2024. A private complaint. Cognizance is taken subsequent to 1/7/2024. If cognizance is taken subsequent to 1/7/2024, the procedure which the trial court is required to follow is the one under BNSS. That is the settled legal position now. But he straight away, he would issue summons. That is incorrect. In fact, your lordship in one of the cases ruled, that is a reported judgment, my lord. In fact, I had the occasion to argue that matter before your lordship under 195 capital A of the CRPC. But no doubt a public servant in the absence of a complaint by the court under 195 for certain classified offenses can present a complaint and the court can take action. But you can't give up the procedure which you are required to follow
40.
under section 340. As in this case, my lord, it is a public servant.
ಇದೇ ವಿನಯ್ ಕುಲಕರ್ಣಿ ಇದ್ರಲ್ಲೇ.
ಹೌದೌದು. This man is a public servant. He presents a complaint. The only privilege which you would enjoy, my lord, the dispensation of recording of the sworn statement and of the complainant and
I
the
have allowed
witnesses,
it.
if any. But it will not dispense with the legal requirements.
40 procedure follow ಮಾಡಿಲ್ಲ ಅಂತ.
Yes, ಮಾಡಿಲ್ಲ. Adrinda, in fact, that is what your lordship also recorded.
ಇದ್ರಲ್ಲೂ ಅದೇ ಇರೋದಾ?
Idralli, may I just request your lordship to kindly turn to the
No, procedure
order of
BNSS should have been followed.
how the BNS ought to have followed. Kindly, that is a settled legal position, my lord. Any number of judgments, including my lord's judgment in.
That's my difficulty is this. The ASG appears in this.
ಆಯ್ತು,
matter.
ಯಾರಾದ್ರೂ appear ಅಲ್ಲಿ
Not-
ತನಕ.
not-
My lord, he has posted the matter for.
In fact, 2 times it has come
no,
up
no,
before this
no,
court.
I'm sorry.
Question of interim.
If I am able to make out a prima facie case for consideration of my request for the grant of.
What has he posted the matter for?
My lord,
What has he posted the matter?
next week, my lord, for arguments before charge.
Chetan.
ಅಷ್ಟೇ, let him not record further proceedings, ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ.
Let him record. Let him not frame.
My lord, in fact, your lordship has said in the earlier order on 17th of December, it goes to the root of the matter, jurisdiction of the court itself. ಅಷ್ಟೇ, ಏನೂ ಆಗೋದಿಲ್ಲ ಅದರಲ್ಲಿ. ಏನಾಗುತ್ತೆ?
ಯಾವತ್ next date ಇರೋದು ಯಾವತ್ತು?
17th ಏನೋ ಇದೆ.
17th is Monday, not 17th.
ಹೌದು.
ಅಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ
ಅದೇ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲೇ
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನೆಕ್ಸ್ಟ್
17th March.
ಎನಿವೆ ಮಲಡ್ whatever it-
17th March, let him.
7th March is what I am requesting.
ಅಲ್ಲ ಈ ತಿಂಗಳು ನಾನು ಹೇಳ್ತಾ ಇರೋದು ನಾನು
17th Monday.
ಎಸ್ ಈ ತಿಂಗಳು ನಾನು ಹೇಳ್ತಾ ಇರೋದು ನಾಟ್ ಮಾರ್ಚ್.
Get to know the date and come back.
Yes, ma'am.
You take
I'll
a date.
verify and
Well,
get
what is going to happen, Malad, if he does not
No,
record,
we'll see. It's not,
if he does not hear us, nothing is going to happen. He will-
Let him hear
no.
on the arguments before charge. That's not a problem.
No.
If he's posting it for framing of charges, yes.
No. Argument. Well, why should I address arguments before him, my lord, when I am entitled to?
It is only a procedure liberation.
Quite
I
right,
correct
quite
it.
right. Why should I go and appear before him even without issuing a notice to me as mandated under section 231?
That we'll see whether what had to be followed, we'll see.
Yes.
Because it's a complaint registered prior to the BNSS.
No. September 2024.
Oh, after BNS.
After BNS. Cognizance is taken subsequent thereto.
Let's see. The next date I will calculate. Yes.
It is not saved, my lord, under 531.
It's not.
Not saved under
Saved and
531.
that I know. Let's see.
Lordship.
Yes. ಇದು enforcement ಇಡಿನ ಇದನ್ನು
ಹೌದು.
ಪ್ರಿಡಿಕೇಟ್ offense ಅಲ್ವಾ ಇದು?
Predicate offense.
ಮತ್ತೆ ಇಡಿ
Predicate offense there.
ಇದೆ. ಈ enforcement directorate ಯಾಕೆ?
ಹೌದೌದು ಇಡಿ.
What happened to the predicate offense?
ನಮ್ಮೇಲೆ ಇಲ್ವೇ ಇಲ್ಲ.
You are not an accused in.
No, charge sheet is also filed against others, not against me. I am not even named in the FIR. No final report against me.
It is answered by Pankaj Bansal.
It's all right, let it be answered.
No, that's all right. I'm not on that.
There is no difficulty.
No, why? I thought it was the predicate offense.
No,
No.
not.
No predicate offense against me.
All right, we'll
I'll verify and get.
verify and get back, then we'll pass out. ಅದನ್ನ ಆರ್ಗ್ಯೂ ಮಾಡ್ಬೇಕಾದ್ರೆ ಹೇಳಿ.
Yes.
ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ಇದೆಯಲ್ಲ. ಸುದರ್ಟಿ ಬಂತ.
Let there be if I am entitled to,
No,
let there be an interim order, my lord.
Yes. ಎಲ್ಲ ಕೇಸಲ್ಲಿ.
ಅಲ್ಲಲ್ಲ ಇದರಲ್ಲಿ why should I go and appear and argue?
You are not appearing, sir. It's only argument.
Yes, my lord, I am arguing. Why should I argue?
Petitioner is not appearing before the court. Counsel, we'll see. Yes.
ಅಲ್ಲ your lordship may protect my interest.
ಬರ್ಲಿ ಡೇಟ್ ಹೇಳಿ.
ಅಲ್ಲ ಅವ್ರು ಲಾಸ್ಟ್ ಟೈಮ್ ಕೇಳಿದ್ರು. Every time he is asking, he has been recorded.
No, I'm not adjourning it. I'm only passing it over.
ಈಗಲ I am sorry, my lord. I thought you. Pardon me, my lord.
Passing it.
No, I'm sorry. I'm sorry. Let him come. Let him. I'm sorry, my lord. Really sorry. I thought that your lordship is adjourning.
ಅದಕ್ಕೆ I told other matter argue ಮಾಡ್ಬೇಕಾದ್ರೆ ಹೇಳಿ ಅಂತ ಹೇಳಿ.
Please. I'm sorry. Really sorry. My apologies.
Very
Bill number 80, K. Ravishankar.
My lords, I appear for the respondent, my lords.
Yeah.
499,500.
Yes. List on 7th March. Special court matter alva. 7th March.
Complaint, my lords, is an MLA. That is why, my lords.
Interim order subsisting will continue to the next date of hearing.
My lords, may I request on 14th, my lords, instead of 7th.
14th, all right.
Grateful.
Past over matter, seal number 4, Hanmantraya CH.
I appear for the petitioner in this matter, your lordship.
Madam, ಯಾಕೆ ಪಾಸ್ ಓವರ್ ಮಾಡಿದ್ ನಾವು? ಎಸ್ ಪ್ರಸನ್ನ ಕುಮಾರ್. ಇಲ್ಲ ರಾಹುಲ್ ಈಗ ಎಲ್ಲ ಹೋಗ್ತಾನೆ. ಎಲ್ಲಿ ಸೀರಿಯಸ್ ಆಗಿ ಬೇರೆ ಕಡೆ ಮಾಡ್ತಾರೆ. Yes. Passed over twice.
Yes.
Interim order ಇದೆ, ಇಲ್ಲ take it on 20th, madam.
Interim order illa, your lordship. The matter is for on 21st. The stage may be deferred, your lordship.
Wait. No. Let him come. Pass over. Dharwad ಬಂತ. ಯಾಕೆ ಲೇಟ್ ಆಗ್ತದೆ? ಮತ್ತೆ ಏನ್ ಮಾಡೋದು? ಮತ್ತೆ ತಗೊಂಡ್ಬಿಡೋದು ಇಲ್ಲಿ ಬಿಗ್ ಗ್ರೂಪ್ ಅಷ್ಟೇ ಬೆರೆಯೋದಿಲ್ಲಲ್ಲ. ಕರಿ 77.
Number 77, Sunil Kumar S. Sunil Kumar P.
ಇದರಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇದೆಯಾ ಮುಗ್ದಿದ್ಯಾ?
I'm sorry, my lord.
ಇದ್ರಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮುಗ್ದಿದೆಲ್ಲ?
ಇಲ್ಲ ಇಲ್ಲ ಇನ್ನು
ಶುರುನೇ ಮಾಡಿಲ್ವಾ?
ಶುರುನೇ ಆಗಿಲ್ಲ. ಅವತ್ತು for any to have the advantage of an intermodern, my lord, we were required to make some submissions.
ಎಂಟರ್ ಮಾಡ್ರು ಕೊಟ್ಟಿದ್ದೇನೆ.
ಕೊಟ್ಟಿದೆ. ಇದೆ. ಅದಕ್ಕೋಸ್ಕರ ಮಾಡಿದ್ದಷ್ಟೇ. Some limited submissions were
Yes,
made.
yes.
ತಪ್ಪಾಗೋಯ್ತದು.
ಸರಿ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಕ್ವಾಶ್ ಮಾಡಿದ್ರು 164 ರೆಫರ್ ಮಾಡಿ ಫರ್ದರ್ ಆರ್ಡರ್ ಇಸ್ ಫಾಸ್ಟ್ ಅಂತ ಹೇಳಿ ದಟ್ ವಾಸ್ ದ ಸಬ್ಮಿಷನ್.
ದಟ್ಸ್ ವಾಟ್. ಈಗ ಚೇಂಜ್ ಆಗಿದೆಯಾ ಸಬ್ಮಿಷನ್? ಏನಿಲ್ಲ.
Submission that was for interim order.
One of the submissions,
One
my
of
lord. The number of submissions.
There are number of submissions.
All right.
My lord, I don't know how far your lordship would appreciate my submissions. If I were to invite your lordship's kind attention and make certain comments on this. I had the honor and privilege of appearing before me. He's a brilliant judge. There is no doubt about that, good English. And he would refer to number of judgments and all that. But in this case, my lord, things are happening in a most topsy-turvy manner. I don't know why. I shall just invite your lordship kind attention. In this, on this application, he has written 2 orders.
2 orders?
Yes, my lord. One is suppressed, the other is placed on record in the case.
Huh?
That is why I said, my lord, I don't know how far your lordship would appreciate my submissions, because I know him as a very intelligent, a brilliant judge and all that.
How are you?
I shall take your lordship now. I shall take your lordship. May I request your lordship to
Which
kindly...
petition are you holding?
Yes, my lord, in this very petition itself.
383.
He-
383.
The first order which he has written, according to me, my lord, has it been suppressed because it inured to my benefit. And subsequent thereto, he would write another order, which has inured to the benefit of the prosecution. My lord, may I request your lordship to kindly turn to?
Is it palpable or demonstrable?
Yes, my lord, I am going to demonstrate it now.
121.
May I request your lordship to kindly turn to page 121? Last time also, your lordship may recall to your lordship's memory in the earlier application also. Passes the order today. Would subscribe his signature 1 week later. My learned friend, Mr. Prasanna Kumar, took a serious objection that there has been an inordinate delay on my part.
Recorded all that.
Your lordship has recorded it. And even said that I'm in no way responsible for the delay, and it is the prosecution that is causing delay unnecessarily. Now, my lord, this is the order that is impugned now. My lord, the order that is impugned commences from, my lord, page 50. It comes to an end at page 121. Kindly permit me to take your lordship to this operative portion of the order, which runs to only 1 paragraph. Application filed by accused number 1, so and so under section 306 and 307 of the code is hereby allowed, and he is considered as approver, and he is directed to make full and true disclosure of the whole of the circumstances within his knowledge relative to the offense and to every other person concerned, whether as principal or abettor. Fine, excellent. This application came to develop. Now, my lord, the next is very, very important. Kindly read this. Typed by me.
In my official laptop.
ಇನ್ನು ಬೇಕಾದಷ್ಟಿದೆ ಅಷ್ಟಕ್ಕಿಲ್ಲಲ್ಲ. I don't know why.
Yes.
I don't know why. That too, my lord. 50 to 71 pages. Let him type. Let him type. I have no objection. I can't come either way. Probably he is not interested in making use of his stenographer. Doesn't matter.
Dragon ನಾನು ಡಿಕ್ಟೇಟ್ ಮಾಡ್ತೀನಿ ರಿಸರ್ವ್ ಮ್ಯಾಟರ್ಸ್.
ಅಥವಾ ಇರ್ಬೋದೇನೋ ಅವತ್ತು ಸ್ಟೆನೋಗ್ರಾಫರ್ ಬಂದೇ ಇರ್ಬೋದು, ಅಥವಾ ಡಿಲೇ ಆಗ್ಬಿಡುತ್ತೇನೋ ಆರ್ಡರ್ಸ್ ಮಾಡೋದಕ್ಕೆ ಬೇಗ ಮಾಡೋಣ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಮೇ ಬಿ ಸಮ್ ಕಂಪೆಲಿಂಗ್ ರೀಸನ್ಸ್ ಆರ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸಸ್ ವಿಚ್ ವಿ ಕಾಂಟ್ ಇಮ್ಯಾಜಿನ್. ಐ ಆಮ್ ನಾಟ್ ಫೈಂಡಿಂಗ್ ಫಾಲ್ಟ್ ವಿತ್ ದಿಸ್. Certainly, I am not finding fault with the learned judge.
Mark of efficiency.
The learned judge, my lord, sitting on his desk and bringing the typewriter, the computer, the system, and typing it for himself. or for the reason, or for maybe for the reason that what order he's going to pass may be leak and all that, as if it is the order of conviction and all. There is nothing here. An IA to treat me as an approver, my lord, it is neither a final order or a conviction or a judgment. No, zero. He wanted to be a witness. All had come enter into the witness box is the order. That's all, excepting that nothing else. No matter what I'm trying to invite my lord's kind attention is typed by me in my official laptop, revised by me, corrected, taken the print on 23rd of December 2024. It leaves no doubt, my lord. The judge has typed it, took out the print, corrected it, and then pronounced. Fine. Now, my lord, may I request your lordship to kindly go to page 324 for a second. Where is this order?
324.
324. Where is this order? What happened to this order? My lord gets it?
The same day.
Yes, my lord, same day. This is the order sheet. Orders dictated in open court.
Very separate order.
Where is that?
ಇದು
dictated alla. Typed by me by using my private laptop.
ಅಲ್ಲ official laptop.
Official laptop. ಅವರೇ ಟೈಪ್ ಮಾಡಿರೋದು. ಇದೆಲ್ಲ ಹೋಯ್ತಿದು. What happened to this order? Dictated in open court. We were there.
ಅಲ್ಲ only operative portion or the entire order?
ಇಲ್ಲ, ಅದಕ್ಕೆ ನೋಡ್ತೀನಿ, ಅದಕ್ಕೆ ಹೇಳ್ತೀನಿ ನೆಕ್ಸ್ಟ್. ಅದಕ್ಕೂ ಇದೆ ನೆಕ್ಸ್ಟ್. ಇಲ್ಲ ಅಡಿನಲ್ಲಿ ಬಾಟಮ್ ಅಲ್ಲೇ ಇದೆ. ಇದು application filed by accused number 1 so and so is hereby allowed.
ಅಲ್ಲ rejected.
I'm sorry, my lord.
ಇದು correct.
Is allowed as approver, directed to make full and truth related to the offense and every other concerned, whether as principal or abetar. ಇದಾಯ್ತಲ್ಲ ಇದು ಮೇಲ್ಗಡೆದು. ಇದು ಮತ್ತೆ ಪುನಃ ಇದು ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್. ಆರ್ಡರ್ಸ್ dictated open court, application filed under section so and so is allowed. Rejected. Malava's application. That is the first information.
Malavad ಏನು application?
She wanted to oppose
this
that she should not be treated as an approver. I am the first informant. I am the victim because as defined under section 2WA, if I am right, my lord, I am the victim. I am made a widow. He is the principal accused. His culpability is more. He is the one who had smashed the head of my husband. Don't treat him as a witness. You are going to hang others, whereas you are going to send him home. Don't send others to gallows. Send him to gallows first. That is our contention. And then the learned judge would dismiss that application.
Anyway, she has not challenged.
My lord, in the order, she is challenged. She is one of the petitioners before your lordship.
One of the petitioners?
Yes, my lord, one of the petitions is one petition. My lord, may I invite your lordship's attention for a second? ಇವತ್ತು ಆ ಪಿಟಿಷನ್ ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ. ಇವತ್ತು ಲಾಸ್ಟ್ ಟೈಮು ಲಿಸ್ಟ್ ಆಗಲಿಲ್ಲ. ಅದು
ಯಾವ್ದು ಕೊಡಿ?
ಮಲ್ಲವಂದು.
Sir, Mallav's petition, lordship, last time I made an submission before this honorable court, lordship, and this honorable court has given a direction to me.
For the petitioner in that?
Yes, lordship. And yes.
Writ petition number?
Yes, lordship.
589 of 25.
We'll get it. Yes.
May I request your lordship to kindly see the order, my lord?
ಇದ್ಯಾ order?
ಇದೆ ಮಲ್ಲವಂದು ರಿಜೆಕ್ಟ್ ಆಗಿರೋದು. Session trial court avate.
Dictated to
same day.
Transcribed.
Dictated to the stenographer, grade 1, transcribed and typed by him, revised and corrected by me and pronounced in open court. ಏನೋ ಒಂದು ಆರ್ಡರ್ ಇರ್ಬೇಕಲ್ಲ ಅವತ್ತು. ನಾವು ಅದಕ್ಕಿನ್ನು ಬೆಳೆಸ್ಕೊಂಡು ಹೋಗೋದು ಚೆನ್ನಾಗಿ ಕಾಣಲ್ಲ. ಯಾಕೆ ನಾವೇನು ಅಫಿಡವಿಟ್ಗಳು ಈ ಥರ ಆಯಿತು ಆ ಥರ ಆಯಿತು ಅಂತ ಹೇಳೋದು. ಬಟ್ ಇಫ್ ಐ ಆಮ್ ಶೂರ್ ಮೈ ಲಾರ್ಡ್ ಐ ಆಮ್ ಸಕ್ಸಸ್ಫುಲ್ ಇಫ್ ಐ ಆಮ್ ಏಬಲ್ ಟು ಪರ್ಸ್ಯೂಡ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ದಟ್ ಸಮಥಿಂಗ್ ಆಲ್ ಈಸ್ ನಾಟ್ ವೆಲ್. Something is wrong. But my respectful submission to your lordship is, what happened to this order? Which he dictated to the stenographer. Where did it go? Did it vanish like a mist?
And everything happens on the same day.
Yes, my lord. This order also, second order also, Malava's application also came to be dictated to the stenographer in court, transcribed, corrected, everything. Yes, that is there.
Malava's application.
Yes.
ಇದೆ.
ಅದರಲ್ಲೂ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಬರೀತಾರೆ. ಏನಂತ ಬರೀತಾರೆ?
Dictated stenographer grade 1 transcribed typed by him.
ಅದು ಏನು ಸ್ಟೆನೋಗ್ರಾಫರ್ ಗ್ರೇಡ್ 1 ಇದೆ ಇಲ್ಲಿ. ಬರೀ ಸ್ಟೆನೋಗ್ರಾಫರ್
ಇದೆ. Transcribed and typed by him and corrected by me, pronounced in the open court on this day and reserve ಆಗಿತ್ತಾ ಇದು?
ಇದೆ, ಇಲ್ಲೂ ಇದೆಯಲ್ಲ. Orders dictated in open court. ಯಾರಿಗೆ dictate in open court? ಅವ್ರಿಗೆ dictate ಮಾಡ್ಕೋತಾರೆ, ಟೈಪ್ ಮಾಡ್ಬಿಟ್ರೆ. My lord, I'm very, very serious, my lord. I'm not making any joke here.
Nobody's laughing.
Sorry, your lordship may.
No, I'm surprised about.
Yes, my lord.
the manner.
That is why, my lord, initially I said I have greatest respect for this learned judge. He is a brilliant judge. There is no doubt about that. No doubt. Very good English. Reads. Comes with thorough preparation, even to hear us also. He would ask us the queries and all that, gets himself satisfied and then proceeds with the matter further. No, my lord, my concern is I'm more worried about my client now, not about the judge.
About the system.
Yes, my lord, I hold a brief for my client, not for the judge. I'm attacking the judgment of the judge. My lord, my respectful submission to your lordship is, if on this day, my lord were to agree with me, your lordship, I'm sure your lordship has got to agree with me, because that is the endorsement which he has made at page 121. It leaves no doubt. I'm sure, my lord, no one can interpret it in any other better way when the judge himself says, typed by me in my official laptop, revised by me, corrected and taken the printout. Fine. Either this should be true, or what is recorded in the proceeding sheet of the case, which your lordship would find at page 300.
ಇದು allow ಆಗಿದೆ.
I'm sorry, my lord.
ಅಲ್ಲ, which was in your favor? There is nothing in your favor. You told me that ಒಂದು.
Yes. ಇದೆಲ್ಲ ಹೋಯ್ತು ಹಾಗಾದ್ರೆ ಇದು?
It is not in your favor.
But this order is not there at all. We don't know.
There you said.
What we are seeing here.
One favoring the prosecution, one favoring you.
Obviously. What happened to this order then? But what your lordship is seeing is only an operative portion. Where is the order? Order is the one which he has dictated to the stenographer. What happened to that? No, does it not, my lord, a serious issue, my lord, warranting consideration at your lordship's hands? But is it not open to me to contend before your lordship? Obviously, there are two orders. One typed by him, and another is dictated to the stenographer. As my lord has posed a question to me, even this order also does not inure to my benefit. Even this order also does not inure to my benefit, because the operative portion of the order has been incorporated in the proceeding sheet of the case. That your lordship has got to examine vis-a-vis the order which came to be dictated. What does it contain? What happened to that order? Is it suppressed for the reason that it has inured to the benefit of the accused, or it has inured to the benefit of the prosecution, well, the contents of which would have certainly inured to the benefit of the accused? Probably one dictation in the open court, and thereafter, my lord, certain findings which is not based on the record of the case or the legal position, then changing the order. It's a very serious issue, warranting consideration at your lordship's hands. It is not so easy or so simple, provided your lordship would agree with me that one dictation to the stenographer, another which he would type by using his laptop. My lord, it looks, my lord, a little bit awkward. A judge, my lord, a session judge, taking his official laptop, sitting in front of the desk, and then typing nearly about 50-60 pages. For what? To ask a person to step into the witness box as a witness. Because we have been questioning that time and again before your lordship. This is the third application. First application rejected. Second application, your lordship would reject it. Third application, he would entertain. Well, this would be my first submission, which I thought I should invite my lord's kind attention, because it goes to the very root of the matter itself. According to me, my lord, I don't know why. What happened to that order is $1 million question. It is a mystery. Mystery that has remained unanswered. I don't know whether my learned friend, Mr. Prasanna Kumar, will be in a position to answer it. Or my learned friend, Mr. Nayak, will answer it. He knows.
ನಾಗೇಂದ್ರ ನಾಯ್ಕ ಅವ್ರಿಗೆ ಏನ್ ಗೊತ್ತಿರುತ್ತೆ ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲ.
ಅವ್ರ ಪಾಪ ಏನ್ ಹೇಳ್ತಾರೋ ಏನ್ ಹೇಳಲ್ಲ. ಏನಾದ್ರು ಇದ್ರೆ ಹೇಳೋಗಿದ್ರೆ
ಪ್ರಯತ್ನ ಮಾಡ್ಲಿ ಎಲ್ಲಿ ಆದ್ರೂ
ಹೇಳ್ತೀನಿ ಅದಕ್ಕೆ. ಅಲ್ಲ ನಾಗೇಂದ್ರ
ನಮಗೂ ಹೆಂಗ್ ಗೊತ್ತಿರುತ್ತೆ
ಅವ್ರಿಗೂ ಗೊತ್ತಿಲ್ಲ. ಈಗ ಗೊತ್ತಾಯ್ತಲ್ಲ ಈಗ ಏನಾಗಿದೆ ಅಂತ.
ಅಲ್ಲ ಜಡ್ಜಿಗೆ ಮಾತ್ರನೇ ಗೊತ್ತಿರುತ್ತೆ.
ಈಗ ಗೊತ್ತಾಯ್ತು. ಗೊತ್ತಾಡೋದಲ್ಲ ಗುಡಿಯುಮಾರ್ ಸರಿ ಈಗ ಗೊತ್ತಾಯ್ತಲ್ಲ ಏನಾಗಿದೆ ಅಂತ. ಒಂದೊಂದಾಗಿ ತೋರಿಸ್ತೀನಿ ಒಂದಲ್ಲ ನೆಕ್ಸ್ಟ್ ತೋರಿಸ್ತೀನಿ ನಾನು. ಐ ಡೋಂಟ್ ನೋ
ಇದ್ರೆ ಅವ್ರನ್ನು ಪಾರ್ಟಿ ಮಾಡ್ಬಿಟ್ರೆ at least
ಯಾಕೆ?
not a position to reply.
In fact,
ಅವ್ರ ಮೇಲೆ allegation.
no. This honorable court and the Supreme Court has time and again come upon the parties heavily as and when even a tribunal is made a party. No, there is no need for you to make the tribunal a party. A Tahsildar is a party, a deputy commissioner is a party. It is a court that passes the order. No, when I seek for transfer of the case, you take it from me, I will certainly make use of it. In the event it is warranted, I will certainly make use of it. In the event of there being such a contingency, if not today, tomorrow, I do not know what is going to happen, how your lordship is going to react to this. I can't imagine to myself. Certainly I will do it. I am not hesitant. I am here, my lord, to invoke my lord's jurisdiction to see that justice is done to the parties in the case. That's it. But my suspicion is, if these two were to be kept in juxtaposition and dread, what is written in the order and what is written in the proceeding sheet of the case, it would certainly create some doubt or suspicion with regard to the existence of another order on that day passed by the judge. My lord, probably he thought, my lord, I don't know. My lord, it is only the constitutional courts that could say pronounced in open court by way of dictation, and thereafter not the trial courts are not clothed with the powers of
reasons to follow.
Avargilla powers illa. But probably at times, my lord, over enthusiasm. Hey, come on, take down here. That is why I said, my lord, he is an intelligent judge, very intelligent judge. No doubt about that. I'm giving him encomiums to him. No doubt about that. But in this case, my lord, I don't know. Every day, my lord, it is hunting me like anything. One after the other, one after the other, one after the other. It is hunting me like anything.
Encomiums ಕೊಟ್ರಿ.
ಕೊಟ್ಟೆ.
ಅಲ್ಲ ಅದಕ್ಕೆ took him to the crescendo and dropped him to the abyss.
My friend Mr. Sham is also there with me. He has also seen on that day what happened. Dictation maya agbitre.
Enigmatic ಅಂತ ಹೇಳಿ. Mysteries of unexplained ಅಂತ ಹೇಳಿ.
Yes. ಅದಕ್ಕೆ ಹೇಳಿದ್ದು took him to the crescendo and dropped him.
ಇದು ಎಲ್ಲಿ ತಪ್ಪಾಗಿದೆ ಅಂತ ನನಗೂ ಕಂಡುಹಿಡಿಯೋಕೆ ಆಗ್ಲಿಲ್ಲ. I have also not been able to unearth the truth. But the truth remains, two orders are there.
That we'll see. We'll
see
what is to be done. I will do.
Yes, madam. My lord, may I now invite your lordship's kind attention on 12/12/2024. Have a look at 12/12/2024 proceeding sheet, which my lord gets.
Page.
My lord, first kindly go to memo, which your lordship would get at page 125.
Memo.
125.
Which memo?
Page number 120. Sir? Okay. My lord, ಕೋರ್ಟ್ಗೆ ಕೊಡದೆ ನಾನು ಇಷ್ಟು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿದ್ದೀನಿ ಈಗ.
ಈಗ ಕೊಟ್ಟೇ ಇಲ್ಲ.
ಅವ್ರಿಗೂ ಕೊಡಿ. ಅಲ್ಲ, just to show where the judge has gone wrong.
125.
Kindly go to page 125.
Memo.
Page 125. Well, in 125, kindly permit me to take your lordship to this. It is only a one paragraph memo. The 15th accused has produced here with the recorded conversation. ಇನ್ನೂ ಒಂದು recorded conversation ಇದೆ ನನ್ನ ಹತ್ರ. That, my lord, it will be little bit embarrassing. Therefore, I did not produce it.
Accused number 1 and certain lady.
Yes, my lord, not accused number 1 and certain. ಇನ್ನೊಂದು ಪಬ್ಲಿಕ್ ಪ್ರಾಸಿಕ್ಯೂಟರ್ದು ಅಕ್ಯೂಸ್ ನಾನು ತೋರಿಸ್ತೀನಿ ಅದನ್ನ ಅವಶ್ಯಕತೆ ಇದ್ರೆ ಹಾಕ್ತೀನಿ. ಅವತ್ತು ನಾಗೇಂದ್ರ ನಾಯ್ಕ್ ನಮ್ಮ ಹತ್ರನೂ ಇದೆ ಅಂದ್ರು, ನಿಮ್ದು ಹಾಕ್ಬಿಡಿ ನಾನು ಅಂತಂದೆ. ಏನಿದ್ರೆ ನಿಮ್ದು ಹಾಕ್ಬಿಡಿ, ಎಲ್ರದು
ಏನಿದೆ ಕೊಟ್ಟು ಬಿಡ್ಲಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಇಟ್ಕೊಳ್ಳಿ. ಬಟ್ ಅಟ್ ಲೀಸ್ಟ್ ಕೊಡ್ತೀವಿ ಅಂತ ಕೊಡ್ತಿದ್ರೆ
ಇದಕ್ಕೆ ನಾವೇನು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿಲ್ಲ, ಏನಿಲ್ಲ. ಬಂದೆ ಬರೋಣ ಈಗ ವಿಲ್ ಕಮ್. ಅಲ್ಲ, ಇನ್ನೊಂದಿದೆ, ದಟ್ ಇಸ್ ಮಚ್ ಮೋರ್ ಸೀರಿಯಸ್. ಅದು ಟ್ರಾನ್ಸ್ಫರ್ ಪಿಟಿಷನ್ ಅದೆಲ್ಲ ಈಗ ಬೇಡ, ಅವಶ್ಯಕತೆ ಇದ್ರೆ ಹಾಕೊಂಡಿಲ್ಲ ಬೇಡ. The 15th accused has produced herewith.
15th accused is you, petitioner.
Yes, that is a petitioner before your lordship in this petition. 15th accused has produced herewith the recorded conversation between the first accused and a certain lady, in which conversation the first accused has demanded through that lady a huge amount to implicate the 15th accused, among others, in the case from his statement, which he would be making before the court under section 306 of CRPC. This
Based upon a powerful
by the first accused, the conversation between Nagendra Naik Avara, now approver. That is the conversation.
Muslim. Yes.
This demand is placed upon a powerful politician who is inimically disposed towards the 15th accused, among others, since the statement that would be made by him would wipe out the career of the 15th accused as a politician. The conversation that is recorded will have a material bearing for the purpose of consideration of the third application filed by the first accused, invoking the jurisdiction of this honorable court under section 306 of CRPC. Therefore, the 15th accused above named humbly prays that this honorable court be pleased to read and record this memo and take the pen drive and record in the case for being read while disposing of the application filed by the first accused under section 306 of CRPC in the end of justice.
This is a pen drive problem.
Pen drive produce ಮಾಡಿದೀವಿ. I produced before the court. ಇಲ್ಲೂ ಕೊಟ್ಟಿದ್ದೀವಿ ನಾವು pen drive. No, my lord, this was filed on 12/12/2024 prior to the passing of the order.
What order is passed on?
Yes, my lord. Now, my lord, may I request your lordship to kindly turn to the proceeding sheets at page 316 of my earlier first volume, 316. There is a petition. Along with the petition, I produce the order sheet. Your lordship gets it, madam?
I am there.
Yes, 316 at the bottom, last paragraph. The Lord Counsel for the accused number 15 has filed a memo with one pen drive and document. Kindly go to page 318.
Case called out. I am at 316.
316, my lord. Last para.
The learned counsel for the accused has filed a memo with one pen drive and document.
Fine. Now kindly go to page 318. But the document is the boarding pass of this lady and this man.
Boarding pass?
Yes, my lord, they would go to Delhi to have this plan. I will be the approver. I will see that his political career is ruined, provided you pay me. When I invited the Lara trial judge's notice to this, what is the amount he demanded? I said he would demand 15 crores.
That conversation is recorded?
Yes, my lord, it is in pen drive.
Pen drive.
The judge was also shocked. My lord, now that I have produced a pen drive also before your lordship, I will produce a manuscript.
ಅದು ಇದೆಯಾ?
ಇದೆ. ನಾವು ಮಾಡ್ಬೇಕು manuscript. ಅವ್ರು ಮಾಡಿ. ಇಲ್ಲಿ kindly go to page 318 now for a second. Kindly go to page 318 for a second. The learned SPP submits. The learned SPP submits that you would find necessary objections to the memo filed by the learned counsel for the accused number 15, wherein a pen drive and a document is produced.
Objections ಹಾಕಿದ್ರಾ?
No, my lord. Your lordship's question, I'm prepared to answer it. What happened to that? How he has
What happened to the
how he has referred to it in the order? He does not even refer to it at all in the order.
No, where is the transcript of this? ಮಾಡಿಸಿಲ್ವಾ?
ಮಾಡಿಸ್ಕೊ. Some lapse on our part.
Transcript ಇದೆಯಾ?
ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಷನ್ ಮಾಡ್ಲಿಲ್ಲ. ಅವರು ಫಸ್ಟ್ ಡೇ ಆಫರ್ ಮಾಡೋದು.
ಆಫರ್ ಅಂದ್ರೆ
ಕೊಡ್ತೀವಿ ನಾವು ಅಂತ ಮತ್ತೆ
ಆಫರ್ ಅಂದ್ರೆ
ನೀವು ಫಸ್ಟ್ ಡೇ ಕೊಡ್ತೀವಿ ಅಂದ್ರು ಆಮೇಲೆ
ಅಲ್ಲ,
ಕೊಡ್ಲೇ
ಅದೇ
ಇಲ್ಲ
ಈಗ-
ಅಂತ ಏನ್ ಅನ್ಕೋಬೇಕು?
ಅಲ್ಲ, ಅವ್ರು
ಈ ತರ
ಕೊಟ್ಟಿದ್ದು
submission
he is
ಇರುವಾಗ
accountable for the accused.
ಈಗ
CBI also was given. ಕೊಟ್ಟಿಲ್ವಾ ನಿಮ್ಗೆ?
ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಅಂತ ಹೇಳಿ.
ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಅಲ್ಲ, ಸಾಹೇಬ್ರು ಕೇಳ್ತಾರೆ ಪೆನ್ ಡ್ರೈವ್.
ಕೊಟ್ಟಿದ್ದು
ಮತ್ತೆ
ನಾನು ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಕೇಳಿದೆ, ನೀವು ಫಸ್ಟ್ ಡೇ
ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಅಲ್ಲ.
ಫಸ್ಟ್ ಡೇ ಆಫರ್ ಮಾಡಿದ್ರು ಆಮೇಲೆ ಕೊಡ್ಲಿಲ್ಲ ಅಂತ ಏನ್ ಅನ್ಕೋಬೇಕು?
ಅದ್ರ ಏನಾಗುತ್ತೆ ಅಂತಂದ್ರೆ ಪೆನ್ ಡ್ರೈವ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಆಗತ್ತೆ ಅವಾಗ.
ಅಲ್ಲ, ಬೇರೆ ಆಫರ್.
ಅಲ್ಲ, ಈಗ ಅವ್ರು ಅದ್ರ ಮೇಲೆ ಆರ್ಗ್ಯೂ ಮಾಡೋದು. ಒಂದು ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಕೊಡ್ಲಿ, ಎಲ್ಲೂ ನಾವು ಗ್ರೌಂಡ್ ಅಲ್ಲಿ ಇಲ್ಲ, ಈಗಿಲ್ಲ, ನಾನೇ ತರ್ತಾ ಇದ್ದೀನಿ.
ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಯಾಕೆ ಮಾಡಿಸಿಲ್ಲ?
ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಕೊಡ್ಲಿ.
ಮಾಡಿಸ್ಬೇಕಾಗಿತ್ತು.
That should have been.
ಅಲ್ಲ, ಅದನ್ನ ವಿಡಿಯೋನೇ ಬೇಕಾದ್ರೆ ಪ್ಲೇ ಮಾಡ್ಬೋಣ ಅಂತ ಬೇಕಾದ್ರೆ
Correct, but that should be the first thing you.
ಮಾಡ್ಬೇಕಾಗಿತ್ತು.
Then affidavit ಜೊತೆಗೆ ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್
ಮಾಡ್ಬೇಕಾಗಿತ್ತು. ಮೇಲೆ ಲ್ಯಾಪ್ಸ್ ಆನ್ ಅವರ್ ಪಾರ್ಟ್.
Yes.
ಐ ಕ್ಯಾನ್ ಸಿ.
ರಿಪ್ಲೈ
ಏನ್ ಗ್ರೌಂಡ್ ಮಾಡೋದು?
ಬರ್ಲಿ.
ಇಲ್ಲೇ ಇದೆಯಲ್ಲ, ಇದೆ ಬ್ಲಾಕ್ ಅಂಡ್ ವೈಟ್ ಅಲ್ಲಿ ಇದೆಯಲ್ಲ, ಏನ್ ಗ್ರೌಂಡ್ ಮಾಡೋದೇನ್ ಬಂತು?
ಇಲ್ಲ, ಪೆನ್ ಡ್ರೈವ್ ಅಲ್ಲಿ ಇದೆಯಲ್ಲ.
ಅಲ್ಲಲ್ಲ, ಮೆಮೋದಲ್ಲೇ ಇದೆಯಲ್ಲ, ಏನಾಯ್ತು ಅಂತ ಅನ್ಬಿಟ್ಟು.
ಇದೆ.
ಮೆಮೋದಲ್ಲೇ ಇದೆ, ಏನಾಯ್ತು ಅಂತ ಅನ್ಬಿಟ್ಟು.
ಇಲ್ಲ, ಪೆನ್ ಡ್ರೈವ್ ಇದು ಬಂದಾಗ ಸ್ವಲ್ಪ ಪ್ರಾಬ್ಲಮ್. ಅದು ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಇದ್ರೆ ಒಳ್ಳೇದು.
ಪೆನ್ ಡ್ರೈವ್ ಅದನ್ನ ಪ್ಲೇ ಮಾಡಿದ್ರೆ ಪ್ರಾಬ್ಲಿ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ವುಡ್ ಆಲ್ಸೋ ಬಿ ಶಾಕ್ ಅಂಡ್ ಟೇಕನ್ ಅಬ್ಯಾಕ್.
ಪೆನ್ ಡ್ರೈವ್ ಆಲ್ವೇಸ್ ಜನರೇಟ್ ಶಾಕ್ಸ್. ಅದು ಯಾಕೆ ಕೊಟ್ಬಿಟ್ರೆ ಒಳ್ಳೆ.
ಅಂಡ್ ದಟ್ ಯಾರ ಜೊತೆ ಅದು ಕನ್ವರ್ಸೇಷನ್ ವಿತ್ ಅ ಲೇಡಿ?
Accused number 1 is speaking to the lady.
Yes, both of them go to Delhi. ಅದೇ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರೋದು. ಯಾವ್ದನ್ನ? As a document, boarding pass and all that, tickets of boarding pass ಎಲ್ಲ.
Yes.
But what I am submitting to Lordship is, why is it necessary for the purpose of adjudication of this application? Probably the next question would be from your Lordship would be this. Well, look at his conduct. He's a blackmailer. He is trying to blackmail me. You are going to grant pardon to him, despite the opposition by the victim, Malawa, the wife of the deceased.
The whole thing is victim has opposed the application, saying that don't grant pardon.
Don't grant pardon.
She is a hostile witness in that state case.
Hostile
She
witness.
herself-
Alla, victim herself is trying to.
But she herself has not supported the case. We are
Yes,
not, her husband has been done today.
Not against others, but against him.
Against accused.
Yes, yes, yes.
She has turned hostile against other.
No, he's not treated, my lord, kindly see this.
Treated hostile.
ಯಾವ್ದೋ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಬಿಟ್ಟೋಗಿರುತ್ತೆ. I shall, if need be, I shall take your lordship to the evidence. That is what I am producing now before your lordship in the documents. ಒಂದು ಸೆಂಟೆನ್ಸ್ ಯಾವ್ದೋ ಒಂದು ಇರೋದಿಲ್ಲ. Did you identify him ಅಂತ ಏನೋ ಇರೋದಿಲ್ಲ. ಅದಕ್ಕೆ I may be permitted to treat hostile. ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ. He has spoken to or given evidence on all material aspects of the case of the facts that are well within her knowledge. If it becomes necessary, I will do it. Even if she is hostile, when she says, don't grant it, no, merely because you are hostile, therefore I am rejecting your application, your objection.
No, the accused number 15, accused number 15 is Vinay Kulkarni. Now, the conversation is not with Vinay Kulkarni.
No.
It is to give evidence against Vinay Kulkarni.
Yes. That is with a lady, a conversation between A1 and a lady.
All right.
My learned friend said, the victim has turned hostile. Right? That's what he said. No? But they have given him her up. She appeared before the court. She wanted to give evidence. The additional charge sheet came to be filed. After statements came to be recorded, the prosecution would say, no, we are going to give her up. I shall read to you, Lordship.
Don't worry.
Well, at the first instance, when the trial took place before Dharwad court.
That is before the CBI.
Yes, my lord, before CBI. She was treated hostile by the prosecution. My lord, the whole evidence that was recorded or collected by the investigator has been turned topsy-turvy now, because the CBI has collected evidence, total contradiction to the evidence that has been given and led in court by the prosecution and collected by the investigator. Now we are only concerned with the evidence which the investigator has collected under 173(8 now.
Yes.
Now she appears. Summons was taken. The learned judge would also record time and again that cross-examination of this witness would be deferred because she is going to speak to the motive aspect and the conspiracy that is involved in the case, subject to the other witnesses or one or two witnesses who are going to speak to this very same. That is how, my lord, her examination was deferred from time to time despite the fact that she appeared before the court. Finally, on the last date of hearing, when she appeared before the court, the prosecution would make a categorical statement which came to be recorded by the judge. Shockingly, you don't want to examine her, you want to give her up. Yes, they say. That has been recorded. Where is the question of treating her hostile now? Where do you get that information? I'm posing that question to my learned friend.
You'll answer it later. Yes. Next.
Well, at 164, I'm sorry, this pen drive, not even adverted to, not even referred to in the order. Even with regard to its production also, it has, well, he may accept it, he may not accept it. That is a different issue. That is left to his judicial.
But pen drive should have been referred.
At least he ought to have referred to it. When I say something, look here, he's a blackmailer. He is trying to make capital out of the situation. He would demand about 10 to 15 crores in order to see that I would not step into the witness box to give evidence against him as an approver. That's all. And he would place a demand upon a politician who is my political adversary. He will tell him, you tell him that he has got to pay the money. Otherwise, I'm going to keep quiet. But whatever it may be, for whatever worth it is, a certain material object, if my lord were to call that pen drive as a material object, or a document, in fact, how the Supreme Court has said in Akbar's case and all that, even a recorded version is also a document under 200, yes, under 206, 203, 209, that those things have also got to be given because it has the status of a document, even a pen drive and all that. But I would have been happy had he referred to it at least in that, which he does not do it.
Yes.
So the third legal submission. May I invite your lordship's kind attention? So before I take your lordship to the facts, I'm just narrating the legal submission. Though your lordship would be coming across time and again, day in and day out, Lord section 306 and 307 and 308. But just to refresh my memory, may I invite your lordship's kind attention?
Yes, sir.
But my lord also would be telling us every now and then, if you keep reading, every time you read, something new or the other will occur to us. That is how your lordship will be telling us every now and then. May I request your lordship to kindly
New dimension at every read.
In fact, I don't know how your lordship would recall to your lordship's memory when I was arguing that matter under section 207 and 217 of the IPC. My colleague who is the counsel on record, Swamini, pointed out that I invited your lordship's attention in that case. But sometimes what may occur to us may not occur to others. What may occur to others may not occur to us. May I request your lordship to kindly have a look at section 306 for a second?
Yes.
Because it is a most serious and important issue. And I am covered by any number of judgments of the Supreme Court. Your lordship may take it any number of judgments.
Yes.
On this score alone, this order has got to go. This order has got to go. But since my lord has told us, my lord, across the bench and the bar, that this time no order of remand and it will reach its finality in this court only.
Well, if I have to do it, I have to. I can't do it. I can't do the job of the sessions court.
In spirit. Nothing, I mean nothing, my lord.
Right.
Kindly go to section 306 now for a second. With a view to obtaining the evidence of any person supposed to have been directly or indirectly concerned in or privy to an offence, to which this section applies. The Chief Judicial Magistrate or a Metropolitan Magistrate at any stage of the investigation or inquiry into or the trial of the offence, and a magistrate of the first class inquiring into or trying the offence at any stage of the inquiry or trial may tender a pardon to such person on condition of his making a full and true disclosure of the whole of the circumstances within his knowledge relative to the offence and to every other person concerned, whether as principal or abettor in the commission thereof. This section applies to any offence triable exclusively by the court of. But a plain reading of the provisions of section 306 would indicate or tell us that this is a jurisdiction that is clothed upon the magistrate. A plain reading. Now kindly go to section 307. Power to direct pardon at any time after the commitment of a case, but before the judgment is passed, the court to which the commitment is made may, with a view to obtaining it, the evidence of any person supposed to have been directly or indirectly
Sessions
concerned-
Court.
a Sessions Court jurisdiction. Now, my lord, 308. This would be very, very important. Where in regard to a person who has accepted a tender, but first, an order that I'm going to treat you as an approver. Then the second is, I'm going to give you pardon. The third is acceptance of pardon by the accused whose application came to be allowed, without which, my lord, the process does not get completed. The whole thing goes. That is what the Supreme Court has said. My lord, why?
No, I considered this on the last occasion.
That is how your
This
lordship
argument
granted.
was made, but I
That is how
did
your
not
lordship
go
granted.
deep into it.
Your lordship granted an absolute stay. My lord, otherwise what happens
There is a
this?
procedure
Yes.
after acceptance of pardon.
My lord, otherwise what happens is this.
That's what I intermodal ಹೇಳಿದ್ದೀನಿ.
Yes, my lord, that is how your lordship has granted an interim order. My lord, otherwise what happens is this. Well, my lord, a person against whom, my lord, a serious acquisition or charge is made and whose culpability is more when compared to others, my lord, would come out with an application and makes an application and seeks for pardon, and that application is allowed. In fact, it has happened in this case also with regard to the other accused. He was given the pardon. His 164 statement was recorded. The judge had not recorded his evidence. 164 statement had been recorded. Then he was summoned as a witness. He turned hostile. But then what is it that the court could do? The
That is
court,
why 308
308.
procedure is important.
then, my lord, then only, my lord, after reference to the High Court, my lord, he could be prosecuted. That is a safeguard. That is a safeguard. Otherwise, he gets virtually the benefit of a judgment of acquittal at the initial stage, or an order of discharge at the initial stage. Virtually, it is in parameteria with an order of discharge. He being pardoned, look here, step into the witness box, I'm going to treat you as a witness, means he will be enjoying the benefit of an order of discharge as against the other accused who are required to take the trial in the case. That benefit continues, still he turns hostile. In the absence of an acceptance of pardon by him. In the event of there being acceptance of pardon by him, there could be a prosecution against him under section 308. Otherwise, no. Just kindly permit me to take your lordship. Where in regard to a person who has accepted a tender of pardon made under section 306 or section 307, this 308, well, it has got to be read along with the 306 and 307 with regard to the acceptance of pardon, because we don't get either under section 306 or under section
No,
300.
I mean to say, after 307 order is passed, tendering pardon.
Yes.
That should be made over to the person who
My lord,
is
how-
wanting to seek pardon. He should accept the pardon,
kindly,
and then the statement should be recorded is the submission that you are making.
Lord, kindly pardon me for a minute. What the Supreme Court has said, what the Supreme Court has said is, no sooner his application is granted, send a copy of that order to the accused, then ask him whether he is going to accept the pardon or not. If he accepts the pardon by filing an appropriate affidavit or a memo, whatever it may be, then proceed to record his evidence. Otherwise, no.
One clarification.
I'm sorry.
Now, when he files an application supported by an affidavit or whatever, saying that I am going to turn approver and please grant me pardon, would that not suffice that he would not deviate from his
No, my lord.
his
See,
affidavit that he
the
is saying he's
question
wanting
of
pardon?
the cost.
Is it tacit compliance with the 308 or there should be a 308 compliance later?
The question of acceptance of a pardon would arise or step in only after the court says,
of
I'm going
pardon.
to pardon you. Without pardoning him, how could he say, I'm going to accept the pardon?
The affidavit may result in pardon, may result in rejection of pardon.
Rejection also. I would say, sorry, I'm not interested. I will go and stand in the dock itself. I feel I'm in a better position in the dock rather than in the witness box.
So,
I mean, that too, my lord, when 308, after imposition of conditions.
Correct.
Those conditions he has got to accept. Prior to the passing of the order, he was certainly not aware of the conditions.
If the order under 307 itself speaks of conditions and all that, is it again to be ordered? No.
307 or 306 does not postulate any imposition of condition.
Postulate,
No.
but while the judge passes an order under 307, if he
He'll be-
imposes 1, 2, 3, 4
He'll be
conditions.
overstepping.
No, that's what I'm
He
just
can't
clarifying.
overstep. But he can't
clarifying
overstep the
my
mandate of
doubts,
law.
that's all.
It will be an assault on the provision. He can't overstep the mandate of law.
That's all.
Yeah, no, that is my submission.
No, he may not refer to 308.
Quite right.
But if he says these are the conditions on which I am granting pardon without reference to 308, would that suffice to come to obviate the procedure under 308?
But he should say that then. It is not for the
If
court.
in a given circumstance.
Yes, it is not for the court. Ultimately, it is for the accused. He should appear before the court no sooner the order is passed, no sooner the conditions are imposed. Yes, I am agreeable for this condition. I am accepting the pardon. My lord, I shall invite my lord's attention to the Supreme Court. What the Supreme Court would say is, you send the copy of the order to him. And of course, my lord,
Just clarifying.
please. May I now kindly have
Clarify ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ರೆ ಆಮೇಲೆವರೆಗೂ ಇರಲ್ಲ. Yes.
But it is only under 308 that we get the imposition of conditions, not in 306 or
So
300.
306, 307 is a plain power
That's it.
of the magistrate in the sessions court to grant pardon or reject pardon.
Okay.
Once pardon is granted, 308 kicks in.
Okay.
That's all. Yes.
May I request your lordship to kindly go to the order and the proceeding sheet again. I am only making my submissions on the important legal issues which I have raised.
Yes.
My lord, page 121 is the operative portion of the order.
Yes.
Order that is available on record.
Again, with permission to digress, hello, demolitions ಇದೆ. I'll just grant them stay and continue. Yes. I'll continue.
ಅಲ್ಲ,
Dharwad bench the ಸ್ವಲ್ಪ matter.
230 more list.
ಒಂದ್ ನಿಮಿಷ ತಾಡಿ. ಏನ್ ವಾಪಸ್ ಹೋಗ್ಬೇಕಾ? ಬೆಂಗಳೂರು ವಾಪಸ್ ಹೋಗ್ಬೇಕಾ?
ಇಲ್ಲ ಇಲ್ಲ
ಹಾ, ವೇಟ್.
ಅವರೇ ಕೇಳಿಸ್ಕೋಬಹುದಲ್ಲ, ಅವ್ರ ಹತ್ರನೇ ಇದೆಯಲ್ಲ.
ಅಲ್ಲ ನನ್ಗೆಲ್ಲ
ಕೋರ್ಟ್ ಕೊಡ್ತೀವಿ ಸರ್, ನಮ್ ಕರ್ತವ್ಯ. ಐ ಸಾಟ್ my lord, I said yes, it is a lapse on my part. I may be the lapse may be
ಯಾವಾಗಲೂ
condoned.
ಕೊಡ್ಬೇಕಾದ್ರೆ ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಕೊಟ್ಬಿಟ್ರೆ ಇಟ್ಸ್ ಈಸಿಯರ್.
ಅಲ್ಲಲ್ಲ, ಈಗಿನ ಕಾಲದಲ್ಲಿ ಏನಾಗಿದೆ, ಟೆಕ್ನಾಲಜಿ has advanced to such an
I can
extent.
myself do it. That's a different thing,
ಅಲ್ಲ.
but that's not correct.
Sari, that is right, my lord.
Unless the transcript
No,
is
no,
there, I
that's
would
right,
not
my lord.
venture
No doubt,
it.
as the learned judge, I have a laptop, therefore I myself can type it ಅಂತಂದ್ರೆ ನಾವ್ ಹೇಳಕ್ಕಾಗತ್ತಾ? ತಾವು ನೋಡ್ಕೊಳ್ಳಿ ಅವ್ರು. ಡೆವಲಪ್ ಮಾಡೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ ಅಂತ ನಾನು ಹೇಳ್ತಾ ಇರೋದು. ಇಟ್ ಇಸ್ ಕ್ರಿಸ್ಟಲ್ ಕ್ಲಿಯರ್, ಆಸ್ ಕ್ಲಿಯರ್ ಆಸ್ ಮಿರರ್.
Yes, Kavita madam, totally. I'll just dictate and if I'm adjourning, I'll dictate.
Please.
Because I have to extend the interim order. Very witness alla, it's
ಇಲ್ಲ ಬೇರೆಯವ್ರು ಮಾಡೋ ಹಾಗೆ ಇಲ್ಲ, ಅವರೇ ಬರೆದು ಬಿಟ್ಟಿದ್ದಾರೆ ಇವಂದು ಆಗೋತಂಗೆ ಮಾಡಲ್ಲ ಅಂತ. ಹಿ ಇಸ್ ಮೋರ್ ಆಫ್ಟರ್ ದಿಸ್ ವಿಟ್ನೆಸ್ ದ ಲಾರ್ಡ್ ಟ್ರಯಲ್ ಜಡ್ಜ್.
ಈಗ ಫಸ್ಟ್ ಆರ್ಡರ್ ಯಾವ್ದೋ ತೋರಿಸಿದ್ರಲ್ಲ ಸರ್, ಅಲ್ಲ ಲ್ಯಾಪ್ಟಾಪ್ ಟೈಪ್
Yes, my lord.
ಅಲ್ಲ which page is that?
Page 125. 125.
125 ಅಲ್ಲ
125.
121. Heard the learned senior counsel C.V. Nagesh appearing for the petitioner in so and so along with all other senior counsels ಎಲ್ಲ ಹಾಕಿ ಅಲ್ಲ ಅವರು ಸಪರೇಟ್ ಪೆಟಿಷನ್ಸ್ ಅಲ್ಲಿ ಸಂದೇಶ್ ಚೋಟ ಅವರು M.F. ಶ್ಯಾಮ್ ಸುಂದರ್ ಎಲ್ಲ ಯಾವ್ಯಾವ ಪೆಟಿಷನ್ ಕೇಳ್ತಾರೆ ನನಗೆ ಬರ್ಕೊಡಿ ಎಲ್ಲ ಯಾರು. The learned senior counsel would project a threshold illegality in the proceedings before the concerned court in special CC 565 of 2021. He would place reliance upon the order passed on 23rd December 2024, the impugned order herein. The order reads as follows. Page 120, 121. The order would depict that the order is typed by the learned judge in the official laptop, revised by him, corrected and taken a printout on 23rd December 2024. This will be referred as order number 1. The learned judge on the same day has passed another order which depicts that the orders are order dictated in the open court with a separate order. The ಗೊತ್ತು ಅದಿದೆ ಅಲ್ಲಿ ಇಲ್ಲಿಂದ ರೆಕಾರ್ಡ್ ಮಾಡ್ತೀನಿ. The order passed on the same day, which according to the learned senior counsel is different, reads as follows. This is page 323, 324. Another order is passed rejecting the application of the victim filed under section 301(2) of the CRPC. The said order reads as follows. Idu 2 anta alle barde, page 324. The learned senior counsel would submit that the proceedings before the concerned court is marred with certain suspicion of 2 orders being passed on the same day. He would submit that it would require the records of the concerned court to be seen at the hands of this court. The learned senior counsel would further elaborate the submissions made at the time of grant of the interim order, that once pardon is granted under section 307 by the court of session to an accused, section 30 procedure stipulated under section 308 should be necessarily followed or mandatorily followed. In the learned senior counsel submits that procedure is not followed even to its remotest sense. The learned counsel Nagendra Nayak, appearing for the accused number 1, who is now granted pardon, would submit that he would reply to all those submissions on the next date of hearing. So does the learned counsel P. Prasanna Kumar, representing the CBI. So does Pada. The counsel representing the CBI, P. Prasanna Kumar, also would submit that he would reply to all those submissions on the next date. The learned senior counsel C.V. Nagesh further submits, taking this court to a memo which reads as follows. A memo is preferred, appending to it a pen drive with regard to certain conversation between accused number 1 and a certain lady. The learned senior counsel submits that it is done to sabotage the career of the accused number 15. The transcript of the said conversation of training in the pen drive shall be placed along with an affidavit by the next date of hearing after serving an advance copy upon the counsel appearing for the respondent. With the issues being as aforesaid, permitting examination of any witness, barring accused number 1 even, would not be appropriate at this stage. Therefore, the interim order so granted shall continue till the next date of hearing. Yes. List on 20th, 2:30 ge hakla. List on 20th at 2:30.
Come as barring accused number 1, including accused number 1, it should be.
Including accused number. Right. Sorry.
Otherwise, examine.
Including accused number 1.
Lordship, one.
ಅದು petition ನಿಮ್ದು ಯಾವ್ದು ಅದು ತರ್ಸಿ.
Yes.
This petition. ಆ ಕೋರ್ಟಲ್ಲಿ ಹೋಗಿದ್ಯಾ? Registry to secure writ petition, papers of writ petition 859 of 2025 by the next date and tag the petition along with these cases.
Lordship, I filed a wakalat for respondent number 2 on these 3 matters, Lordship.
One nimsh, sir, one nimsh.
I filed a wakalat for respondent number 2 in 3 matters, Lordship. My name may be shown in the cause list, Lordship.
One nimsh.
Yes, Lordship.
Registry to print the name of R. Nagendra Naik as appearing for the R? R2.
Yes, Lordship. I am representing the R2, Lordship.
Sir, one nimsh.
The de facto apologies, Lordship.
ಯಾವ್ದಕ್ಕೆ ಯಾರಿಗೆ ಏನಾಗಿದೆ ನಾಯಕ್? ಅಲ್ಲ R3 ಎಲ್ಲ ಕೇಸಲ್ಲೂ Learned registry to print the name of R. Nagendra Naik as appearing for Basavaraj Muttigi wherever he is arrayed as respondent. ಆಮೇಲೆ ನಿಮ್ದು ಯಾರಿಗೆ? ಮಲ್ಲವ
R2, Lordship.
ನಿಮ್ಮ
Praveen Kumar NK, Lordship. Praveen Kumar, Lordship.
Registry to print the name of Praveen Kumar as appearing for the second respondent victim complainant in all these cases. ಆಯ್ತಾ? ಅಷ್ಟು interim order will continue. Yes.
Lordship heard me in the courtroom session.
Sir.
ಬಂದಿರ್ಲಿಲ್ಲ.
ಯಾವುದು?
Whether the procedure that is to be followed.
308.
ಅಲ್ಲಲ್ಲ, PMLA ನಲ್ಲಿ BNSS.
BNSS. ಅಲ್ಲ, which matter? ಯಾವ matter sir ಅದು? Serial number? Who ಮಾಡಿರೋದು? that Valmiki Corporation. ED matter. Yes. 7th ಹಾಕ್ತೆ because ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗಿರಲಿಲ್ಲ. 2:30 ಮೂವ್ ಮಾಡಿದ್ದಾರೆ. We'll take it on 7th.
ಅಲ್ಲಿ ತನಕ let him not record any proceedings.
ಅಲ್ಲ, next date ಕೇಳಿದಾನೆ ಯಾವತ್ತು ಅಂತ.
21st
of HPC. ಅದೇ HPC ಗೊತ್ತು. 21st ಅಲ್ವಾ?
But if he has no jurisdiction.
List on 20th. Yes. List on 20th. 20th ಹೆಂಗೂ ಇರ್ತಿರಲ್ಲ ಸರ್. Yes.
Even this serial number 4, ಅದು ಸೇಮ್ ಕನೆಕ್ಟೆಡ್.
ಅಲ್ಲ, ಅದು ಅಭಿನಯ.
ಅದೇ ಸೇಮ್ ಕನೆಕ್ಟೆಡ್ ಮಾಡಿ.
ಕನೆಕ್ಟೆಡ್ ಯಾವುದಕ್ಕೆ?
ಅದೇ ಇದು ನಾಗೇಂದ್ರ ಕನೆಕ್ಟೆಡ್.
ಅದು ವಾಲ್ಮೀಕಿ ಕಾರ್ಪೊರೇಷನ್ ದ.
Yes, your lordship.
ಅದು ಅವತ್ತೇ ಬರ್ಲಿ.
But connection ಬೇಡ your lordship, because I am on a different.
Correct. Connection ಬೇಡ. But ಅವತ್ತೇ ಬರ್ಲಿ ಅಷ್ಟೇ.
Yes, sir. Stage may be deferred.
ಅವತ್ತು ಮಾಡೋಣ. It's on 21st. We'll do it on that day.
20th. Yes, sir.
Yes.
Much obliged.
20ಕ್ಕೆ ಸರ್.
ಅಲ್ಲ, ನಮ್ದಕ್ಕೂ ಅದಕ್ಕೂ ಕನೆಕ್ಟ್
ಅದು ಕನೆಕ್ಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ.
Predicate offense ಇಲ್ಲ ನಮ್ಮ ಮೇಲೆ, ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿಲ್ಲ ನಮ್ಮ ಮೇಲೆ, ಬೇರೆಯವ್ರ ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿರೋದು.
ಅಲ್ಲ, ಅದು ಕನೆಕ್ಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ.
Honorable the Supreme Court speaking to Justice Voka has said the provisions of section CRPC are applicable in relation to proceedings under the PMLA. But then in that case, the Delhi High Court has said sanction for prosecution is necessary.
Even PMLA.
For prosecution. But in fact, the Marin Council who is to argue this matter is the one who argued the matter before the Delhi High Court. Mr. Prasanna Kumar is aware of it. ಅದಕ್ಕೋಸ್ಕರ ಒಂದು ಅಲ್ಲಿ ತನಕ ಪ್ರೊಸೀಡಿಂಗ್ಸ್
ಅಲ್ಲ 20ನೇ ತಾರೀಕು ವಿಲ್
ಸ್ಯಾಂಕ್ಷನ್ ಇಲ್ಲ ಇದ್ರಲ್ಲಿ ಆಗ್ಬೇಕಾದ್ರೆ.
ಲೆಟ್ಸ್ ಸಿ.
And in fact, in one of the columns, what they would say is that the accused has committed this offense under section, which is made penal under section 4, violation of section 3, made penal under section 4, in his official capacity as a public servant.
All right, then we'll see. Yes.
Please, keep your.
Much obliged.
Yes. 79
14th March.
14th ಹಾಕದ್ನಲ್ಲ ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ 14th ಹಾಕಿದ್ದೀನಿ 20th again you are here ಅಲ್ವಾ so we can continue with this ಮೇಡಮ್ ಮೇಡಮ್ ರಿಲೇಟ್ ಕಳ್ಸಕ್ಕೆ ಹೇಳಿ ಅದನ್ನ ಆಮೇಲೆ ಇದು ಮೆತ್ಗೆ ರಿಲ್ಯಾಕ್ಸ್ ಅವ್ರು ಓಡಿಸ್ಕೊಂಡ್ಬಿಟ್ರೆ Dharwad bench. 230 mode matter.
Dharwad 230 mode, please. Cell number 1, Ganesh Rai Bagi.
Mike.
I have filed a KVA petition in this petition. Challenging, they are challenging.
ಹೇಳಿ
No, we have not challenged that order, Your Honor.
not challenge anything
Order challenge ಮಾಡಿಲ್ಲ ಅವ್ರು ಯಾವ್ದು petition file
ಏನ್
ಮಾಡಿಲ್ಲ.
ಚಾಲೆಂಜ್ ಮಾಡಿರಿ ಹೇಳ್ರಿ
We have challenged the order passed by the respondent dated 16/1/2025 as per annexure L, Your Honor,
ಏನದು
withholding the approval of the Samiti, my lord.
withholding the approval of
Approval of Samiti and renewal of
Howdy.
Samiti, my lord.
renewal of
Samiti and approval of the Samiti, my
ಇಂಟ್ರಿ
lord.
ಮಾಡಲ್ ಮಾಡಕ್ಕಾಗತ್ತಾ ಅದು
Yes,
ಇಂಟ್ರಿ ಮಾಡಲ್ ಮಾಡಕ್ಕಾಗತ್ತಾ
ಆಗತ್ತೆ sir.
ಆಗತ್ತಾ So,
No,
ಅದು
sir,
ಮತ್ತೆ
my lord, we have not challenged that order.
ಹ್ಮ್.
What, for which you has filed the
ಬಿಡಿ ತೊಂದ್ರೆ ಇಲ್ಲ
ಹೌದು sir.
ಇಂಟ್ರಿ ಮಾಡ್ರೆ ಫೈನಲ್ ಆರ್ಡರ್ ಎರಡು ಒಂದೇ
My lord, it has hampered the administration, my lord, day-to-day activities of the administration, my
correct
lord.
sir when entry mode and final order are the same how can I grant it now
Not the same, my lord.
ಮತ್ತೆ ಏನ್ ಹೇಳಿ sir?
Not the same, my lord.
Please to stay the implementation of the impugned letter. Quash the impugned letter. Effect is that permit the petitioner submit to manage the affairs. Entry model ಕೊಟ್ಬಿಡೋಣವಾ?
My lord,
What sir?
humble submission, my lord.
Hmm.
It has no power to stay its order. It has no.
Which order?
It has passed the.
Which order was passed first?
J and K, my lord.
K and page ಹೇಳಿ sir.
My lord.
Which order was passed first and which order was stayed later?
Page number 20. Annexure J and K, Your Honor. Annexure J and K, Your Honor.
ಸ್ವೀಕೃತಿ ಪತ್ರವು ಕೆಳಕಂಡ ಷರತ್ತುಗಳಿಗೆ ಒಳಪಟ್ಟು ಸೊ ಸ್ವೀಕೃತಿ ಪತ್ರ ಆಯ್ತು ಆಮೇಲೆ
Next committee is approved.
Page.
As per K, Your Honor.
ಅಪ್ರೂವ್ಡ್ ಆಮೇಲೆ
The very, these annexure J and K have been stayed.
where which order?
This annexure J, my lord.
ಅಲ್ಲ ಸ್ಟೇ ಆಗಿರೋದು ಯಾವ ಆರ್ಡರ್ಲಿ ಸರ್ ಯಾವ ಆರ್ಡರ್ಲಿ ಸ್ಟೇ ಆಗಿದೆ
Is the annexure J and K.